statement of the applicable law. Another case that, well, I think that's the main case. But that is a slight language change to reasonable woman. We're not asking for something like reasonable alleged sexual assault victim or reasonable abused person, but just woman, to reflect the fact that Ms. McCandless is a woman and that should be taken into consideration rather than having gender neutral language.
But wouldn't that be the circumstances? I mean, the instruction discusses under the, circumstances as they existed at the time from the perspective of the defendant. And wouldn't that be one of those circumstances?
I certainly think that's implied, but that the use of woman in the language would make it more explicit and better conform to the evidence in this case.
All right, is state prepared to address that at this time?
I'm not prepared to address it at this point in time, although I generally share the court's view that I think under the circumstances it's already covered there. There are a couple cases that the court may want to take a look at as it relates to lesser includeds as well, including State versus Morgan, M-O-R-G-A-N, which is 195 West 2nd, 388, 536 Northwest 2nd, 425, a 1995 Court of Appeals decision which discusses specifically when first-degree reckless homicide is appropriate, not appropriate. In that case, they affirmed a convict. They found that the trial court had instructed on first-degree intentional and not on first-degree reckless, but had included a felony murder one.
I'm sorry, counsel, is that 195 was 2nd 388?
388, yes.
Okay.
So you may want to, it goes through the analysis, and I think is a good analysis of when you should and when it's required and when it's not required to give a lesser included offense instruction. You may also want to take a look at State versus Weeks, W-E-E-K-S, which is 165 West 2nd, 200, 477 Northwest 2nd, 642, 1991 Court of Appeals decision, which again goes through the criteria. I think the criteria are pretty standard in all the cases, and I think it's pretty much the same criteria the counsel mentioned, and that's essentially whether or not there is sufficient evidence to find not guilty on the greater offense and sufficient evidence to find guilt on the lesser offense. So I think it's appropriate to argue it tomorrow. I think those cases are ones that'll be pretty good for the court to start with and just try to get the basic framework for how you make that analysis.
All right. Another area that I would like some input on is I think the state submitted an instruction about the use of the mental health evidence in this case. Was that the state? May have been. I'm not
yes.
Sure. Okay.
I think we did. We submitted an instruction related to that. Yes, Your Honor.
All right. And I think it was the way that it was tailored was as to explanations for the defendant's recollection and so on and so forth.
Just the same thing.
I wonder, again, whether, and I think we've talked about this at some other point in this case, whether that mental health or mental or psychological evidence could the jury consider that as to the reasonableness of her perception or use of force as it relates to any mitigation from first-degree intentional homicide to second-degree intentional homicide. Again, for me, it comes from essentially what was the discussion from State versus Deborah Head, and that discussion was, I think, an Attorney General's letter or discussion before the 1988 homicide revision, and I don't know what the defense perspective is on that, and I don't believe there's any. I haven't seen any cases right on point with that, but that being discussed in State versus Deborah Head, it may just be dicta, but that's one issue I'd like counsel to think about. The second, yes, go ahead.
I haven't seen it, but there's been testimony today through a witness, Dr. Hopper, that talked about reflexes and habits when under attack, when the brain's under attack, and what happens to the prefrontal cortex and regarding behavior. And there was no objection, there was no limiting instruction, there was nothing that would suggest that they couldn't consider it for whatever purposes they wanted to. So the defense would be of the position that I don't have the instruction in front of me, but that at least as to Dr. Hopper's testimony today, that's something that the jury can consider in deciding reasonableness of the beliefs.
Well, I think this testimony said something along the lines of, misappraising the threat or misappraising the situation, something along those lines.
He also said, regardless of misappraising, he just said when the brain is under the attack, the prefrontal cortex is diminished and incapacitated, and so anyone in that situation, short of essentially a Navy SEAL who's got training, would respond in a reflexive or habit way. And so I think it cuts both ways, but it's certainly from the defense standpoint, that's what we're focusing on, is the reasonableness then of a belief under those circumstances at that time. And that's testimony about reason, how the prefrontal cortex is diminished. So again, we think we would object to that, to an instruction that would limit the use of that evidence.
Okay, well, the big concern I have, of course, is that, the jury is not instructed that this is not a insanity defense, not an NGI case. I think in a way that they understand that, because the jury doesn't get that instruction, and they start thinking about some of this, I guess, for lack of a better term, psychological evidence. I don't want them to be confused and to think that that's on the table, so I think they should, I think in the instruction, and I don't know that there's a pattern for this, there is, again, if you get into that, but we don't have that plea, and I think a jury has to be told that, that's not an issue in this case in some way or another, so I'd ask counsel to think about that as well. Sometimes when juries aren't told about that, they take it upon themselves, but I think we do have an awful lot to talk about during jury instruction conference. So, anything else, again, today that the court, you want to give the court a heads up on?
Just when the court looks at State v. Morgan, Judge, I'm going to ask the court to think about this language. State v. Morgan, that's another case that I saw some of the trial of, took place in Milwaukee County. It was a rather famous case because Felicia Morgan, who I think was a juvenile at the time, had committed an armed robbery and had shot the victim. And the main lesson of the Morgan case actually has to do with things that have nothing to do with jury instructions. But what the court noted when it declined to give a first-degree reckless homicide lesser included instruction was that, number one, Miss Morgan had shot the decedent at very close range. And that the trajectory of the bullet passed through the decedent's vital areas, and that it was almost touching the decedent's body. And, here, the medical evidence, clearly indicates that these are wounds that were potentially survivable. They're at any particular, first of all, they could have been survived with medical treatment. There's testimony in the record as to that. Second of all, there's testimony in the record that Mr. Woodworth could have lived for some period of time, whether it was minutes to 30 minutes. I think that's the range that has been established, even though he ultimately bled to death. But there was not a stab wound, for example, to the heart or cutting the aorta that would clearly establish a lack of recklessness. That's on the objective side. On the subjective side, we have testimony in the record that not only goes to the issue of self-defense, where we have testimony in the record that not only goes to self-defense, that Ms. McCandless testified to, we also have both her testimony on the stand that she stabbed anywhere and everywhere she could. That's also in her statement to Detective Prock. She was also questioned on the stand whether she had an intent to kill. She said she did not. She was also told when she was interrogated, and that's in Exhibit 290, she was asked, and the state put this in, were you trying to kill him? And she said, I just wanted him to go away. He wouldn't go away. So there's pretty clear evidence to support a lesser included of first-degree reckless homicide and the line of reckless homicides as opposed to simply the line of intentional homicides. So I do want the court to take that into consideration. I think it's better for us to put forth some argument now in support of that, and I'd ask the court to think about that. And I think this is a very weighty decision because the failure to give appropriate lessers is one of the most frequent reasons why verdicts are overturned. That and other crimes evidence, quite frankly, in terms of my discussions with appellate lawyers and what happens. So we are also making arguments for lessers beyond first-degree reckless, and I'll argue those tomorrow. But just in terms of the notion of criminal recklessness as compared to criminal intent, there's clear evidence in the record that supports an acquittal on an intentional crime and a potential conviction on a reckless offense. And I frankly think it can be reversible error, and I don't use those words lightly, to fail to give an instruction that incorporates recklessness. I'll leave the rest for tomorrow.
Okay.
Your Honor, I didn't think we were arguing this today, and so I haven't argued it.
You're welcome to
I'm not going to argue it today. We can argue it tomorrow when it's appropriate to do so. But our position is clearly different than Ms. Vishny's, and we clearly do not believe it would be a reversible error not to give that instruction. I'll leave it at that.
All right. Okay, anything else?
I don't think so. I just want to.
All right, then we'll be in recess until tomorrow at, I just ask council to be here at 8:25, so we can have the jury in at 8:30. Fine, we'll continue. We're in recess. Thank you.
Thank you.
All right, does the defense rest at this time?
Yes, Your Honor.
Okay, does the state have any rebuttal evidence?
Very brief, Your Honor. First witness we would call would be Detective Ryan Prock. Detective Prock, as part of your work, you've reviewed the extractions from Alex Woodworth's devices.
That is correct.
Does that include reviewing the extractions from his cell phone?
Yes.
Did you review those extractions as it relates to text messages that Alex Woodworth received that were on that phone?
Yes, I did.
Did you see any text messages on March 5th of 2018?
There were text messages on March 5th.
Specifically, did you see a text message from John Hansen?
I saw one.
Irrelevant. Can we approach, Judge?
All right, objection is sustained.
And just so that it's clear, the text was on March 6th from Hanson?
That is correct.
And was that shortly after that these searches on Facebook occurred involving the defendant and Jason Mengel?
It was.
All right. Now, Detective, when you interviewed the defendant on March 24th of 2018, had the autopsy been completed yet of Alex Woodworth?
No, the autopsy was going on at the same time as the interview.
And you were at the scene on March 23rd when Alex Woodworth's body was found, correct?
That is correct.
Right. At that time, and prior to interviewing the defendant, which of Alex's wounds were you aware of?
I knew of the wound to the side of his head. I knew of his throat wound, in particular the cut, the slash mark wound. And then I knew there was a large amount of blood in his groin crotch area.
All right. Outside of that, did you know of any of the other injuries?
No, I did not.
Sustained? All right, thank you. I think that's it, right? That's all I have, Your Honor. Thank you.
Okay. Any cross related to just those specific areas?
When you were I want to ask you some questions about your being at the scene on the 23rd of March.
Okay.
That's the date that you went and saw the car and saw Alex Woodworth in the car, is that right?
That is correct.
How long were you, and that was, just to put it into context, on the 23rd, you, at some point chronologically, you met with Ezra McCandless, is that right?
That is correct.
After that, you went to go speak with Farmer Sipple, right?
I went and spoke with Mr. Sipple, yes.
And then after that, while you were ending that up or sometime during that, you got the call from Piper that they'd found footprints.
Yes, Sergeant Piper got a hold of me.
And that's when you then, at some point that day, after those events that we just talked about, you went and observed the car and Mr. Woodworth in the car, right?
That is correct.
How long were you there at the scene by the car?
I couldn't put a time on it.
You stayed there during the processing while the crime lab came, while other people came?
No.
Okay, did you leave before the crime lab appeared?
Yes.
Did you leave before it got dark out?
No. Well, are you talking about up by the car or are you talking out by the road?
Maybe were you there, at some point Mr. Woodworth's body was taken out of the car and put on was taken out of the car. Is that right?
That is correct.
Were you there in general, not there to watch that, but were you there in general when that happened?
I don't believe I was on the scene at that time, no.
You had already left?
That is correct.
Okay. Had you gone back to the scene on the 24th at all, other than what you just talked about, prior to your talking to Ms. McCandless on the 24th?
You're talking about back to...
So on the 23rd, you were at the scene?
Yes.
And then you left the scene?
Correct.
And then on the 24th, you spoke with Ms. McCandless?
That is correct.
In between the time that you were at the scene on the 23rd until the time that you spoke with Ms. McCandless on the 24th, during that time, did you go back to the scene?
I do not believe I did, no.
Okay. When you say you do not believe you did,
I don't believe I went back there.
you use the word believe. Is there some hesitation?
Well,
you haven't used that before, and so.
No, I did not go back to the scene.
Okay. Did you, during that time period, have conversations or contact with officers who were at the scene?
I had a lot of conversations, and I don't know which investigators from Dunn County were or were not at the scene, so I couldn't say that. I would assume I spoke with somebody from the scene.
On the 24th, when you met with Ms. McCandless, that was late in the afternoon?
No, that was in the morning, I believe.
Well, I'll just ask this. What time was that?
I couldn't give you an exact time.
Okay. In the morning at 8 a.m., in the morning at 11 a.m., or you just don't know?
It was between 8 and 10 a.m. I couldn't give you an exact minute, hour, half hour. It was between that time frame.
Okay, and in that, you know when you left the scene on the 23rd?
Yes.
What time did you leave the scene on the 23rd?
Oh, I don't know what time I left. It was dark, and after that I went into Dunn County's Sheriff's Office.
Okay. And then on the 24th, before you met with Ms. McCandless, did you go and speak with anybody in person at the Dunn County Sheriff's Department?
Investigator Conkey met me at Mayo Health System.
All right. And that's where you met eventually with Ms. McCandless, right?
That is correct.
Prior to during that meeting with Mr. Conkey, did he inform you of the investigation, what had been going on at the scene, give you up to date about the processing of the scene?
I don't remember what our specific conversation was about.
Okay. You were here in court and saw some of the pictures from the scene, is that right?
Yes.
And you saw there was a picture of Mr. Woodworth at the scene in which his shirt was pulled up and there was, I can't remember what the wound number was, but I think it's wound number 16 in the autopsy report. The wound on his back side by the ribs was visible. Do you remember seeing that picture in court?
I remember that picture.
Did Investigator Conkey tell you about the wounds that he had knowledge of prior to your meeting with Ms. McCandless?
I don't remember what he told me specifically, no.
Okay, so he might have, he might not have. You don't have an independent memory right now whether he did or whether he did not. Agreed?
I just remember the wounds that I knew about, and
I'm not asking about that, sir. I'm asking you about what Mr. Conkey may or may not have told you. It sounds to me like you say you don't have a memory of what he told you on that day. Agreed?
I don't remember what he told me, no.
All right, thank you.
All right, any redirect?
No, Your Honor.
Okay, Detective Brock, you may step down. Thank you. And the state have any additional witnesses?
Very briefly, the state calls Julia Post to the stand. Can you please state and spell your name for the record?
Julia Post, Julia Post.
And do you know the defendant, Ezra McCandless?
Yes,
How long have you known her?
since grade school.
And did you go to school with her through middle school, high school?
Yes,
And were you friends with the defendant?
yes,
Do you have an opinion as to the defendant's character for truthfulness or untruthfulness?
yes, I do.
And what is that opinion?
They are not very truthful.
I have no further questions.
All right, any cross-examination?
Yes. You knew Ms. McCandless from elementary school.
Yes,
You rode the bus together, right?
yes,
As little kids.
yes,
And then you went to middle school with her, right?
yes,
And you know her from middle school, right?
yes,
And then eventually you guys were classmates in high school, right?
yes,
She went away to college in Marinette, agreed?
yes,
You stayed in the area and went to college in Eau Claire.
yes,
During that time, you didn't have much, if any, contact, agreed?
yes,
Your contact that you've had with Ms. McCandless is basically from the bus in elementary school, from middle school, and from high school, right?
no,
Well, she was in Marinette, you were in Eau Claire, you didn't have much contact, you just agreed with that, right?
yes,
And then after that, when she came the next year in the summer of 2017, fall of 2017, Ms. McCandless was in the Eau Claire area, correct?
yes,
You were going to school, right?
yes,
She wasn't going to school, agreed?
yes,
You didn't have much contact, you weren't in the same friend group, agreed?
yes,
So your contact with her up until
a particular day in March of 2018 was really from elementary school, middle school, and high school. Agreed?
No.
So, other than high school, post-high school, you had contact with her on one day in March of 2018, right?
No.
You saw her in March of 2018, right?
Yes.
She came to your house.
Yes.
She was a friend of yours.
Yes.
She brought her journals.
Yes.
You looked at her journals.
Yes.
You edited or did edit, but you looked over them from grammatical standpoint, correct?
Yes.
She was pretty relaxed about it, right?
Objection, this exceeds the scope.
Sustained.
Judge, this is 906-16 about her opinion. I'm able to do that under 906-16. I believe it's Alaska v. Davis. I don't have the Supreme Court site, but
Give me a second. Now, 16 goes to bias. That question was asking about her opinion about her mood.
it goes to bias and it goes to credibility. This witness has offered an opinion. I am asking questions to see what foundation, if any, she has for that opinion, and that's part of the bias that you're able to bring up. I've cross-examined her and said she had contact in elementary school, she had contact in middle school, she has contact in high school. After that, she says she's not had any contact, yet when I ask her about her opinion, she says it's based on something beyond these middle school, high school years. And so,
Okay, well, you can ask that. I don't have a problem with that, but I'm sustaining that specific question, or objection to that specific question. So you may continue.
you spoke with the police after you learned about the death of Alex Woodworth, is that right?
Objection again, exceeds the scope.
It's going to establish the questions that I'm going to ask her, Your Honor.
Overrule that objection. You may continue.
You spoke with the police about Ezra McCandless after you learned about the death of Alex Woodworth, right?
Yes.
And you know those conversations were all recorded. You know that, right?
Yes.
And there's reports about those, correct?
Yes.
And what you told the police was, let me make sure I get it correct.
Aaron, can we have a sidebar on this, man?
All right, Counsel Croach.
When you spoke with the police, you told the police that your parents didn't like you being with Ezra. Is that right?
Yes.
Yet, you were with Ezra in March of 2018, right?
Yes.
And then you found out that this person who your parents said they don't want you to be with was accused of homicide, right?
Yes.
And you've read about that in the papers.
Yes.
You've watched news about it, correct? You've never seen anything on the news about it in any way?
You have to answer out loud. I know you're shaking your head. Does that?
No, I have not.
Okay, but you have read articles in print or digital versions of written articles?
Yes.
And you've gossiped about it with your parents?
Yes.
You've gossiped about it with friends in Eau Claire?
Define gossip.
You've spoke about things that you don't know about with your friends in Eau Claire regarding the charges against Ezra McCandless, right?
Yes.
You weren't there on March 22nd, were you?
Can you redefine gossip for me? I'm sorry.
I think you've answered the question. You don't have facts about March 22nd that you can offer here about what you saw, what you heard, what you felt, what you smelled about what happened on March 22nd between Ezra McCandless and Alexander Woodworth, right?
Yes.
You haven't read police reports?
No.
You haven't read medical reports,
No.
crime lab reports?
No.
You haven't seen any photos from the scene?
No.
Spoke to psychologists?
No.
Any other experts about it?
No.
You haven't been here in trial watching this in any way?
No.
You haven't been watching it on court TV or any other news media during this?
No.
So you don't know anything about what's going on in the trial?
No.
You just have an opinion about a person you knew in middle school and high school. That's what you're here to offer.
Objection, that's misstating the evidence.
Well, it is misstating the evidence. I'll sustain that.
You're here to offer an opinion about a friend from middle school. Agreed?
Objection, asked and answered.
Sustained.
That's all.
Any redirect?
Ms. Post, did you have an opinion about the defendant's truthfulness before you saw the articles in the news or before this came out on March 22nd, 2018?
Yes.
And what was that opinion?
My opinion was that this person is not very truthful.
Nothing else.
Okay, any recross?
So you're telling this jury that prior to March 22nd, you had these opinions about Ezra McCandless, correct?
Yes.
Yet on March 23rd, you went to the hospital and met with her, this person who you say you have this opinion about, right?
Yes.
Nothing else.
Okay, you may step down. Thank you. And I believe Ms. Post could be excused?
Yes.
Any additional evidence from the state?
No.
All right, any rebuttal from the defense?
No, Your Honor.
All right, ladies and gentlemen, both parties have rested. We have quite a bit of work to do for jury instructions. And rather than to have you wait for hours here and then for there to be arguments late in the day and give the case to you this evening, as I'd indicated yesterday, the plan is for us to do that work, which is, again, we expect the jury instruction conference could take as long as 3 to 4 hours. And so we're going to excuse you for the day, and then I just ask that you be prepared. Bring an overnight bag tomorrow and be here by 8:30. And, it seems like there's always an issue that comes up that delays things a little bit, but if I want you here to be able to start with instructions and then closing arguments beginning at 8:30 a.m. tomorrow on Friday. Yet I gave you the instruction, we call it part of 150 yesterday, and I'm just going to reiterate, I've read it to you a number of times, just to remind you it's extremely important that you make your decision in this case based solely on the evidence offered and received at trial. There will be extensive instructions about evidence and so forth in the instructions, but again, you're not to discuss the case either among yourselves or with anyone else. Don't let anyone talk to you about this case or try to influence your opinion in any way. Do not look at any form of media, newspapers, television, social media, internet, news, or any other way. Do not, again, do any research with any on or off of a computer regarding any of the parties or this case or publicity and so on and so forth. Again, it's very important that you jurors who have been selected for this very important duty decide the case, again, based only on the evidence received by the court pursuant to the rules of evidence in this state and the instructions on the law that the court will give you. And again, that, as you can probably tell by now, this is a complicated case. And here's, and I don't want to make the attorneys too nervous here, but I just want to improvise here a little bit. When you get into the subject that you have in this case, there's a lot of movies, television shows. Every state has maybe different terminology and so on and so forth. Even Wisconsin did a major revision of its homicide statutes in 1988. So even in Wisconsin, different things were called by different names. So what's important, and you have to trust that this court and these attorneys are working hard to make sure that you are properly instructed on the law of Wisconsin as it exists today. And that's another thing, that the danger of commentary from other places and I hope everybody's following those instructions the court has given you so far. But the law is different in different places, and people talking about this case don't necessarily know what the law is here and what the decisions are here. And so it's important, in order to do your duty, that you wait for any discussion or consideration until you've actually heard what you are to decide and what the law is that will be presented to you for your decision. You will, again, be given detailed instructions, and it's, I tell you, a fairly big project. We have to go over it word for word, and the law requires that we do that on the record. We'll do some off the record, but ultimately, in every case, there has to be a formal jury instruction conference on the record. We try to be as efficient as possible, but in a case where we've had several days, this is day 14, we've had 13 days, 12 and a half days of testimony, so there are a lot of issues. And so I just ask that you be patient and that you understand that. You all took an oath at the beginning of this case that you would make your decision based upon the evidence that's received in this courtroom and on the instructions the law gives you. And so now is a very important point where you get a little time off today, and I want you can rest, process what you've yourselves, what you've seen or heard, and then hope that you be fresh tomorrow morning, and the attorneys will be fresh and have an opportunity, again, to make sure that everybody's prepared for this very important part of this trial, that being the instructions and the closing arguments of counsel. Again, one of the things I do still have to take up with counsel is whether you would be sequestered. It used to be the law in this state that it was mandatory to sequester a jury once they've been sworn in a case of this nature. And that's no longer required by the law. But one of the questions that we have to consider is, how late you jurors may want to deliberate into the evening, and whether you'd be more comfortable being able to be at your own homes, or if you do not reach a verdict, to be able to go home overnight. And we have to think about those sorts of things, how late we would have you go, and frankly, we want to give you as a jury some input on that. So we'll take that up as you begin your deliberations.
Judge, could we approach about that issue? I think there may be some answers that we could give you just very briefly.
Okay, someone in the part of the state, okay. Well, ladies and gentlemen, I can tell you that, again, parties are not asking for sequestration. So, again, this is something that it's very important that all of you, follow those instructions that I've given you and we've talked about every day, so that you're not improperly influenced in any way, and that you decide this case on the evidence and the law, okay? What I'd like to do is take a short recess, 15 minutes, until 11:15, and then begin talking about jury instructions. But, I think before that we better clear up the sidebars. There was an objection, 957, with the rebuttal witness, Detective Ryan Prock. The defense was objecting to the content of the text message that John Hansen had sent to Alexander Woodworth on March 5th or 6th, 2018. Court sustained the objection as it relates to the content on hearsay grounds. Anything else that either counsel would like to put on the record with respect to that?
No, Judge.
No, the only thing I'd say, Your Honor, is just that the state had not intended to prove the truth of the matter asserted. I understand the court's ruling that it would have been for that, and so that's fine.
All right. And then 1014, Julia Post was on the stand. Ms. Nordoff objected to an area of cross-examination that Mr. Nelson had. We had a sidebar, and I overruled the objection and allowed Mr. Nelson to continue his cross-examination. Anything else either counsel would like to put on the record with respect to that sidebar?
Just the basis was, I believed it was exceeding the scope of direct, so.
Okay. All right, and then again, it was, Mr. Nelson had pointed out in a report the direction he was going to go, and the court was, and he did go there, and the court believes that that would have been fair for bias. Questioning? Yes. All right, now, the defense was going to have a packet, proposed packet of instructions.
Yes, Judge, I'm not sure where we're at, but I think we may need more than 15 minutes. Obviously, there's been a lot of balls in the air here, and so we're close to that. I would ask that maybe we take a break until, hold on a second.
Well, here's what I'm thinking.
So we have.
You need your microphone on, too.
I think we can get you something by 11 o'clock.
Okay.
So,
All right, well, I guess then it's not going to be productive if we come back in 15 minutes, so, but I have a starting point packet. And that includes what was requested by the state, in addition to, and this is what I would like you to think about between now and 11 o'clock, is that I did my own relatively short instruction on how the jury can use the psychological evidence. Now, it's interesting in reading the, I think it was the Morgan case where we're talking about, they referred to this in Wisconsin. The history of Wisconsin law is mind science in the guilt phase of a trial. But I don't think we had any psychiatrists. We had psychologists testify. But in any event, and I'll certainly share that with you, but I want counsel for the defense in particular to, I guess be ready to articulate and argue as to what purposes the jury may be able to use that evidence. I was wondering whether the defense, in part, was intending to argue that the evidence, psychological evidence, was in some way circumstantial evidence that there had been an attack. And I don't know, but I'll give you, again, my idea, certainly, but I think it's very important that the jury be advised that, again, this is not an insanity case, and that they're not to consider any of the psychological evidence for purposes on the ultimate issue of guilt or not guilt. And that it doesn't go to intent, certainly. That's not part of my instruction. But it can be used, well, I'll just give you my instruction, but I want you to think about that because I think the jury has to be told how they can use that evidence. And it's, there's quite a few cases, but I also believe that it supports the court's opinion, at least in what I read in the Morgan case, it supports the court's opinion that evidence of psychological evidence can be relevant and can be used for the jury when considering, again, for example, the reasonableness of either the belief that she was in imminent danger of death or great bodily harm, or whether the amount of force used was reasonable. I don't know of any case exactly on point with respect to that. But I want you to think about those aspects because I think there probably would be a considerable amount of discussion about that. So then we'll break until 11. Does that give the state enough time?
Sure, that's fine. Judge, if we can just quickly clean up Exhibit 720 so we put that issue to bed.
Yes.
That was the portion of the DSM-5. There was an objection and then a sidebar, and the court allowed admission, and then there was some additional argument afterward. And rather than continue with the argument, the parties worked together to come to an agreement as to which portion could be used as substantive evidence. It's partial page 274 through partial 276 with some exceptions. I will have, the state will work to get a redacted version of this, and then we will provide that to the clerk when we come back.
All right.
I just think Attorney Nelson, I've discussed it. I don't think the defense has acknowledged that there was that understanding, so I think there just need to be a record.
Is that correct, Mr. Nelson?
Acknowledged, yes.
Okay, very good. All right then, we'll be in recess until 11 a.m. Thank you. All right, we're back on record. It's a little after 11 a.m. Okay, council, I believe that court provided parties with, I think, 5 copies of a preliminary packet of instructions. And I think the thing, here's what we have to do. The court reporter needs a few hours in order to complete the transcript requests that have been requested. And so if we address some issues now and then break for a period of time and then come back, that might accommodate that so she can get that done for you. So the first thing I'd like to take up is the issue of lesser included offenses that would be submitted to the jury. And the state, well, actually, that's the second issue. The first issue I want to take up is, notice on the information that the penalty enhancer using a dangerous weapon was used. It was alleged. It seems to me that, and we don't have it on the proposed verdict forms, but it seems to me that would be a special jury question.
It is, Your Honor, and it should be on each, depending on whether or not the court gives any lesser, well, I suspect is definitely going to give at least one lesser included, which is second degree intentional. We can talk about the others in a little bit, but yes, it should be on each one, and that would be a question that will say if you find the defendant guilty, then answer the following question, and it would, did the defendant use a dangerous weapon in the commission of the offense, yes or no?
All right, and Mr. Nelson, does the defense have a position on that?
I apologize, there's a lot of moving parts right now. I was not listening as well as I should.
Okay, well, just to sum it up, and I think the state concurs with the court that there should be a special verdict question on any guilty verdict forms for any offenses submitted to the jury, that if you find the defendant guilty, did she use a dangerous weapon?
Yes, I understand the charging, I understand that's how it would be handled. I'm not in a position to comment on the wording of it, but in principle, I understand, and I think that's the correct legal way to handle it.
Okay, so we just have to make a note, Mr. Dietrich, we have to put that on the verdict forms. Okay, first of all, now moving second, I guess, into lesser included second degree intentional homicide. In the court's opinion, it's appropriate to give that. I mean, the analysis is it a lesser included offense? Yes, it is. Number 2, is there a reasonable basis in the evidence? Looking at the evidence in the light most favorable to the defendant, a basis to acquit on the greater degree, and again, if the jury, looking at the light, in the light most favorable to Ms. McCandless, the court believes that a second degree intentional homicide would be a lesser included offense. It should be submitted to the jury, and I don't know if either party wants to argue that or disagrees with the court on that.
I think we'll eventually, I think probably the best thing now, Judge, is to just, if you have some preliminary rulings, I know we have a memo that we're submitting now about lesser included, we're e-filing it in the moment. I don't know if now is when you want arguments on all of these. I think what would be most helpful for the defense is if Your Honor has some of these preliminary, to just put them down, and then we can come back and say what we agree and what we don't agree with once we know kind of the bigger package.
Well, that's what I would like to do, because if nobody disputes that that's a lesser included, then we don't need to spend a whole lot of
I don't believe anyone's disputing second degree intentional as a lesser included that should be
You agree?
No, Your Honor, we agree that there is evidence that would support a
Okay. All right, so that's not disputed. Now, the state has withdrawn its request for a first-degree reckless homicide, and the defense has requested that, as well as second-degree reckless homicide and homicide by negligent handling of a dangerous weapon. So who is going to handle that on the defense? Okay,
Ms. Vichny, Will, I know she submitted some writing, and is now the time we want to argue that, or do we want to?
I thought we were just going to defer to this.
well, I would like to get some things out of the way, because they were going to, in here, I just want to address that, Ms. Fisher, you had mentioned, I think it was off the record, that most cases, and I would tend to agree with you, in most cases that I've been involved with, and I recall one homicide where there was, we had I wasn't the judge, we had I think a 4-hour instruction conference in chambers, and, I went away from that thinking it shouldn't be done that way. We had a whole courtroom full of people waiting, and it was, frankly, it was a case that was tried like 2 weeks after State versus Deborah Head came out, which turned the whole law, frankly, well, I don't want to use a pun there, but
Well, Deborah Head overruled Camacho.
yes, and so that's where, it was a pretty significant case when there was arguments about self-defense, so it was, frankly, my experience from that is I'd like to do as much on the record as possible, because otherwise we're just going to be repeating a whole lot of things. We can do some off the record here in the courtroom, to give the court reporter a break if there are things that we agree on, but what I would like to do is go through and again, see what's disputed here, and then I guess we can come back and argue it, but it's disputed as to the 3 lesser included offenses the defense is requesting that the state is opposed to. So, do you want to take that up now, or do you want to take that up?
Well, I have done a written memo,
Okay.
which cites a lot of case law,
Okay,
though it's all Wisconsin case law, because I think that's what's pertinent here, except for one U.S. Supreme Court case. I would like the court and counsel to read my memorandum before I argue it, because, that was the purpose of putting it in writing. I don't know if the clerk has received the e-filing yet. Our final version of it was sent to Mr. Nelson's office at least 15 minutes ago. Madam Clerk, have you received it?
I won't receive it, it would be a different clerk.
Oh, okay.
I haven't received it, so I don't know that it's been.
Well-
I did not see it in the.
Okay, so, we can certainly, though we've e-filed it, I can certainly print a copy for everybody. Right now, it just won't have the formality of signature lines and the proper header, but
Sure.
the body of it is exactly the same. Would you like us to do that, Judge?
yes.
Okay, Mr. Maxey, could you please print out and with a copy for the court and a copy for the prosecution.
Okay, moving on then, so obviously we'll come back and we'll argue that then after the lunch break. We're going to take a longer lunch break today. Okay. Some water.
The other thing, Judge, I'm sorry, Mr. DeFore, did you submit your proposed McMorris instruction?
Yes.
Okay. We're also in the process of e-filing an alternative to the state's McMorris instruction. They're similar, but they have different language. Do you want us to go get a copy of that printed as well?
Yes.
Okay, we will do that. Mr. Nelson's going to go tell that to Mr. Maxey. The other thing that we are e-filing, there were a few pattern instructions that we didn't see in the court's list that, I don't know if it was inadvertent, but just so you know what we're e-filing, we didn't see 155, which is exhibits. And if we overlooked it, I apologize to the court. But Mr. Nelson advised he didn't see 155, he didn't see 157, remarks of counsel. We didn't think there was 160, closing arguments. Or 190, weight of evidence.
Weight of evidence is on page 17 for sure.
Okay, that could be, Mr. Nelson read this, not me, so I can't say what's on what page.
16 has remarks of counsel 157 and exhibits 155.
Okay, that could be, I mean, we went through this very quickly.
Right.
So we were going to e-file additional ones if they're already in
And
there.
closing arguments is on page 20, counsel.
Okay, that's fine. So if those are in there, I apologize to the court and counsel.
Yeah, those are all included.
Okay, that's fine. We just made mistakes as we were going through the packet. So the other thing that we are e-filing is the proposed substantive jury instruction. And that has not, or that should be e-filed. If you want a hard copy, we can again ask Mr. Maxey to produce that. The other thing I wish to advise the court is the court's instruction, other acts modified, 275. We want to take a look at that and potentially make some changes to it. We just haven't had time to really think about that. I mean, I think our version will have similarities to what the court did, but perhaps some crucial differences as well, too. You know, I'm not sure, we haven't really talked about it. What? Okay. Well, the other thing that he wants a hard copy of is our substantive.
Yep, I'm working that out right now.
Okay, that's good.
And this is, these are, okay.
Judge, that was the, apologies for interrupting, that was the, one is the McMorris, defense version of McMorris, which is entitled the cautionary instruction, and the multiple page document is Ms. Vishni's memorandum of law, which anticipates, the first sentence anticipates the substantive instruction, which is being printed off right now.
Then and we probably don't need to file the requested jury instructions because we were wrong. We missed 155, 157, 160, and 190. So.
Yeah, 160 is actually, this is 460.
460?
Yeah.
Oh,
And it's,
sorry.
what, page 20?
Okay, that's fine, but while you were out of the room, it was determined that we had missed 155, 157, 460, and 190, that they're all in the court's submissions.
Great. So
I think we could tell the office to not file this, and that we need to work on 275. So we could probably, you know, I don't know how long it'll take me to do that. That's a rather...
I have my scribbles, so we have, I think, minor edits to the to the judge's proposed one.
Okay, but we need to retype it, so, yeah, we should retype this.
Okay, well,
If you, I don't know if you want me to do that after lunch or
You know,
before lunch. I could get this typed up in about 15 minutes. I'm not that.
yeah, well, that's what I thought. We would break for a period of time. Again, the court reporter needs time to work on those transcripts.
Right.
So,
Just tell me when you want this.
you know, if you were to email it, if you typed it and emailed it to Mr. Dietrich, that would be fine. We can print it out.
Yeah, I think he must be on my email now because I emailed something yesterday, right? I'm sorry, what was the first name of that person again?
Joseph.
Okay, let me just, it's right. It's right where? In my email?
No, he's right.
He's right there.
Oh. I'm so sorry, because we hadn't met personally, I don't think. Okay, but let me just see if it would be Dietrich. D-I-T. I'm sorry, Mr. Dietrich, what's your email? D-E-T?
We can go off the record for.
Oh, Joseph Dot. Yeah, I have you in my email, so I feel like an idiot. I'll email that to him as soon as I've finished it, and I'll go work on it right now before lunch. So do you want us to reconvene before lunch?
No, again, I want to give the court reporter an opportunity to, work
Sure,
on his transcripts, and I want to know, what we can agree on and, what's disputed. And so I can study those differences and come back for the formal conference then.
I think we'll also submit a revised version of what I think Your Honor's calling the
mind science instruction.
Well, I made that in brackets. I took that from Morgan because of the use of the term mind science in quotations in that case, but
Just
I think,
whatever we call it, just
I think it should
we're talking
be-
about the same thing.
I'm thinking it should be called psychological evidence.
I do too. That's rather passé, mind science. Case is over.
Well, there's I think psychological evidence is more appropriate.
Right.
For instance.
And we would agree, Your Honor.
Okay.
All right, so then we're going to so both of these really, one is 275/605 and the other is just a pure 275. And we're going to enter revised submissions to both of these. We appreciate the fact that the court has done some work on these, really
What's the
make
starting
our
point?
path easier.
Yeah, it's just a starting point.
Okay, so we'll retype this and get that. So what time, Judge, would you like us back here?
Well, let's work through this. I want to know let's figure out what we have. And then
Oh, we
let's
have more
talk
to do.
about that.
I'm sorry, I didn't realize that.
Well, okay, you mentioned different in substantive instructions. Was there something about the substantive instructions that,
Well,
Apologize, I just handed our substantive instruction to Joseph.
how does it differ from the pattern instruction? Is that significant?
The insertion of self-defense in different places, and obviously the lesser included. The biggest difference is all 5 of the homicide charges, as opposed
Okay,
to,
I see.
as opposed to the instruction that right now only, I think, has 3. I don't know what the basis is, other than just, that was the state's original submission for first degree, second
Yes.
degree, first degree reckless.
Yeah, that's the starting point for us.
And so we have in ours, the language that we talked about before, use of the word woman rather than person. We have all 5 homicide counts, and we have, I think, the appropriate use of self-defense based upon the Austin case for the reckless matters. And I apologize, I don't have the Austin case at the top of my head, but it's mentioned in the footnote.
Are you talking about force less than that likely to cause death or great bodily harm?
Hold on just a second, Judge.
.801 instead of 805.
no, the Austin case,
Is that in your memorandum?
no.
So the Austin case, I apologize, State v. Austin, AUSTIN, 349 Wisconsin 2nd, 744. The open site, 213 Wisconsin Appellate 96. That was regarding self-defense in reckless crimes. There was a modification to the standard jury instructions, I believe, in 2015. What the jury instruction committee said, modified it based upon Austin. The defense thinks that it did not follow Austin completely, and that's you need to read Austin, is the bottom line.
All right.
Yeah, so that's not in the memorandum because the memorandum only really deals with the issue of reckless, the 2 degrees of reckless and negligent homicide and lessers in general. So this has to do with the way that the language is drafted on self-defense to every single degree.
All right. Well, I'm going to just address the issue about the self-defense, the wording of that right now. I'm going to stick with a reasonable person. I think that's correct in the law. I've had a chance to think about it overnight. It's a neutral pronoun. I think it's very appropriate. And looking at it from the circumstances of the defendant, certainly you can argue, that's one circumstance. She's a woman. But I just think a gender neutral pronoun in that's what the pattern instruction is. And I just think that's the correct way to instruct the jury on that, just so put that to rest. I heard arguments about that yesterday, and so that's going to be that way.
Okay, 1 minute, Your Honor. So do we have it? Okay. So what we have, so we're going to go, can you go back? All right. So we're still e-filing for purposes of record preservation, that jury instruction, so that's preserved. But we have a backup version that uses the gender neutral, but still with the lessers and the self-defense language that we are asking for. So Mr. Maxey is going and getting a copy of that now, so then the court can look at that without having to think about, oh, I need to change this gender language. I think I'll just make it easier.
All right, thank you.
Well, Your Honor, I guess the state's position is that, the law and the instruction says that they are to take, that it's the reasonable person in the defendant's situation. It already clearly makes that case that does it. You don't have to change it to a reasonable woman. I think, frankly, it's inappropriate to do that. I don't think there's a basis for doing that. And I think that sticking with the standard and jury instruction is the way it should be, and it already, as I say, takes it into account.
Okay, and so that's a decided issue then. Okay, so as far as the substantive instructions, it's just, again, it's not the substantive instructions themselves, it's just whether they're included, and then a different self-defense instruction for the reckless lesser included than for the intentional crime and lesser included. Is that correct, Ms. Fishney? Is that the difference?
I'm sorry. I was
No, in
looking
terms
at-
of the elements of the offense, you don't
Yes.
disagree on that? Okay.
Yeah, it's going to be identical, but it's going to use the pattern gender neutral language.
You were correct, Your Honor. The issue that we're contesting is when and how many times does the self-defense definition get inserted and where within that as well. I believe the pattern instruction on reckless, if Your Honor gives reckless, the pattern instruction does not have self-defense as a separate element. The pattern instruction has self-defense as a part of the assessment regarding criminal recklessness. And it's the defense's position that Austin actually says that just like under intentional, when it's reckless, self-defense needs to be consideration not only in the assessment of recklessness definition, but it's a separate element in and of itself. And so that's the distinction in our instructions from the pattern instruction.
Okay.
So I just didn't want to say that we were agreeing that they're the elements, because that's really what it comes down to is self-defense an element of recklessness, or is it considered in some other way?
And Mr. Dufour, I mean, for sake of argument, that court were to give the lesser included instructions on the reckless homicides.
Yes, and the court, if the court does decide to give the lesser included, it's right in the instruction that you've prepared. It says the defendant is guilty of first-degree reckless homicide, et cetera, et cetera. You will be asked to consider whether the privilege of self-defense, in deciding whether the elements of first-degree reckless homicide are present. You don't have to give the instruction and shouldn't give the instruction on self-defense multiple times. It gives it inordinate emphasis if you give it multiple times, and there's no reason to give it multiple times. It's already in there, and if the court gives additional lesser includeds, you can add additional lesser includeds to that instruction, which starts on page 3 and ends right now at the top of page 4. You can just add on another bullet point after that one if you give second-degree reckless, another bullet point after that if you give homicide by negligent use of a dangerous weapon. There's no reason to give the whole instruction on self-defense more than one time.
Yeah, I not trying to rebut, I understand that position. We disagree, but I understand his position. On page 9 of Your Honor's submitted instruction regarding first-degree intentional, it talks about, first-degree reckless. It lists the elements of the crime, and it lists 3 elements: cause of death, death by criminal or reckless conduct, and number 3, utter disregard for human life. And it's our position that there needs to be a 4th element, and that is while not acting in self-defense. Just like there's an element for that in the intentional, it's an actual element as opposed to a consideration under reckless. I understand they're gonna oppose that, but I just wanted to make clear what our position was.
Okay, good, thank you. And we'll take that up again when we reconvene after I read the Austin case. Okay, now, I'd like to just again go through this briefly. We talked about now the substantive instructions and lesser included and self-defense. On burden of proof, presumption of innocence, I know there was a pretrial motion on that, 140. I have been giving, I'm sorry, the version that we have in this draft, which sort of a compromise. It comes from I think the jury instruction, it comes from a footnote, and I guess I'd like you to weigh in on that, but rather than the last sentence, I change it to, you are to search for the truth and give the defendant the benefit of a reasonable doubt if it arises in your minds after you have carefully considered all the evidence in the case.
Just from the defense perspective, Your Honor, we filed written arguments about this, I believe, with a brief. I understand Your Honor's ruling. I stand by our position, but I don't know that the defense is requesting to be heard on it anymore.
Okay.
And while the state would prefer the standard draft, we understand the court's position and understand its court's discretion.
Okay, and so I'm going to give it the way it is here. I think that's a fair compromise. And there had been a fairly recent case, I think, that really upheld the standard instruction 140, but the court does have some discretion there, and I think this strikes a fair balance. Okay, any dispute with 145?
No, Your Honor.
What about 103, the pattern instruction? I think we have to add in there
This has the woman.
judicially noticed facts.
Nothing on 103, Your Honor.
And, but you agree we should add 4th, facts?
I think that's actually covered. In 3rd, it says any facts to which the courts or lawyers have agreed or stipulated or which the court has directed you to find.
Very good. You agree with that, Mr. Nelson?
I apologize, I was handing the clerk the neutral.
The pattern 103 would include judicially noticed facts, the way that it's drafted.
What page are you on?
That's page 12 of the court's packet. Okay. All right, and then with 275, there are a few different variations in the court's variations. We already kind of covered that. Now we have the submissions from both parties, so we'll study those, and then we'll take up argument on that when we reconvene.
You don't have the R2,
I think it's,
McMorris stuff, you mean?
I don't know
Yes.
what you just handed to me, if that was a copy.
I think we called it, hold on, yeah, cautionary instruction, evidence of prior writings of the victim. That's what we call it. But right now I'm working on the courts too.
Yeah, I have your copy of that. Yeah.
Okay, I just wanted to clarify that we're still working on those.
Okay, yeah, and that's, again, that's what we're gonna have to reconvene, we'll take that up. Write their title. Mix those up. Okay, so, moving past that, 170,
Judge, we are going to be asking for 172 in addition to 170.
What's that?
172 is evidence of conduct, it basically reads something to the effect of evidence has been received as it relates to the conduct of the defendant after the incident, whether that evidence shows consciousness of guilt, and to what extent consciousness of guilt indicates actual guilt is for you, the jury, to decide. That's pretty close. I don't think it's an exact quote, but it's pretty close to what it says.
Okay,
We object to that.
okay.
I believe there's clearly been evidence of attempts of the defendant to conceal, concluding her statements to people that the incident happened at Owen Park, including her request to go to the hospital and not to have the police, and not a request to have the police called. You know, I think all of which are evidence of actions of the defendant and evidence that she lied afterwards. In fact, I think admissions that she lied afterwards about certain things, such as who carved boy into her arm, all of which is evidence of conduct that can be argued as consciousness of guilt, Your Honor.
Okay, again, we'll take that up when we reconvene. 157 and 150, well, 157, first of all, any objection to that pattern instruction?
Okay.
155, exhibits?
No objection.
No objection.
Objections of counsel, 148,
No objection.
No objection.
147, improper questions,
No objection.
No objection.
150, stricken testimony, there actually was,
There was some, so no objection.
No objection.
and weight of evidence, 190,
No objection.
No objection.
195,
No objection.
No objection.
and 300, credibility of witnesses, and we do have the draft with the defendant has testified in this case.
Agreed.
And no objection. And I assume that portion about the defendant testifying, I believe, has to come in at the defense's request, but I assume they are, and it's no objection.
Okay. All right, then 200, extra expert opinion,
No objection.
No objection.
expert testimony, hypothetical questions. There was hypothetical questions asked by Mr. Hahn.
Yeah, I think there were some, so I
Yeah.
think,
Any objection to that?
I don't recall the hypothetical question, but that's the standard instruction if there was one, so.
Okay, and then we'll just take out the shaded and bracketed portion, who requested it. So, then 205, then okay there. Impeachment of witness,
there was testimony as to Mr. Stoiding having been convicted of a crime, so it would be, I think that was the only one.
okay, so again, we remove the bracketed shaded language, and then it would be evidence has been received that one of the witnesses, he's the only one, in this trial, has been convicted of crimes. And then, so we remove the rest of the shaded language there, adjudicated delinquent, we don't have that. Take out the brackets, but it would be convicted of crimes, I think it was 24, something like that. And then, so, both parties okay then with that?
Yes, Your Honor.
Okay. Okay,
We're withdrawing 327, Your Honor.
327 will be out, there's no evidence of prior. Okay, 160, okay, I misread it, it was 160, not 460. 460 was right next to it.
Agreed.
Yes.
So that one is okay. Closing instruction. And of course, 482 will depend upon, what the decision will be with respect to
Is there
lesser.
a longer version of 460 if I'm? I'd have to look it up here, sorry, Judge.
Well, just make a note of it, I just assume that.
No,
Right.
that's a full 460 as far as I recall it.
I think this is the straight pattern instruction for 460.
I agree that is the straight pattern instruction for
460. I thought that there was another number that's an alternative to 460 in my possession. But I will have to look it up and get back to you.
Okay, we'll hold off on 482. What about 515? Everybody
No
okay with that?
objection.
Okay.
Agreed.
And 525.8, I don't know that that's all after anyway. So then the verdict forms and all that will be dependent upon lessers as well as, but they will include for any guilty verdicts or substantive offenses, will have the question, if you find the defendant guilty, do you find that she used a dangerous weapon, yes or no?
Now, there should also be an instruction on use of a dangerous weapon, Your Honor. I'm not sure on the number on it, but we'll find that and advise the court as quickly as we can.
Okay, so any other areas that we need to address when we reconvene?
No, Your Honor. Outside of, as I said, the use of a dangerous weapon and as to the 172, nothing else.
Okay. And has the state had an opportunity to review well, I should put it a different way. Is there anything in addition the state would like to submit with respect to the 275 and the use of the psychological evidence?
No, Your Honor, I think what I saw on here, and I have it, well, I put it to the side, but now I don't see it to the side. I think the way the court did it is fine from the state's perspective.
Mr. Nelson?
We
Ms.
disagree,
Vishnu.
we disagree, we'll be submitting, is this the 275 panorama evidence, or is this the 275 psychological evidence, but?
This is well, it's not really, it's just, I just drafted it.
We're submitting revised versions of the jury instruction regarding the journals, revised vision of the jury instruction regarding panorama evidence, and a revised jury instruction regarding psychological evidence. So we will be submitting in writing those defense proposed versions of those three
Okay,
instructions.
and you do that, when will you have that?
Now, the panorama one, I've been typing while sitting here, it's just about done.
Okay.
Really. We could probably,
I think we can do them both. I think the other one has other minor changes, so 20 minutes after we're out of court?
Sure.
it's mostly a question of how long it takes me to type. It's much more that's what's taking the time, quite frankly.
Okay.
And Your Honor, the instruction on use of a dangerous weapon is 990.
990, got
Yes.
that, Joseph?
So this was charged with.
Mr. Dietrich.
I didn't know that. So that's in our jury instruction.
All right, then, we'll go off the record for a moment. Madam Reporter, how much? Sorry about that. All right, we are back on the record.
Judge, for the court and everybody's aware, I have good news that, if for some reason jury deliberations go into next week, my trial in Iron County, a plea was entered today.
Well, good, all right.
But hopefully they don't go into next week, so we have to worry about that.
Here, I thought the good news was going to be that we actually agreed on a difference in a jury instruction.
We've agreed on some things, Judge.
We agreed on some things, so,
We're hoping you agreed on the jury instructions.
well, we can at least tell you that as to the, hold on a minute. You have to press on it for a while, here. We can at least advise you, Your Honor, that we have agreed on the instruction that is called, it has cautionary, one minute. It's called the cautionary instruction, evidence of prior writings.
The version that you proposed?
The version that we proposed is agreed to by the state.
Yes.
So that would be fine. I'm assuming the title of the instructions, you don't read them, you just read the body of the instruction, correct?
Yes, I usually leave the titles in there just for being able to, particularly for instruction conference, but if council.
For the conference, yes. For the copy that goes to the jury, I want it called prior writings of Alex Woodworth, not victim.
I think that's what we have in the version that you should have from us.
Oh,
Wait,
okay.
no, I'm sorry.
Yeah, it says victim. I just think it should have his name, Alexander Woodworth. But otherwise, the defense copy has been agreed to by the state. So we don't have to fight about that.
Yes.
Joy, did you see that?
I don't think that one's in there, I think we only have the one by the state, so we'll have to add that one on the next draft.
Okay, so the one that the defendant proposed, we'll put in there, because I think I did.
Did we
I think
e-file?
we were just trying to get it done fast and missed
I
it.
think it did get filed.
Okay, I just want to make sure we've all right. So I would ask for that one modification that it be, that in the packet, that it say of Alexander Woodworth.
Okay, so do you have any objection to the bold capital letters in between, like,
No,
would say evidence of prior writings of.
no, I don't care about that.
Okay, so we'll replace what we have here. It'll be cautionary instruction, this is on page 16, cautionary instruction, evidence of prior writings of Alexander Woodworth. And then it will be what is.
The defense version.
Defense.
Okay, thank you. The next one, which is the panorama evidence instruction. The defense submission has an error, which it failed to incorporate the last paragraph that the court had drafted, where it says definitions on the issue. It's two paragraphs. It's the evidence was received on the issue of context or background.
Right.
I think that the state has no disagreement with the defense revision of that instruction and the omission by the state. What?
Right, Your Honor, we had no problems, and I think the court did that already. The court changed that in what it submitted to the sexual encounter between Ezra McCandless and John Hanson. But the end of what the court had originally submitted, which states definitions, and then the evidence was received on the issue of context or background, that is to provide a more complete presentation of the evidence relating to the offense charged. The next paragraph, you may consider this evidence only for the purpose, it probably should be purposes I have described, giving it the weight you determine it deserves. It is not to be used to conclude that the defendant is a bad person and for that reason is guilty of the offense charged. That language should be included still, and I believe counsel is agreeable to that.
Well, take a look at ours on page 15 and going into 16. Does that have to be changed then?
Yes, we've changed it. Hold on a second. Yours,
Because I thought we put
where
in
is
there.
it? Hold on a minute. Is this a new copy?
The last two paragraphs that you had, so we can just reinsert the paragraphs you had.
Okay.
One second, because we did make some changes. So wait, this is prior writings. This is not prior writings, we're not that. Oh. Okay, page 15 going into 16. Okay. So, all right, so we changed alleged sexual assault into sexual encounter. The parties agree with that. Let me just look at the other. With respect to the offense charged in this case, but I also like the last sentence that was in the original court's version, and I think we should have it, which is, it should not be used to conclude that it says the defendant, I would ask it to say Ezra McCandless, is a bad person, and for that reason is guilty of the offense charged. I would like that last sentence in there.
All right.
I just think if the court just puts back the paragraphs it had under definitions, that properly states the law, and just have that whole section in there. That's the way we would request it, and I think that states the law. It conforms to the pattern instruction on it, and that's what our request would be.
I'm agreeing with you. I just would like the word Ezra McCandless instead of defendant there, because we've used her name throughout that, and I do feel her name should be used throughout this, because we're...
Okay, in this instruction, but not necessarily the whole packet. That may be an issue, but...
No, I'm talking about this particular instruction. We can get to that
Yeah,
later on other
okay.
ones, but this is full of people's names, so I think she should be just treated the same as all the other names that are in there. I understand that.
Yes.
Yes,
That's what we
okay.
want. So we insert the last...
Okay, that's good. So that one we're resolved, all right?
Okay,
Then, okay, then the next one, the court's copy is on page 17. The mental condition. I don't know in your latest copy if you adopted ours or not.
Yeah, it's changed in that instruction.
yeah, we put both of your versions in there, and I'm fine with how you've changed the court's version. I'm fine with the defense submission as a statement of the objection.
I prefer the court's original version, Your Honor. I think it better states the law, and would ask the court to do that, but change from, first, this is not an insanity case, to this is a mental responsibility case. But otherwise, I think it more accurately states the law, and more completely states the law than the version requested by the defendant.
So, I don't agree with that. We've added these words. However, Ezra McCandless is not raising such a defense. I think that that's important and makes it very clear that the defense has not done that. All right, so that line,
Yeah, I'm fine with that line. but
Okay.
What is it, that, Mr.
think-
Dufour, that you believe that should be in there that isn't in the
I'm trying to
modification?
find, and I'm...
You're probably talking about paragraph point number
Court's original
1.
version, and, yeah. No, I've got it here, it's just a matter of getting to the right version here. It's this one. I have too many papers here, Judge, I'm sorry.
Well, I do actually have a version that had the court's versions with strikeouts and then ours in bold. And so I can tell you exactly what the differences were, Mr. Dufour, if you will trust me to do so.
Sure, that's
In
fine.
point number 1, this is what the court wrote. You may consider the psychological evidence on the issue of whether Ezra McCandless suffered from a condition, and then the court has the word caused a lack of ability. And we changed that to presented barriers for her to encode, store, or, because we think that more, it's not really a legal issue, it's what the testimony was. And the testimony wasn't really about lack of ability, it was about presenting barriers. So we think that more properly reflects what the doctor actually testified to. And that included encode, store, or retrieve, whereas the court said a lack of ability to retrieve. So, and then the court wrote an involuntary repression or blocking of memory, and I don't think, that implies that that's being done proactively. by the person repressing or blocking memory, that's something that someone's making a choice. So we changed that word to response, an involuntary response that interfered with her ability to remember. We think that more accurately reflects the testimony. It's not really a legal issue.
Any, from the state, any,
This is the original version? Okay. Let me take another look here.
Mr. DeFore, I could email you the two together.
No, that's fine.
Okay.
I don't- There it goes.
The old court's version, but the new court's version adopted ours. Right.
Well, I guess I don't have a problem with the modifications, that's fine.
No,
all right, then we'll leave it that way, and then we'll
that's a good one.
take out the paragraph above it on page 17.
Okay,
Yes.
Okay,
all right.
and, okay,
Then we get to, oh, you know what, ours doesn't have possession of a dangerous weapon there. And it should. Well,
okay, you want to go back to the top then? And I guess you can tell from the packet that I provided to you that I have not included the homicide by negligent handling or operation of a dangerous weapon.
okay, I'm sorry.
And let me know when you're ready. We'll go into the
Yeah,
lesser included.
I have so many papers in front of me, unfortunately, I kind of lose it when that happens.
Yeah, I totally understand.
Okay, so I need to figure out which is which. So the courts these are the new courts. I need Mr. Maxey to help me, just 1 minute, please.
I only brought one version back with me.
These are the new ones, not these? What's this one? They gave us two copies. Okay, so let's go to the works one, just so I understand. Okay, so what the court's inclination is, just for the very first issue, is to not give homicide by negligent handling of a dangerous weapon, but to go down to second-degree reckless homicide.
Well,
Is that what
I feel, first of all, right now, that I think it's appropriate to give first-degree reckless homicide instruction in a version that the defense submitted. With that version of self-defense, I read State versus Austin, and we have included it, make it clear that it is an element the state has to prove that it was not lawful self-defense.
And we are not, I was not going to disagree with that, Your Honor, when we got to that point, so.
I think the state's disagreement is about whether it gives it at all, but
Right.
if the court's giving it, the state did not disagree with the defense use of the language.
Right.
Yeah, I mean, I think the pattern instruction does say that the burden is on the state. This just makes it more clear, puts it out there as an element, so.
It does, and then the other difference that I have to look at was, and I think the parties both agree with this, is, all right, so on page 4 of the court, but where's ours? Okay, so on page 4, so let's, where the discussion occurs of self-defense. So the court's version starts on page 3.
Okay.
Okay, the court's version starts on page 3. Where, okay, can you get that for me, please? Okay. Ours starts on page 2, so we have a line that the court doesn't have, which is self-defense is an issue in this case.
Right. And we agree that should be there, Your
And
Honor.
where would you?
Just under, it should be the first sentence under self-defense.
Okay,
The
like a
court starts,
paragraph by itself?
no, it's just the first sentence of that paragraph.
Okay, so just change the first sentence of that paragraph. Mr. Dietrich, to
Add the first
self-defense is an issue in this case.
Okay.
Yes.
Actually, Judge, I made a mistake. If you actually go back to page 2, we have a one-line theory of the case in ours, where we wrote, it is the defense theory, whenever the court ends with the charges it's going to give, I think it is appropriate to give a theory of the case instruction that the law is pretty clear that that theory of the case should be very brief and succinct. And so we wrote, it is the defense theory of the case that Ezra McCandless stabbed Alexander Woodworth in self-defense.
My only problem with that, Your Honor, is that that's already in there, because I understand a theory of the case instruction when it's not part of the instruction already, but it's already part of the instruction that this case is about self-defense. I don't think you need a separate theory of the case instruction when it's already, the court is already instructing that self-defense is the defense in this case.
Well, it's our position that, first of all, we want it. Second of all, we think that the law allows for it. And third of all, every trial I've ever been in, it has been right after crimes to consider. That's where all the courts have placed it. So that's the reason for it being placed there as opposed to a separate jury instruction. I think that's where it should go. If the court doesn't want it to go there, then I think it should be a separate instruction. But
So,
I think it makes a lot more sense to put it there, and I don't think it's overly obtrusive. It's one sentence that incorporates really the law with the facts. So the defense theory of the case that Ezra McCandless stabbed Alexander Woodworth in self-defense, that's it.
and where do you believe that should be inserted?
I think it should be right after crimes to consider, obviously.
Page 2?
Page 1.
Page 1.
Oh, I'm sorry, page 2 of your version, page 1 of our version.
All right.
Yes, so that's where I think it should go, right after the crimes to consider. It should be the last line of that paragraph.
So the last line of the paragraph.
Yes.
Yeah, again, I don't see any harm in doing it to the state, or any prejudice to the state, so we'll do that. The theory of
It is
the defendants, or the defense theory, or
It is the
defendants?
defense theory of the case. I don't care if you say defense or defendants, it's just the way I
Okay.
wrote it.
We'll just do the defense theory of the case is that Ezra McCandless stabbed Alex Woodworth.
Yeah, we don't have the word
Self-defense.
is, just that. It is the defense theory of the case that Ezra McCandless stabbed Alexander Woodworth in self-defense. Okay, so that's, oh boy, sorry.
Okay,
Okay,
so
all right.
Go with
Now,
that.
moving along, so this is our page, this is the court's page 3, right? Self-defense. All right, so then, as it goes, page 3, the rest of that would be the same. Page 4,
I think actually, counsel, on page 3, after the defendant is not guilty of any homicide, that paragraph, I think there should be the defendant in their request at the bottom of page 2 has language that is part of the pattern jury instruction on self-defense, and so I believe is
That's
appropriate
appropriate.
there, which is a belief may be reasonable even though mistaken. The reasonableness of, and whether the court uses Ezra McCandless's or defendant's belief, I'll leave up to the court, must be determined from the standpoint of her at the time of her acts and not from the viewpoint of the jury now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of defendant or Ezra McCandless under the circumstances existing at the time of the alleged offense.
that's correct, and that's direct language from 805.
Right, I agree. I looked up 805, it does directly come from there.
Mr. Dietrich asked me specifically about that, and I thought we had that somewhere else, but we'll read it.
I looked, I didn't see it somewhere else, Your Honor, so.
Well, I didn't have in a belief may be reasonable even though mistaken. I think we took that out, so you know which paragraph, Mr. Dietrich?
If it's, I didn't see it somewhere else, but if it is somewhere else, then that's fine, but if it's not somewhere else, then it should be in there.
Okay. We can give it to you if you need it later. I mean, we have it on our copy. Okay,
Yeah, we have it. We just,
right.
you have to retype it.
No, it's fine.
Okay.
In there if you want.
And you want that, you believe that that should be in the area of
Yes.
self-defense?
We think it should be there.
Okay, so we'll put that in,
Okay.
between the
Not guilty,
perfect self-defense and the,
and then starting to get into the different degrees. Now,
okay.
The
so on
next-
Page 3.
okay, then the next one, okay, your next bullet point and ours are the same. The first degree intentional bullet point is the same. The first degree reckless adds the words, "and she was not acting lawfully in self-defense," which we think conforms with State v. Austin. So the court's version ends with utter disregard for human life, and we add the words, "and she was not acting lawfully in self-defense."
What page are you on?
That would be page 4, Your Honor, of yours, but our submission, it would be page 3.
Your Honor, our position is that the court has, you will be asked to consider the privilege of self-defense in deciding whether the elements of first and second degree reckless homicide are present. You're already covering it, you don't have to put it in twice.
I think it has to go in with each count. I think that's kind of the teaching of the Austin.
I think we do have it. If you look at the counts,
It's included in the elements.
it's included in the elements.
No, that might be, I haven't gotten there yet. I'm just on this kind of summary page with the bullet points. Under self-defense. I think it should be there. And I think I think it's unclear here, and she was not acting lawfully in self-defense. And I'll tell you part why I think it's important. You may have it in the later. I have to tell you, I find this one of the most confusing jury instructions I've ever dealt with. And I've tried a lot of self-defense homicide cases, and I am befuddled every time I go back and do another one.
Well, it's difficult stuff.
It is really hard, and if it's hard for us as lawyers and judges, I can just imagine how hard this is for the jury. So I think this really clarifies right in the beginning that if she's acting in this privilege of self-defense, she's also not guilty of these, the court has first degree reckless and second degree, So I think those extra words, which are not very long, it's, "and she was not acting lawfully in self-defense." So it's just a matter of a few words, 7 or 8 words. I think it really clarifies what the law is to put it up here.
And where,
Well, Your Honor, and I don't know, if they want it there, that's fine, but then that last sentence that says you will be asked to consider the privilege of self-defense in deciding whether the elements of first degree, second degree reckless homicide are present should be struck, because you've just said that, you don't have to say it twice. There isn't a reason why it needs to be said twice. You can, either way is fine with the state. What our problem is not putting it in there twice.
Okay.
Because that gives undue emphasis to it.
Okay,
So the
I
bullet
don't have a
points-
problem with what the state said. I just think, so on your page 4, Judge,
yeah, I see what you're talking about.
right, if you would add the
Mistake.
words, "and she was not acting lawfully in self-defense," if you would do those words after that and after the second degree reckless homicide, also,
I'm fine with that. Like I say, one way or the other, but it's just both that I have a problem with.
Okay, that's
Okay.
fine. So we'll just, that way it'll be consistent on the summary page on page 4 with how we have it in
okay,
later as the
that's
element.
fine. So we should just, okay, here you are on your copy. All right, very good. All right, so then going next, it says, all right, we have another sentence in our sentence, which is on page 4 of our submission. And if we were going with the court submission, it would fit page 4, which would be after you name all of the lessers that are being submitted to the jury. we have a sentence that says, this includes the requirement that the state must prove beyond a reasonable doubt that Ezra McAllis was not acting in self-defense. So we want that sentence added.
Your Honor, I believe that a portion of that is part of the pattern jury instruction, but I believe it should start with the state must prove beyond a reasonable doubt that the defendant was not acting in self-defense.
I don't have a problem with omitting the words, this includes the requirement that.
Where do you think that should go?
That should go right after,
But right before it says, if the state does not satisfy you.
right.
So after the word second-degree reckless homicide, but before the next sentence.
So, on page 4, sort of just below the middle of the page, in that paragraph where it says, okay, do you know where that is, Joseph? Mr. Dietrich? Right after a sentence that ends with, or second-degree reckless homicide, you would insert, the state must prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. Is that the language?
That's fine, Your Honor.
Everyone agrees on that? Okay.
And so, one question, Mr. DeFore, are you saying that the pattern instruction does not include those words, this includes the requirement?
Yes, it
Okay.
does not.
Okay. Yeah, I'm not going to argue about that, it's too small of a point. Okay. All right, so then, statutory definition, state's proof, elements the state must prove.
Okay. Clarinet.
Okay, so this is all the same, right? Okay. Actual belief then is on page 6 for them, and it's on page 6 for us. That's the same, right? Okay. Okay, so the difference is at the bottom of page 6, Judge.
Okay.
Your paragraph says, you are only to be concerned with what the defendant actually believed, period. We agree with that. The last sentence says, whether these beliefs are reasonable is important only if you later consider whether the defendant is guilty of second-degree intentional homicide, and I think that should include all of the lessers that the court is going to give at that sentence, because the reasonable belief is important for first-degree reckless homicide, second-degree reckless homicide as well. So that's how our version goes. We added all of these lessers. And I understand it looks like the court's not giving homicide by negligent handling, but we think it should.
Okay, we can make.
Where in yours was that?
On mine, that would be page 6, Mr. DeFore, right before jury's decision.
Page 6 on yours?
Yes.
Actually, I think it's page,
Should be page 6 on ours, not the last paragraph. And on the court's copy, it's also page 6, but right at the bottom.
okay.
So I think whatever lessers the court is giving should be included in that last sentence.
I'm not sure I agree with that, Your Honor. And because I believe that goes only to the element of it being imperfect self-defense for purposes of second-degree intentional homicide, because, and I think it still has to be perfect self-defense to be a defense to first-degree reckless or second-degree reckless. So I think it still has to be a reasonable belief to be a defense to first or second-degree reckless homicide.
Correct, and that's really what and that's what we're saying. That whether these beliefs are reasonable, whether the belief is reasonable is not relevant to first-degree intentional homicide. But we're saying whether it's reasonable goes to all other lessers. That's essentially what we're saying.
Yeah, there's something confusing about this.
I
think-
know.
I think that only I agree with Mr. Dufour that after looking at these cases this morning, that the reasonableness aspect is taken into consideration in the reckless by an unreasonable use of force, substantial unreasonable use of force. And so it has to be perfect self-defense. So that's why in the first degree reckless instruction, we left in the defense request for that short version of the self-defense law. Let's see.
So I just think it makes it more clear here that the reasonable belief really goes to every single count. Is it a little repetitive? Yes, but does it clarify the language? Also, yes, I think.
Let's see. The way that reads on the bottom of page 6 is confusing. It seems to me on first degree intentional homicide, the reasonableness is an issue. I don't know.
No, it's not well, not really, because if they find an actual belief,
It has to be an actual reasonable belief.
Right. And I think if you add that to,
I see.
if you add first or second degree reckless homicide to there, then you're basically saying that she doesn't have to have a reasonable belief for first or second degree reckless homicide, but she does. She has to have an actual and reasonable belief to support a defense to first and second degree reckless homicide. Reasonableness is only an issue if you're going to find her. Lack of reasonableness is only an issue if you're deciding second degree intentional homicide. So I don't agree that it should say first or second degree reckless there, because I believe that actually misstates the law.
Yeah, what about that paragraph in the bottom of page 6? Is that the pattern?
I think it is the pattern, and now I'm rethinking whether just that paragraph should just be struck, period, because I think it should either cover every offense or it just shouldn't even exist there.
No, Your Honor, because it has to be, I'll pull up the pattern instruction here, just give me a second.
Or the other alternative would be to end that paragraph with, you are to be concerned only with what the defendant actually believed. Because if we're going to say whether they're reasonable is important only if you later consider, I mean, then it really, to me, it's either you either have all of them or you just don't have it. No, I don't want to do that. I think if you do level sentence, you do none. Okay. So, well, I'll let you keep the notes with what.
Your Honor, I just pulled up the pattern instruction, and it is exactly, and this is the pattern instruction for first degree intentional, second degree intentional, and first degree reckless. And it says whether these beliefs are reasonable is important only if you later consider whether the defendant is guilty of second degree intentional homicide, period.
All right.
It's our argument that that is a misstatement of the law, that it should be for all of the lessers.
And I disagree, because that would be saying then that she does not have to have an actual and reasonable belief to act as a defense to first or second degree reckless homicide, and that is a misstatement of the law.
Yeah, I think that's correct. I'm going to just stick with the pattern.
All right, I understand. So you,
Okay.
Okay. All right, now moving on to jury's decision. I think that and make every reasonable effort to agree are identical. Then we go to second degree intentional. Let's see, number 3. Okay. Then we go to reasonable belief. And so when the paragraph that you have, Judge, on page 8, if you would go to page 8 and look at your paragraph compared to the defense submission, we think that our submission, which again follows number 805, should be used. So the court's version starts with the words, "the reasonable of the defendant's belief."
Yes.
And we want the sentence in before that, that we have, or it might be two sentences, a belief may be reasonable even though mistaken. In other words, the 805 language we believe should be repeated here.
All right, what's the state's position on that?
Your Honor, I believe the way I look at it is we either include that language at the start where it was included before, or we include it now. It doesn't get included twice. You don't get to say the same thing twice. So if they want to hear that it comes out back where it was.
Yeah, we'll be inserting that whole paragraph earlier.
No, I know that we're inserting it earlier, but here the entire definition of reasonable belief is here, so it's appropriate to be repeated here, because this is the full definition, so I think it should go in both places. So that's our position.
Yeah, it doesn't go in twice, Your Honor.
Yeah,
one or the other, and I don't care which one, but one or the other.
Yeah, we've already got that included, that whole paragraph, and this does again reiterate that it's determined from the standpoint of the defendant at the time of her acts. And, but the instruction, more elaborate instruction on self-defense does include that already. I believe may be reasonable even though mistaken.
All right, so it is coming in earlier, though.
Yeah, it is coming in earlier, so we're going to leave it that way.
All right, so then we go to jury decision. It's the same, right? Okay. Then we have every reasonable effort to agree, statutory definition. So page 9 is the same for both. Okay, so on page 10, you added in from our previous submission, and we're fine with that. The part that the court has highlighted.
Yeah, it's shaded there, but that's, that we would.
Right, I assume that's a highlighting in the original.
And the reason being is that, again, it just reiterates that it has to be perfect self-defense.
Okay.
In the reckless homicide.
Okay, that's fine. We don't have any, that looks fine. And then we go to the definition of utter disregard for human life.
Where are you at, counsel?
Page 11, I'm now on page 11. That's fine. Okay. Jury's decision, that's fine. Make every reasonable effort to agree is fine. So now we're at second degree reckless, the difference, that's fine. Right, it actually should be that way, not the way we did it. Okay, yeah, the way the court did it is correct. And but I think our difference is, so after the difference between the elements, we think the language that is on the top of page 13 for us should also go in. You should consider the evidence relating to self-defense in deciding whether Ezra McCandless's conduct considered an unreasonable risk to another. If Ezra McCandless was acting lawfully in self-defense, her conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that Ezra McCandless did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all the evidence in the case that the risk was unreasonable. So we're asking for that language, as well as the language, the next paragraph, to go in there, because we think that should be added.
Your Honor, it's, again, just repeating language that's already been given to the jury. The court has instructed them that they have to decide if she's acting lawfully in self-defense. I don't think we need to repeat language that the court has already given them.
No, they can refer back to that.
All right,
I'm not
well,
gonna repeat.
if you're not going to do all of it, Judge, then I think instead of, and the defendant was, and that the state has not, and the state has failed to prove beyond a reasonable doubt, I think that language needs to be in there.
Where now?
To conform with Austin.
Page 12?
Yeah, at page 12, if it says, in other words, where you have the words, and the defendant was not acting lawfully in self-defense.
Right.
But it
And I think
says,
what it should say, the state has not proven beyond a reasonable doubt that Ezra McCandless did not act lawfully in self-defense. That should be in there.
it says that just before that. It says, in other words, if you are satisfied beyond a reasonable doubt that the defendant caused the death of Alexander Woodward by criminally reckless conduct and that the defendant was not acting lawfully in self-defense, that's what it says.
Well, I disagree, so that's what we're asking for. That's,
Well, I think, again, I think that's already covered, and they have to prove each of the elements, and we include self-defense as an element. Certainly first-degree reckless, and then the second degree, the only difference is the element of utter disregard for human
Okay.
life. So I'm just going to leave it that way, because I've read through jury instructions so many times, and when I just feel when I'm repeating it, it's just, it just doesn't really add anything. And I think for a jury, if they're using these instructions and they refer to things, they can go back and look at the definition of self-defense.
Okay.
I think it's fairly clear.
all right, and
Fair
then
enough.
you say if you are not so satisfied, you must find the defendant not guilty. What did we write? Well, then we go to another lesser, but let me look at the very end of ours. So where it says if you are not so satisfied, you must find the defendant not guilty.
Page 12.
Yeah, I guess. I would ask, if you look at page 16 at the defense,
I don't have that version.
the defense version?
Yeah,
Page 16?
I don't have it right here.
Oh,
So,
okay, well, let me just read it, okay?
again, our effort is to make sure it's clear that the state has to prove beyond a reasonable doubt the defendant is not acting in self-defense, and I think we have that, so.
So, we should find her not guilty. So I think it should say, if Ezra McCandless was acting reasonably in the exercise of the privilege of self-defense, and her conduct did not constitute any criminal offense, you should find her not guilty. So,
What's the state's position?
Your Honor,
I think
it says, if you're not so satisfied, you must find the defendant not guilty. I mean, that incorporates more than just she was not acting in self-defense. It also includes that we haven't proved some of the elements of the offense. So the jury made, I think it actually misstates the law to the defendant's detriment to say, just, if you're not satisfied she was acting in self-defense, you should find her not guilty, because maybe the jury will find that we didn't prove she was acting recklessly. I don't know, but...
Well, I think this is the pattern. I'm going to stick with it.
all right, I understand what the court is saying.
Okay.
All right, and then obviously, we didn't, so I guess the one issue that has been, I am gathering that the court is not going to give homicide by negligent handling of a dangerous weapon.
Yes, and I'll just say, I reviewed those cases, particularly Miller, and the defense brief, which I have right here. I read through that, and I agree with the standard. And however, if I look at, and let me just kind of go down from first degree intentional homicide, second degree, we agree on that. I think, I believe that looking at first degree reckless homicide, if the jury, and looking at the facts in the light most favorable to Ms. McCandless, in that regard, just say she was wildly swinging this knife and anything and anywhere and everywhere, and if the jury did not believe that she was acting reasonably in self-defense, that jury could find that there was a lack of specific intent, and so could move on to consider reckless, first-degree reckless. And from that point, looking at second-degree reckless in the light most favorable to her, the argument that she, was concerned about helping him or something, that's up to the jury to believe. But again, if you look at the evidence in the light most favorable to Ms. McCandless, that there may be an issue as to whether it's utter disregard for human life. I'm kind of stuck on that. I mean, I'm telling you, last night I was thinking, I think first-degree reckless, not second-degree reckless. However, out of caution, because as Ms. Vishney has pointed out, often mistakes in jury instructions, particularly lesser included offenses, it could be pretty serious error. And that it's a fine line between utter disregard for human life and having just a scintilla of concern for human life. And frankly, I believe that the prudent thing to do is to instruct the jury on both first-degree reckless homicide and second-degree reckless homicide as we presented here. Now, now looking at the next level to homicide by negligent handling of a dangerous weapon, frankly, if the court does not believe she acted reasonably in self-defense, I don't believe a jury could go below second-degree reckless homicide. A reasonable jury couldn't go below that. I mean, there's a knife stab to the side of the head, vital areas, there's 15, 16 wounds. It just is not a negligent handling case. It's, I think giving her the benefit of the doubt in the light most favorable to her, if the jury did not find she was acting reasonably in self-defense, and if they're going down from first degree to second degree intentional homicide, then into the reckless homicide, first degree, then second degree reckless homicide, the court's opinion, again, if they don't believe she acted reasonably in self-defense, that a reasonable jury couldn't find that this was just negligent handling a dangerous weapon. That's my reasoning, and again, Counsel Jolee, welcome to make a record and argument.
Thank you.
If I can, as it relates to the reckless homicides, the state's position is, and certainly, and I understand the defendant's testimony was, I didn't intend to kill the defendant or to kill Alex, but again, if that was the standard on whether or not intent was present or not, we'd have a lot of very short trials because defendants would just get up and testify and intend to do this intentional crime, and we could all go home and call it a day. It's objective intent, and our position is similar to Morgan. Even though Morgan involved a gunshot as opposed to stab wounds, when you consider the variety and the severity of the stab wounds here, the state's position is that a reasonable person under those circumstances, there isn't any question, similar to there not being any question in Morgan, that a reasonable person would know that their actions are practically certain to lead to the death of another, and in this case, Alex, that there is a basis for the court denying any reckless homicide, lesser included. But going further, even if the court finds first-degree reckless is appropriate, and I can understand the court's position on that, and I'm not going to say anything more about that, I fail to see how, when you look at all of the conduct involved here, that her actions are not in utter disregard for human life. I understand her testimony about he said, can you help me pee? And she goes to help him. The fact of the matter is, after that happens, and again, putting it in light most favorable to the defendant, her actions, assuming that all of that took place, is that she stabbed him one more time, and then she took off from there, taking the cell phone of Alex, which she said she was taking to go call for help, but she never calls for help. When she gets to a location where help could be provided for him by saying, hey, he's back here at this, on this muddy road, call and get somebody to go there to help him to try and save his life. She doesn't do that. She says nothing about it. In fact, asks to go to the be taken to the hospital, not asked to get help for anybody. I also not asking to call for help. Left him without any ability to call for help because she took his cell phone and doesn't use that cell phone to try and get help. So under those circumstances, I fail to see how a jury could find that she's guilty of reckless conduct, but she did not act in utter disregard for human life. And so for those reasons, Your Honor, we believe that even with the finding that first-degree reckless homicide is appropriate, there's no way that the court should give second-degree reckless homicide, and there's no way that the facts would support a guilty verdict on first-degree but not second-degree reckless.
Ms. Fiske, go ahead.
Do you need me to respond?
Yes, please.
Okay, thank you. Judge, that's really a misstatement of the evidence here and what the standard is, because looking at the evidence in a light most favorable to Ms. McCandless, her testimony was that Alex Woodworth was walking and talking afterwards, that he laid down outside of the car, that he was continuing to talk outside of the car, that she did take the phone, but that she, intending to call, we know it's not a really long period of time to get over to Mr. Sippel's house from the police testimony, from what Detective Prock said, and when she gets there, she's in a completely dissociative state, and we have expert testimony in the record showing that her version of what happened, which is that she is now in this dissociative state and basically is totally out of it. We have in the record the actual hearing her on the background of the 911 call. We have in the record hearing her, Trooper Knudsen's tape recording. We have Dr. Benson with his diagnosis of PTSD with depersonalization and derealization features. So we have this discussion of the mental health issues, and that really bears on this particular issue. It is very close. That third element, which is why in virtually every trial I've been in where first-degree reckless has been a lesser of first-degree intentional, the courts have always also instructed on second-degree reckless homicide because of the closeness and the kind of subjectivity with this utter disregard for human life. So looking at this evidence in a light most favorable, which is the standard, and there is clearly a reasonable jury could find that she acted with criminal recklessness. In other words, that she had the awareness that her conduct created a substantial and unreasonable risk of death or great bodily harm, but that there are not circumstances that show utter disregard for human life. Do I need to make more argument, Judge?
No, I think, again, this is one of those exercises in the law where it's looking at it in the light, the law requires that I look at it in the light most favorable to the defendant. And so, because first degree and second degree reckless homicide could be razor thin under various circumstances, I just feel it would be imprudent to not instruct on second degree reckless homicide. So I'm going to instruct on second degree reckless homicide, and again, attorneys can argue this, and it's a jury's decision, but I do believe that
Okay.
I'm going to include it, but I don't believe that in any way, shape, or form that it would be reasonable for a jury, again, if they don't believe she's acting reasonably in self-defense, to go to negligent.
I understand the court's ruling. We have really submitted it in writing, but if I can just supplement the record so that it's adequately preserved on the defense side, the real difference has to do with the issue of awareness. In other words, the conduct still creates an unreasonable and substantial risk of death or great bodily harm or death. The issue is, was the defendant actually aware, or should she have been aware? So it's our position that under the totality of the evidence, here, including the psychological testimony, including Ms. McCandless's testimony, that subjective element of her having this awareness was not present, but so that a reasonable jury could find that she should have had this awareness, but in fact didn't. I'll just rest on that argument,
Okay.
Judge.
All right.
Okay?
So
I
noted
do
in that-
understand the court's ruling.
That'll be preserved for the record.
Thank you.
Okay, then, so that gets us through the substantive instructions.
Correct.
Okay.
I think we have then, I don't think we have anything else on the instructions.
Well, we got the 990 is next,
Oh, 990, yeah.
and,
Correct. Well, 990 is charged, as I understand it, in the information. Is that correct?
Yes.
Well, then it should be done as, it has to be done as a separate question and found as a separate fact by the jury, so.
so my thought would be to remove, again, the shaded, all caps at the, after the title to that, and include the shaded portion where it says, if you find the defendant guilty of the offense charged or one of the lesser included offenses, include that paragraph.
Yep.
And then the definition of dangerous weapon, use the second sentence that is there. Any device or instrumentality which in the manner it is used or intended to be used. And do that option.
Okay.
Any objection to that?
I think actually, because of the fact that it's the type of knife it is, I think it could be stated that it's designed as a weapon, and capable of producing death or great bodily harm. I think device or instrumentality which in the manner it is used or intended to be used, is intended for something other than a specific weapon. So for example, if you hit somebody over the head with a sledgehammer, okay, that's not designed as a weapon, but it's certainly in the manner in which it's used is likely to produce death or great bodily harm. But a knife, I think, is a device designed as a weapon, especially this type. Maybe if it was a steak knife or some type of kitchen knife, that might also be different, but I think this is more designed as a weapon. But I don't have a problem if the court gives it the other way too.
Ms. Vishny, what is your position, the defense
Sorry,
position?
1 second. Just talking to Mr. Maxey.
Okay.
Well, for once the state and I are in agreement, I would go with the first, any
Okay.
device designed
Then we'll use that first.
and
sentence,
manner is
certificate,
used
and,
is
not-
likely to produce, no, actually, wait a
How
second.
about we use both? How about we say any device, blah, 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 and then, or any device, we'll just include all of it. I think that, it's a little bit,
One
an
second.
extra sentence to read, I don't think
What's that?
causes any harm.
Yeah,
Yeah,
I think
actually,
that
I
makes
think it should
sense,
be
Your
the
Honor.
Any device designed as a weapon,
We'll conjoin them and use both.
all right.
Right.
So
That
instead of
makes
being
sense, Your Honor.
capable of producing death or great bodily harm, we're going to use the words is likely to produce death or great bodily harm. I mean, any device designed as a weapon, so this is my understanding of how it would read. It would read, any device designed as a weapon which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm.
No.
No, I was just,
No.
that sentence is just to put an or in between. So it'd be, any device designed as a weapon and capable of producing death or great bodily harm, or any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. And then the definition of great bodily harm just once.
I don't have the footnotes to the jury instructions with me. Did the footnotes indicate that it should be an either, or that only one should be selected?
Well, I don't think that's.
So then,
critical.
in that case, I guess I have to take the position it should be the second one, that it should not be both. which is the original way I think it is in the pattern instruction, it's one or the other.
Well,
So,
I'm just going to decide. I'm going to conjoin them.
well, I know you're
Yep.
going to decide.
Okay. Only one, we use the definition of great bodily harm once,
All right,
and so we don't repeat that.
all right, I understand, okay.
And then we already covered 140.
Right, you've modified it slightly.
And then
The
again,
last
we have
sentence,
to-
I understand that has been previously discussed. We've already covered the 275s.
Then I think the rest of the way we have already covered.
Well, we oppose 170, circumstantial
172, you
evidence.
mean? I think you said 172, actually, is the one you were opposing.
Well, that's what Mr. Nelson said. I'm, for the record, also going to oppose circumstantial evidence because I think it's a direct evidence case. The direct evidence is here in the form of Ms. McCandless advising that she was the person who wielded the knife and caused his death, so it's not a circumstantial evidence case. I won't make further argument, that's enough.
Okay, I'll just note that from the court's perspective, the circumstantial evidence goes to intent. And so there's, frankly, I think circumstantial evidence is present in a big part of the state's case as it relates to the elements of the offense, so.
I believe that Mr. Nelson previously made an argument to exclude number 172. I won't repeat that argument here. I think in light of the psychological evidence in this case, that for this particular case, it's not appropriate.
Well, I think that the defendant gets the benefit of the psychological evidence and the argument and the instruction of psychological evidence. And the state then has the opportunity to argue that these things, they can argue it differently, and I think the instruction gives that balance there. It kind of weighs it both ways. I just think on the circumstantial evidence, that rather than saying flight, escape, or concealment, it just be
I think that should be struck.
There's no escape, and there's no concealment,
Right.
other than if you argue that
Right, Your Honor, the way I look at it is, the instruction used to talk about those things, but it doesn't anymore. I think if the court is going to include in what this court sends to the jury, the headings, my suggestion is just take that heading out completely and just make it like it's a continuation of 170, which is really what it's intended to be.
That's fine.
I agree, and that's what I'm going to do.
We all agree.
Yeah.
Okay,
Okay.
Mr. Dietrich, you got that? Take out that heading for 172, but just include that paragraph.
Okay,
for
I'm going
170.
through the rest, I'm up to 300, let me just, which is patterned, experts, closing arguments, closing instruction. Okay. Unanimous verdict. Instructions after verdict received. Oh, that's for later. Okay. All right, so that's fine. I need to look at the verdict forms now.
Okay.
I looked at the verdict forms, Your Honor, and I'm fine with them.
If it's all right with the court, can we just take a very quick break while I go in and show the verdict forms? to
Well,
Mr.
one of the
Nelson?
things,
I've
and
seen it.
we'll go off the record for a moment.
Yeah.
Ms. Camshire may be needed by branch 2. Are you going to? Well, Mr. Dietrich, how long do you think it might take to make those changes?
15 to 30 minutes.
What's that?
15, 30.
Okay, so,
Take 30.
yeah, why don't we, if you come back in at 3:55, we'll have another packet. Just make sure it's
That's
what we
fine.
talked about. Okay, very good.
Sorry, what time did you say we should come back?
3:55.
Okay. We're in any greater danger of the jurors being influenced by outside forces during deliberations than the whole trial so far. So I guess I just know that jurors hate being sequestered and that it can lead to a rushed verdict sometimes because people just want to go home. And so we're not asking for it. I mean, I don't know what the state's position is. That was something that was said the other day.
We don't have a problem with the court that does it. The court doesn't, but I'm certainly not requesting that the court do it.
Okay, well, it will certainly make it, I think jurors would prefer not to be, and it would make for a lot less hassle. So I'm inclined at this point, given the fact that, they've been going home every night, once they start deliberating, that they don't have to be, so I'm inclined not to at this point.
Okay.
So,
We can talk about the timing later, but.
Yeah, and I think we need to talk a little bit about timing of things, what instructions are needed, but let's get them in the final form, and then we have a few things.
all right, back on the record, it's about 4:14. Each party was provided with one set of the final instructions. First of all, Mr. DeFore, is the state satisfied with that final version?
Your Honor, subject to the objections that we made of record, yes.
Okay, and Ms. Fishney?
Yes,
Okay, and again, I
same.
assume for
subject to-
both counsel subject to
Right.
exceptions already made, objections. And what about, did the defense wish to argue the sufficiency of the evidence?
Yes, Judge, it's the defense position. We are moving for a directed verdict. The burden now has increased to the state not proving each and every element of the crime, the charged crime, beyond a reasonable doubt. It would be our argument that because one of the elements of first-degree intentional homicide is that the state has to prove beyond a reasonable doubt that it was not self-defense, that the state has failed to prove that, even when viewing the evidence in a light most favorable to the state, it has not done that, and that only second-degree intentional homicide should be submitted to the jury, that first-degree intentional homicide should not, because they have failed to prove that beyond a reasonable doubt that Ms. McCandless did not have an actual belief that she was in imminent danger of great bodily harm or death.
Okay, Mr.
Your Honor, frankly, we believe that circumstantial evidence is sufficient to show that, and the direct evidence that she did not have that belief. If counsel's position were correct and that there would not be any reasonable basis for it, a defendant in a first-degree intentional homicide could always get up on the stand and testify, I was in fear for my life, and we could never get a first-degree intentional homicide verdict if there's only two people there and she's the only one that can say that. So, no, there's plenty of circumstantial evidence that her story is just that, a story, and that Alex Woodworth was not the initial aggressor, and that she therefore had absolutely no right to self-defense, much less a right to perfect self-defense. And so I believe that the circumstantial evidence is more than adequate to support a verdict of first-degree intentional homicide.
All right, and at this juncture, what is the standard?
Standard is the light most favorable to the state. It still is the same.
All right. Well, based on the totality of the record, all of the evidence, again, in the light most favorable to the state, first of all, there really isn't an issue as to whether the defendant killed Alexander Woodworth. The question is what the intent is in the light most favorable to the state. The court believes if the jury did not believe Ms. McCandless, and that a reasonable jury acting reasonable could find her guilty of first-degree intentional homicide beyond a reasonable doubt. I'm not going to go through all of the evidence, but I base that, again, on the entirety of the record, and so the court will deny the motion, but your exception will be preserved for the record. Okay, anything else that we need to take up before tomorrow?
Your Honor, a couple things that I think are probably appropriate to consider. First off, and I know every court is different as far as what they give as far as instructions before closing argument versus after closing argument. So I'd like to know just, for my sake, so I know when I'm arguing, am I going to be arguing the court has instructed you on this or the court will instruct you on it? Whatever the court's preference is, I'm fine with, but I just like to know. That's the first thing. The second thing is I'm just kind of wondering about timing. My closing, I suspect, is going to be somewhere in the range of about 2 hours, all right? Maybe a little bit shorter, but it'll probably be pretty close to that. At least from what I've seen, I haven't worked through, I've got a PowerPoint that I'm going to be using, I've created that, that's pretty much done, but I have not worked through how long each slide's going to take me to go through as I make my arguments. So, but just based on the number, I'm guessing right around 2 hours. So, depending on how many instructions the court gives before, that could be somewhere between 10:45 and 11 o'clock that I'd be done. I don't know what the court's plan is then. I would suspect, I would not be surprised if Mr. Nelson's argument is going to be that long or maybe a little bit longer. So, we have to plan on what we're doing as far as breaks for the jury, lunch, and so forth, and what type of break there might be between defense's closing, completing, and starting rebuttal, so.
All right, well, the court will read the instructions up to the closing instruction.
Okay.
And, which is on page 22.
All
So
right.
I'll read up to page 22 and then do closing arguments.
Yeah, we have a position on time limits, though. We believe that both parties should be restricted to 90 minutes per side for closing, with the state being able to reserve 15 minutes of the 90 minutes for its rebuttal. I don't think that we really need to each go on for 2.5 hours. I think the parties should have equal time totally, though of course the state, having the burden of proof, is entitled to do a rebuttal argument. Rebuttal argument is just that, is not to be sandbagging. It is the primary state's argument should be its original closing. Rebuttal can rebut particular issues that the defense has raised, should not be a repetition of the original closing argument. I think that 90 minutes per side is perfectly appropriate. We can get it done in 90 minutes. I think the state can certainly get it done in 90 minutes, and there's no need to belabor every point over and over and over again. Many things in this trial have been extremely repetitive, particularly I think many of the displays of photographs, we've seen the scene virtually 3 times over, and there's really no need to do that to engage in a summation for the jury.
Your Honor,
I'm not going to place a time limit on it. I think I'll let counsel make their arguments, and if there's, cumulative or, people are repeating themselves, maybe there could be an objection along those lines, but.
We also request that the court preclude the state from sandbagging in its rebuttal argument, that it in fact be rebuttal. In other words, the state shouldn't be arguing for 2 hours or so. I think that's what Mr. DeForest says he thinks he's going to take, and then the rebuttal go on for another hour. That just doesn't seem appropriate. Rebuttal should be brief, and it should address the points raised in the defense closing and not be a repetition of the original state's closing.
well, clearly rebuttal needs to be rebuttal. We understand that, and it will be, I'm sure, I'm not going to be doing the rebuttal argument, Ms. Nodolph will be, but it will be rebuttal. And we understand the limits of that, and it has to respond to arguments made by the defense, and it will do that.
All right. Okay, so just in the event that there are any issues, again, that we need, it seems like every morning there's something. So I'm thinking I'd like to have counsel here about 8:15. So if there is anything, that we can get that addressed, so the jury, we can bring them in at 8:30. And then I plan to do a break, and I'll do those instructions, and then the state's closing, and then we'll take a 15-minute recess. And, but then, is that going to put you up against the lunch hour for the defense?
Well, first of all, before we get to that, Mr. Nelson had filed a motion in limine as to the prosecutor's closing arguments, that would be document number 122. I don't know whether or not the court has had an opportunity.
It's been ruled on, counsel. The court entered rulings as it relates to it, and I'm
not
at
aware of-
4:25 on the 14th day of trial, we're going to bring up a motion to eliminate that's been argued before, and, I know what my ethical obligations are as far as closing argument. I am not going to stray over a line into something that I'm not supposed to do. I've been doing this for 30 years. I know what I'm supposed to do, I know what I'm not supposed to do, and I'm not going to stray over any lines. If counsel has an objection to something I make, as far as an argument, counsel can certainly make it.
Well, at least I've never been in court when this matter has been entertained by the court. Perhaps it occurred, there was a day that I was not in court recently, I think it was September 27th.
Well, I think we talked about this a long time ago, but.
That could be, I just wasn't here. But, there were several points that were raised, I think, starting on page 5. I don't know how the court ruled on this. If the court has ruled on it,
Well, the
then,
ruling is that there be no improper closing arguments.
that what?
No improper closing arguments, so.
Okay, I understand. So the court is not going to address point by point the things raised. And I don't think this is the 11th hour. It was filed on February 1st, 2019.
Well, and I think the state is well aware, again, they're experienced, Mr. Dufour understands. And I'm not gonna go any further than that. If there's anything, again, counsel can object if they believe it's improper argument. And court will review the motion and, to be, I guess, aware of potential improper arguments. Okay?
All right, so as I understand this, you want us here at 8:15, though I'm not sure why, by the way, I did review the verdict forms and they're acceptable to the defense.
Okay.
I don't think, so I'm not really sure why we need to be here at 8:15, but if you want us to be, we will be, but.
Well, I just want to make sure that, again, that if there is something, I don't want to, have people come into court at 8:30 and then argue for half an hour.
Sure, of course.
So-
All right, so we're thinking, reading the instructions, my guess is about 30 minutes at the most for that.
Probably.
I don't know how, I've seen some courts really read them fast, but I was thinking about 30 minutes, probably at a reasonable rate of speech. Okay, so the state will argue approximately from 9 to 11? That's roughly what you're saying? About 2 hours?
That would be my guess. Again, I can't tell you for sure. It may be shorter than that. I don't think it would be longer than that.
Well, I don't think that Mr. Nelson wants to have his closing argument interrupted and have a bunch of the jurors be hungry. So my guess is, if the state finishes by 10:30, or so, roughly, that we should just proceed to the defense argument, but if it really goes past 11, I would say we should do a very early lunch break, and probably, I don't know, I haven't asked him his position on it, but, I was hoping that closings would be shorter, but,
I don't
one thing
have-
we don't want to do, I think, is have a break. I don't know if you want to give the jurors a snack perhaps after the state's closing, so that people aren't hungry. We don't want people to be hungry and thinking about lunch instead of thinking about arguments of defense counsel, so.
Well, I'm confident this group is going to be focused. They've been a very attentive group.
I don't disagree with that. I'm just wondering about this,
And-
because if he goes until 11, then the defense argument could potentially go to 1 o'clock. It could be a pretty late lunch. But
Okay.
what we don't want is take a break in the middle of it.
All right, well, I think they get snacks.
Yeah, we can order lunch depending on,
Okay.
yeah.
I agree. I don't think it's fair to the defense if the jury is thinking about lunch instead, or extremely hungry and, can't focus because of hunger in the middle of defense argument. That's why I brought this up, is so that we could hash this out and decide this now rather than thinking about it tomorrow, when, I'm getting done with my closing and we're trying to think, well, what are we going to do now? So
Right.
I don't have a problem with the idea of, giving them maybe a little bit longer break, have a snack, then do defense closing, then give them lunch, and then we can do rebuttal. That might be a way of handling it.
Sounds good.
Okay, that sounds fine. Then I don't think we really have anything else. I mean, we have to talk about deliberation hours, but that could hold until tomorrow. I think it looks like you're not going to sequester the jury now. And
I'm leaning towards not sequestering
okay,
the jury, but
probably not going to. I should revise that. Okay.
all right. Very good. Okay, then, we'll be adjourned until tomorrow morning. Again, I guess ask council to be in the building at 8:15. If
We will.
there are any issues, let the clerk know. Otherwise, but I really want to try and get the jury in at 8:30 so we get going. Okay, then Bond will continue. That's all. Thank you. Thank you. Okay, thank you. Please be seated. Good morning, ladies and gentlemen. Thank you again very much for coming back and for your service. Very good to see you this morning, and you've all been on time, you've all been attentive, and we certainly appreciate that. Okay, members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions, regardless of any opinion you may have about what the law is or ought to be. You must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during the trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The information in this case charges that Ezra J. McCandless, on or about March 22, 2018, in the town of Springbrook, Dunn County, Wisconsin, did cause the death of Alexander Woodworth with intent to kill that person, contrary to Section 940.01, Subsection 1, Subsection A of the Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The defendant in this case is charged with first-degree intentional homicide, and you must first consider whether the defendant is guilty of that offense. If you are not satisfied that the defendant is guilty of first-degree intentional homicide, you must consider whether or not the defendant is guilty of second-degree intentional homicide, or first-degree reckless homicide, or second-degree reckless homicide, which are less serious degrees of criminal homicide. It is the defense theory of the case that Ezra McCandless stabbed Alexander Woodworth in self-defense. The crimes referred to as first and second-degree intentional homicide and first and second-degree reckless homicide are different degrees of homicide. Homicide is the taking of the life of another human being. The degree of homicide, defined by law, depends on the facts and circumstances of each particular case. While the law separates homicides into different types and degrees, there are certain elements which are common to each crime. Both intentional and reckless homicide require that the defendant caused the death of the victim. First and second degree intentional homicide require the state to prove the additional fact that the defendant acted with the intent to kill. First and second degree reckless homicide require that the defendant acted recklessly. First-degree reckless homicide requires proof of one additional element, that the circumstances of the defendant's conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, the defendant has committed. Self-defense is an issue in this case. The Criminal Code of Wisconsin provides that a person is privileged to intentionally use force against another for the purpose of preventing or terminating what she reasonably believes to be an unlawful interference with her person by the other person. However, she may intentionally use only such force as she reasonably believes is necessary to prevent or terminate the interference. She may not intentionally use force which is intended or likely to cause death unless she reasonably believes that such force is necessary to prevent imminent death or great bodily harm to herself. As applied to this case, the effect of the law of self-defense is: the defendant is not guilty of any homicide offense if the defendant reasonably believed that she was preventing or terminating an unlawful interference with her person and reasonably believed the force used was necessary to prevent imminent death or great bodily harm to herself. A belief may be reasonable even though mistaken. The reasonableness of Ezra McCandless's belief must be determined from the standpoint of her at the time of her acts and not from the viewpoint of the jury now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of Ezra McCandless under the circumstances existing at the time of the alleged offense. The defendant is guilty of second-degree intentional homicide if the defendant caused the death of Alexander Woodworth with the intent to kill and actually believed the force used was necessary to prevent imminent death or great bodily harm to herself, but the belief or the amount of force used was unreasonable. The defendant is guilty of first-degree intentional homicide if the defendant caused the death of Alexander Woodworth with the intent to kill and did not actually believe the force used was necessary to prevent imminent death or great bodily harm to herself. The defendant is guilty of first-degree reckless homicide if the defendant caused the death of Alexander Woodworth by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life and she was not acting lawfully in self-defense. The defendant is guilty of second-degree reckless homicide if the defendant caused the death of Alexander Woodworth by criminally reckless conduct and she was not acting in self-defense. Because the law provides that it is the state's burden to prove all the facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether the defendant acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilty for first or second-degree intentional homicide or for first or second-degree reckless homicide. The state must prove beyond a reasonable doubt that Ezra McCandless was not acting in self-defense. If the state does not satisfy you that those facts are established by the evidence, you will be instructed to find the defendant not guilty. The facts necessary to constitute each crime will now be defined for you in greater detail. First-degree intentional homicide, as defined in Section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. In this case, first-degree intentional homicide also requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to herself. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfy you beyond a reasonable doubt that the following three elements were present. 1, the defendant caused the death of Alexander Woodworth. Cause means that the defendant's act was a substantial factor in producing the death. 2, the defendant acted with the intent to kill Alexander Woodworth. 3, the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to herself. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that her conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent existed for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not, by itself, establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The third element of first-degree intentional homicide requires that the defendant did not actually believe the force used was necessary to prevent imminent death or great bodily harm to herself. This requires the state to prove either, 1, that the defendant did not actually believe she was in imminent danger of death or great bodily harm, or that the defendant did not actually believe the force used was necessary to prevent imminent danger of death or great bodily harm to herself. When first-degree intentional homicide is considered, the reasonableness of the defendant's belief is not an issue. You are to be concerned only with what the defendant actually believed. Whether these beliefs are reasonable is important only if you later consider whether the defendant is guilty of second-degree intentional homicide. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Alexander Woodworth with the intent to kill, and that the defendant did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to herself, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must not find the defendant guilty of first-degree intentional homicide, and you must consider whether the defendant is guilty of second-degree intentional homicide, as defined in Section 940.05 of the Criminal Code of Wisconsin, which is a lesser-included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree intentional homicide before considering the offense of second-degree intentional homicide. However, if after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree intentional homicide, you should consider whether the defendant is guilty of second-degree intentional homicide. Before you may find the defendant guilty of second-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. 1, the defendant caused the death of Alexander Woodworth. 2, the defendant acted with the intent to kill Alexander Woodworth. 3, the defendant did not reasonably believe that she was preventing or terminating an unlawful interference with her person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to herself. You have already been instructed on the definitions of causing death and with intent to kill. The same definitions apply to your consideration of second-degree intentional homicide. The third element of second-degree intentional homicide requires that the defendant did not reasonably believe that she was preventing or terminating an unlawful interference with her person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to herself. This requires that the state prove any one of the following: that a reasonable person in the circumstances of the defendant would not have believed that she was preventing or terminating an unlawful interference with her person. 2, that a reasonable person in the circumstances of the defendant would not have believed she was in danger of imminent death or great bodily harm. 3, that a reasonable person in the circumstances of the defendant would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to herself. The reasonableness of the defendant's belief must be determined from the standpoint of the defendant at the time of her acts and not from the viewpoint of the jury now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of the defendant under the circumstances existing at the time of the alleged offense. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Alexander Woodworth with the intent to kill and did not reasonably believe that she was preventing or terminating an unlawful interference with her person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to herself, you should find the defendant guilty of second-degree intentional homicide. If you are not so satisfied, you must not find the defendant guilty of second-degree intentional homicide, and you should consider whether the defendant is guilty of first-degree reckless homicide in violation of Section 940.02 of the Wisconsin, or the Criminal Code of Wisconsin, which is also a lesser included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if, after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, you should consider whether the defendant is guilty of first-degree reckless homicide. First-degree reckless homicide, as defined in Section 940.02, subsection 1 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of first-degree reckless homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following four elements were present. 1, the defendant caused the death of Alexander Woodworth. Cause means the defendant's act was a substantial factor in producing the death. 2, the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person. The risk of death or great bodily harm was unreasonable and substantial. The defendant was aware that her conduct created the unreasonable and substantial risk of death.
After this part, the closings happen.
Or great bodily harm. You should consider the evidence relating to self-defense in deciding whether the defendant's conduct created an unreasonable risk to another. If the defendant was acting lawfully in self-defense, her conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all the evidence in this case that the risk was unreasonable. 3, Ezra McCandless was not acting lawfully in self-defense. Those are the 3 elements. Self-defense is an issue in this case. The law of self-defense allows Ezra McCandless to threaten or intentionally use force against another only if she believed that there was an actual or imminent unlawful interference with her person. She believed that the amount of force she used or threatened to use was necessary to prevent or terminate the interference, and her beliefs were reasonable. Therefore, Ezra McCandless may intentionally use force which is intended or likely to cause death or great bodily harm only if she reasonably believed such force was necessary to prevent imminent death or great bodily harm to herself. The circumstances of the defendant's conduct showed utter disregard for human life as the 4th element. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. You should consider the evidence relating to self-defense in deciding whether the circumstances of the defendant's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the circumstances of the defendant's conduct showed utter disregard for human life. Consider also the defendant's conduct after the conduct to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time the death occurred. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Alexander Woodworth by criminally reckless conduct, and that the circumstances of the conduct showed utter disregard for human life, and that Ezra McCandless did not act lawfully in defense of herself, you should find the defendant guilty of first-degree reckless homicide. If you are not so satisfied, you must not find the defendant guilty of first-degree reckless homicide, and you should consider whether the defendant is guilty of second-degree reckless homicide in violation of Section 940.06 of the Criminal Code of Wisconsin, which is a lesser included offense of first-degree reckless homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree reckless homicide before considering the offense of second-degree reckless homicide. However, if, after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree reckless homicide, you should consider whether the defendant is guilty of second-degree reckless homicide. Second-degree reckless homicide, as defined in Section 940.06 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being. The difference between first and second degree reckless homicide is that the first degree offense requires proof of one additional element, that the circumstances of the defendant's conduct showed utter disregard for human life. If you are satisfied beyond a reasonable doubt that all the elements of first-degree reckless homicide were present, except the element requiring that the circumstances of the conduct showed utter disregard for human life, you should find the defendant guilty of second-degree reckless homicide. In other words,
Ladies and gentlemen of the jury, with the defendant, there's always just one more lie. Just one more lie. And that's, ladies and gentlemen, really what this case is about.
Judge,
Is the
objection,
defendant
reapproach.
telling...
overruled. Please be seated. You can continue. Your objection is preserved.
This case is about whether the defendant is telling the truth, whether his story is the truth or not. Because if the defendant's story is not true, the defendant is guilty. Guilty, first-degree intentional homicide of Alex Woodworth on March 22nd. I'd like to start closing argument with a discussion of what's not at issue in a case. And ladies and gentlemen, there's no question in this case, there's no doubt at all, that the defendant caused Alex's death. The defendant killed Alex Woodworth on March 22nd, 2018, when she repeatedly stabbed him. And there's no real question that that action was intentional, ladies and gentlemen, that she intended to cause Alex Woodworth's death. Now you may say, wait a minute, she testified, she said, I didn't intend to, I didn't want to kill him, I didn't plan to kill him, I didn't intend to kill him. But that's not the issue. Because as the judge told you just a little while ago, intent is not just what the person in their mind plans. That's one part of intent. All right, that's one way you can prove intent. If they say, yes, I wanted to kill that person, that proves intent. But intent is also proved if we can show, and if the evidence shows, that a reasonable person at that point in time knows that their actions are practically certain to cause the death
Judge,
of
that's
the
not the
individual.
law. Objection, that is not the law. Page 5 says the law. That's not the law. Objection, can we approach?
Your Honor, the law is if the person knows that it's practically certain to cause death, that is intent.
That's not what he said. Can we approach, Judge? He misstated the law.
Your Honor, this is argument.
All right, this is argument. It's overruled. Your objection is preserved. You make your record after the argument.
And when the defendant stabbed Alex 16 times, she knew her actions were practically certain to cause Alex Woodworth's death. And when she left Alex Woodworth there, taking his phone so that he has no way of getting help, she knew her actions were practically certain to cause Alex Woodworth's death. It's not about whether the defendant killed Alex Woodworth, and it's not about whether the defendant intended to. It's whether you believe the defendant's story her most recent story that she was acting, she was afraid. That's what this case is about. If you don't believe that story, then the state has proven beyond a reasonable doubt that the defendant intentionally killed Alex and that she did not act in self-defense. And she is guilty of first-degree intentional homicide. In assessing, in deciding whether or not her story is true, you've got to look at her evolving story. Because her story evolves as time goes on. What's her first story? What's her first story about what happened? It's what she tells Officer Reeves and the medical staff at Mayo. This happened at Owen Park in Eau Claire. I don't know how I got to Menominee. I don't know how I got to Dunn County. This happened at Owen Park. And that's important, ladies and gentlemen. It's important for a variety of reasons. But not the least of those reasons is it's important because when you use your common sense, you know why she's lying about it happening at Owen Park. And you know why someone who's being questioned by police and others about what happened would lie about what happened. Your common sense tells you that. And the judge just instructed you. It's one of, I think, it's a very short instruction, but it's one of the most important ones. And that's instruction number 195 that says, essentially, when you're deliberating, you can consider your experiences in the ordinary affairs of life. And what that, ladies and gentlemen, really is, it's the instruction that says, you walk through this door over here, you go back to the jury room, ladies and gentlemen, you don't check your common sense at that door. You use your common sense. And what does your common sense tell you about why someone's going to lie to a law enforcement officer? Your common sense tells you it's to avoid getting charged with a crime. It's to avoid getting in trouble. Why is the defendant lying and saying it happened at Owen Park? She doesn't want them to go back to the scene. She doesn't want law enforcement to go back by Don Sippel's house and find that muddy road where Alex Woodworth lies dead. She doesn't want them to go back there because she needs to be able to get back there and clean it up. Get rid of Alex's body before law enforcement finds it. That's why she's lying about it. That's why she's misdirecting them over to Owen Park. And ladies and gentlemen, I know you just heard a couple days ago from Dr. Hopper, and he talked about matters that are encoded and problems when stress events. But it's important when we're thinking about this and thinking about this lie here, that we think about where that lie and what events that lie is about. Remember all that stuff? He showed you that chart, and it's got the line where the stress starts. And that's where memory starts to work a little bit different. It's when that stress starts. And before that, memory just encodes like it normally would, and your memories are going to be like they normally are. And that stress event, assuming that that stress event even happened, or assuming that that stress event, the stress event could be, as Dr. Hopper said, being involved in a murder, that stress has not happened yet when she's pulling into that muddy driveway. So there isn't any issue with her memory at that point in time, and yet she's saying it happened at Owen Park, to direct them away so she can go back later and clean it up. Her story evolves from there to, I don't remember anything. I don't remember anything. Even on March 23rd and March 24th, when she's interviewed by Detective Prock, when from her own story that she told you on the stand, her memory had come back, she's still saying, I don't remember anything. She doesn't want Detective Prock or any other law enforcement officer to go back to that scene. She wants them to stay focused on Owen Park. And finally, when she's confronted with the facts, when she's confronted with information, Detective Prock was talking to her in a calm voice, talking to her in a friendly manner. He confronts her and says, look, we found your car. We walked down that muddy road and found your car. What do you think we found? And now, she's got to go to Plan B. Plan A is, Alex attacked her, he took off with my car, don't know where anything is, don't know where he's at, don't know anything about it. She's got to go to Plan B and say he was attacking her there, and then she stabbed him. And now, all of a sudden, all those facts that, again, using Dr. Hopper's description, are the facts that are super encoded, the critical, the central details of what happened come out. But the story has to evolve even more, and it evolves into the story she told here, because the story she told then is not the same story she told. We need to take a look at and consider what the defendant does when she leaves Alex's apartment. Remember, testimony from everybody is that they were going to leave Alex's and they were going to go to someplace public. They were going to go to someplace where they could talk, be around other people, so there wouldn't be any issues. Well, what do we know about what the defendant actually did as she drove away? We know, ladies and gentlemen, that she's right here, Alex's apartment. She knows, and there's Half Moon Park right here. There's Phoenix Park right here, a couple blocks away. There's Owen Park that she talked about right here, real close to Lacy's, where she wants to be. Does she go to any of those public places? Does she go anywhere near them? No. She takes and drives straight out of town on Cameron to Madison. It all just changes names and drives straight out of town. Away from the public. Away from a location where she can be with other people as she talks to Alex. Because her purpose is not to talk to Alex, her purpose is to confront Alex. And we're going to talk about that in a while when we talk about the defendant's motive. Her purpose is to confront and get Alex to change his mind about the relationship and admit, as she put it, that the relationship was a mistake. She needs to confront him, and she needs to confront him someplace away from people. What about, and you may have forgotten about, Dan Davidson, who testified fairly early in the trial, but what does he tell you about what he sees? What he sees is important for two reasons. It's important because it contradicts the defendant's story, and it also helps to fill in the timeline of what happens. Because Dan Davidson, bus driver at the time for Beauclair, person trained to make observations of other drivers so that he can make sure what they're doing, to watch them, to look at their eyes. Tells you he sees a car stopped in the road, pointed at this road. on Louis Bjork's property. And he sees two people in there, and he sees a woman driving. Defendant confirms, yeah, I remember somebody driving around me, so the defendant confirms that in fact this happens. And Dan Davidson tells you clearly it's a woman, not Alex, but the defendant, obviously driving that car. Now, I know defense is going to say something like, well, how does he know? And, you know, he doesn't write that clearly in his statement and so forth. But what reason does Dan have to come here and lie to you? That's what he remembers. He doesn't. He has no interest in this case. In fact, he only became involved because he saw law enforcement searching along the ditches there, and he just decided to stop and, hey, there was this kind of weird thing that happened a couple days ago. Just thought I'd tell you about it. Doesn't have an interest in it. Clearly, the defendant was driving. So what else is interesting about that, and what else is strange about that, is remember the defendant's story on the stand. Well, I thought this would be a nice place to go to talk. A nice place to go to talk? Certainly not a public place. Certainly not a place that looks like a good place to talk where other people are going to know. It's private property. It's a deserted area. It's a middle of a farm field. Is that the place you go to discuss continuing to be friends with Alex? Talk more about your relationship with Alex? Place to talk about what's happening at Lacy's? Or is it a place to go and confront Alex? A place where nobody else is going to see what's happening. That's, ladies and gentlemen, what this looks like. A lot more than a place to talk about your relationship. So what happens after they start pulling into there? The car gets stuck the first time. Now, ladies and gentlemen, realistically, and again, this is before, as Dr. Hopper tells you, that the amygdala kicks in and you start reacting based upon instinct, habit, those types of things. This is when you still have rational thought. And the defendant still has her rational thought about her. And what does she decide to do? The rational thought is you're on this muddy road and you're starting to get stuck. If you get stuck, rational thought says, I'm going to back out of here and get out of here before I get stuck so that I can't get out. Stuck the first time. Now, ladies and gentlemen, realistically, and again, this is before, as Dr. Hopper tells you, that the amygdala kicks in and you start reacting based upon instinct, habit, those types of things. This is when you still have rational thought. And the defendant still has her rational thought about her. And what does she decide to do? The rational thought is you're on this muddy road and you're starting to get stuck. If you get stuck, rational thought says, I'm going to back out of here and get out of here before I get stuck so that I can't get out. That's what your rational thought tells you if you're just trying to find a convenient place to stop and talk. Despite the fact that there were probably hundreds of places to conveniently stop and talk where there are other people around. But if you want to get to the location where you, over that hill that you heard about, to where you can't be seen from the road, so you can confront someone and confront them and make them do what you want. You want to keep going. You want to move forward. You want to go over that hill and get away from where everybody else is. And that's what the defendant chooses to do. And once they get stuck, the rational thought is, let's get some help. You know, it's going to have to get out of there sometime, and you're going to have a tow truck someday or sometime. Just because it's going to cost some money, rational thought is we need to get out of here unless we still need to confront it. And he'd do that before anything else happens. Now, as I said at the start, this case turns on whether you believe the defendant's story or not. And I want to talk about why the defendant's story is not believable, why the defendant is not credible. There's 5 areas that I want to cover when I talk about that. I want to talk about the lies that she's admitted that she made. Things that she told you or told others were clearly lies. And not, as Dr. Benson talked about, lies of omission, but rather lies of commission, lies where she intentionally deceived someone knowing what she said was false. I want to talk about lies that are proved from the evidence. In other words, lies that, based on other testimony, other evidence, were clearly things that she said that are lies. I want to talk about inconsistencies in her story. And I'm going to talk about inconsistencies not in these peripheral details about things that happened after a stress event, but rather inconsistencies either before that stress started. In other words, changes she made to her story before the stress event happened, or inconsistencies in central facts, as Dr. Hopper talked about them. Fourth, I want to talk about how the physical evidence, the things that don't matter based on person's memory, don't matter based upon how people think about things, don't matter on whether you believe someone or not, but physical facts, evidence from the scene, evidence that we've uncovered, and how that physical evidence contradicts the defendant's story and says the defendant's story is not true. And finally, I want to talk about the DNA evidence and how the DNA evidence also, which is another form of physical evidence, another form of physical facts, how that evidence also contradicts the defendant's story. So what lies do we know that the defendant told? We know she lied about how Boy got scratched into her arm, right here. This large area of her arm, how that happened. We know she lied about who did that. And we know she intentionally lied about it. We know she intentionally lied about it because she admitted she intentionally lied about it on March 24th. Because on March 24th, when the defendant was interviewed by Ryan Prock, she told him, first in that interview, that Alex did that, and later admitted, again, when confronted by the truth, when confronted by facts that dispute her story, she changed her story and admitted, yes, I lied, I'm the one that did that. Why lie? Why misdirect law enforcement and try and point them over in this direction when you know they should be in this direction? You lie because you're covering up. You're covering up for what you did wrong. She lied about going to Owen Park. She knew, she admitted on the witness stand that she knew she didn't go to Owen Park when she said that. But she lied about it. Misdirected law enforcement. She lied about going to Lacy's first because, and the reason why that's important, it may seem like a small detail, but the reason why it's important is she doesn't want law enforcement to know how important it is to her that she talked to Alex that day. That was the reason why she went against her father's wishes and drove to Eau Claire. That's why she went and found the keys that her father had hidden so she could drive to Eau Claire that day. That's why she went to Eau Claire that day despite not telling Jason the night before in their Instagram messages that she was going to Eau Claire that day, because she needed to confront Alex. I'm going to talk more about that in a little while. But she didn't want law enforcement to know how important that was, so she said, I went to Lacy's first. And changes that story when she's confronted with the facts, when she sees this evidence that shows she's there first. She's at Alex's first. And then her story changes. And she lied when she told Ryan Kroc multiple times on March 23rd and March 24th that she can't remember, until she's finally confronted with what law enforcement knows. And at that point in time, admits, all right, you got me, but this is what happened. I also want to spend a minute talking about her evolving story or changing story on where she was when she scratched a boy into her arm. Because in the course of just a few minutes of her interview on March 24th, her story changes on that. And her story changes because initially she tells Ryan Kroc that she's sitting in the car when she does that. And just a few minutes later, 2 pages later in the transcript of that interview, she says, oh, I did it on the road because I did it right after I fell down and the phone broke. So I was on the road when I scratched a boy in my arm. And her story changed yet again, moved again, when she got up on the stand. And her story then became, I did it when I was by the back of the car. And that's another example of her story having to evolve and change. Because by then she knew about the DNA evidence. She knew what Kevin Scott had found with DNA. And she knew that Kevin Scott had found her blood, her DNA, on the trunk of the car. So now her story has to evolve and change to show why her blood is going to be on the trunk of the car. So now it changes to, I scratch a boy in my arm when I'm by the trunk. It changes, it evolves. She can't keep her story straight. Every time she's caught in a lie, her story changes. Evelyn Hart, caught in a lie, she's not there. I can't remember. Caught in a lie that we found your car, her story changes. Caught in a lie, story isn't that great as far as self-defense when all Alex is doing is, making some really superficial scratches on her and wanting to look at her. So her story changes. He was trying to sexually assault me. As she's confronted with facts, she's confronted with the truth, her story evolves and her story changes. That's not someone who's telling the truth. That's someone who's trying just one more lie. Just one more lie to get out of being forced to take responsibility for the murder, the cold-blooded killing of Alex Woodworth on March 22nd. We also have lies that are shown by the evidence in this case, ladies and gentlemen. She told you, and her story is that this knife, right here, this EMT knife that was used to murder Alex Woodworth, that this knife was given to her by Jolee Carlin, her father. That's her story. Jolee, when he's talked to by law enforcement, including Investigator Kowalczyk, says, I didn't give her a knife. And specifically this EMT knife, he says, I bought 2 of these. I just bought 2 of these from Amazon. And he finds this one, the exact match to that knife. Finds this one in his living room where it was supposed to be and says, yeah, the other one should be in my junk basket in the kitchen or out in the truck. And he goes to look for those. He goes to look for it in those locations and he can't find it. He can't find it because this knife right here is lying in the ditch just before Sippel's daughter's driveway, the defendant put it. And if he had actually given this knife to the defendant, why is he looking for it? Because he didn't. She just had taken it. She took it to use it to confront Alex if she had to. And she lied about Max Martinson and the painting that she was giving Max. Remember, she told Detective Prock she gave Max a painting that she had painted for him. That may seem like a minor thing, it's not a big deal, but again, it's part of her attempt to make it look like it's not a big deal that I needed to confront Alex. This is really more what I'm doing. I painted this for Max, and so I needed to take it to him. What we actually know about that painting, though, is that's a painting that's also acting as part of the barrier in her relationship with Jason Mengel, because it's the painting that was hanging above the bed, Jason Mengel's bed, where she had sex with John Hanson. And it's part of the barrier in that relationship that she wants so much, that ancient love that she describes. And so she has to deflect attention away from how important the painting is, and she has to deflect attention away from how important it is for her to meet Alex that day. There's more lies from the evidence. Another one, minor one again, but another one that shows the defendant can't keep her story straight because she doesn't tell the truth. If she said, I was talking to Jason, I was sitting in my car and talking to Jason when the police arrived. Well, you all saw the video from Officer O'Neill. You all saw that video, and on that video, Officer O'Neill meets with Jason over at the school, over at that Montessori school across the road when he first gets there. And then he then pulls over to Alex's apartment. The defendant's not talking to Jason Mengel when Officer O'Neill pulls up because Jason Mengel is across the street. Her story also changes depending on who her audience is.
I apologize, could you take that down? I can't see the slides. Is that needed still?
Sure.
Thank you. Sorry about that. Thank you.
Her story changes depending on who her audience is. Her story changes, her version of the events changes depending on who her audience is. When she talks about moving out of Jason's apartment, when she talks to Jason, she talks to some other people, it's because of the situation with John Hanson. She just can't take that. She can't be there because of that. But you saw that text exchange between Jenna Van de Zand and the defendant. She tells Jenna, I'm moving out because of Jason, because I can't take it with him anymore. She tells Jason in that Instagram messaging, I'm going to see Alex and I'm going to tell him off one more time. You know, if he doesn't, if he gives me that look again, I'm going to punch him. I'm afraid I'm going to punch him. You know, that's why she's seeing Alex, according to her communications with Jason. But her story now is, oh wait, no, I was going to see Jason to fix our relationship, to make us still friends. And to talk to him about what's happening at Lacy's. Her story changes depending on who her audience is. And her story changes about the heating pad. She tells Jason, I want to return that because it makes me sad. But her statement to Detective Prock is, I returned it because I didn't need it anymore. On March 23rd, she repeatedly lies to Detective Prock when she says she has no idea where Alex's phone is. She repeatedly lies to him over a number of things. Again, where Alex's phone is a central detail that was clearly encoded because it's something she remembers with great detail now. And again, we can't know what the central details are, but we can pretty much infer them by the things that she can describe with vivid detail. And she describes with vivid detail taking the phone, walking with the phone, falling down, and the phone breaking. This is her story now. So clearly that's something she remembers, something that's a central detail. But yet on March 23rd, she tells Detective Prock, I don't know where his phone is. She doesn't want to send them back to that scene. She does not want them to be back where Alex's body is until she can clean up and be able to follow through on her plan A, which is Alex attacked me at Owen Park. He must have dumped me in that area, and who knows where he is with my car now. She lies when she says she doesn't know where Alex is. She clearly knows where Alex is. She absolutely does. That is a central detail without any question. She knows where he is, and yet she lies because, again, she doesn't want to send law enforcement back there. She wants to keep to plan A. And finally, she lies, a small detail, but she lies when she says she urinated herself. She wants to make herself look like she was really panicked. So panicked she urinated herself. Yet Joe Wayne and Jennifer Morris, who examined the defendant closely, said she had not urinated herself. She wants to make it look that so bad that she had to urinate herself. It didn't happen. So let's take a look now. Let's consider the physical facts in this case. Let's consider what those physical facts tell us, and let's take a look and see if those physical facts support or discredit the defendant's story. Do those physical facts tell us that she's telling the truth, or do those physical facts tell her that it's just one more lie? Let's start with Alex's cell phone. Alex's cell phone is found there, and her story is that she fell while she was walking, and the phone broke, and that's where it's going to be. Well, physical facts tell us that the front of the phone and the battery, which is out of it, are down here. Right here. Much nearer the driveway. And the physical facts tell us the back of the phone is right here, almost to the location of the driveway. Physical facts show she's not telling the truth about what happened to the phone. Didn't break when she fell down. She took it apart, left part there, and left part in a separate location. A defense may say, well, wait a minute. We know there was water flowing there. There's water flowing along here. But the water is flowing in this direction here. From Don Sippel's down towards Louis Bjork's property. And what does your common sense tell you again about this? If water's going to move part of that phone, is it going to move this part that's heavy and going to sink? Or is it going to move this part that maybe is a little lighter and may float along? It's going to make the back, it's going to make the back move, not the heavier part. Physical facts tell us her story is not true. Physical facts about this injury to Alex right here in the side of his head, on the right side of Alex's head. That physical fact tells us the defendant is lying, and was lying when she got on the witness stand and told her story. And why, ladies and gentlemen? It's important to remember the details. And unfortunately for the defendant, she doesn't remember the details. Or at least she doesn't get her story to fit the details. Because she told you clearly, Alex is facing her. He's within inches of her. And the knife is in her right hand. She's holding this knife here in her right hand. Alex is inches away from her while she holds this knife in her right hand, and she stabs him with enough force to go through the temporal bone of Alex's head. And both Dr. Mills and Dr. Thomas told you that takes a lot of force. And ladies and gentlemen, if Alex is facing her, Alex's right side is here, her right side is here. How does she come around and stab him with enough force to go through his temporal bone? No, ladies and gentlemen, the physical facts tell you that this injury right here happened while Alex is facing away from her. And ladies and gentlemen, that does not support self-defense. That supports an unprovoked attack on Alex Woodworth. That's what the physical facts tell us. Not somebody's memory, not somebody under stress, not somebody that has PTSD, not somebody that has anything else. Those are physical facts. Those are things that can't be changed. And that right there tells you the defendant is lying. Defendant's story is that except for one stab in the left side on Alex, every other stab took place while she's in the car. That's her story. That includes the stab to the head that we just talked about. That includes the slices along Alex's right side of his neck, slices that were so deep that they cut through the external and the internal jugular vein leading, as all of the medical doctors agreed who testified about it, said it was going to lead to a lot of bleeding. That includes the cut to Alex's groin that involved a lot of bleeding. I mean, you saw, not only did you hear from the doctors, you saw Alex's sweater, you saw his pants, you saw how much bleeding that is. So Alex is supposedly either in the car or right near the car when that happens. When that slice occurred and all that bleeding, again, it's not spurting blood, but it's heavy bleeding. What do the physical facts tell us about that story, that Alex is in the car when that happens? Well, this is the interior of the car. Now we see a fair amount of blood in here, but what we see is transferred blood that's smeared off of Alex when he sits there after he's stabbed. We do not see any pooling of blood here on the floor, where at that time, according to her story, there isn't going to be anything. We don't see any pooling of blood right outside of the car, and we'll see that in just a moment. No, we see a lot of smears of blood. We do not see that large volume of pooled blood that you're going to see if that slice across the neck occurred there. But what do we see outside? Outside we see pools of blood here. You see pools of blood here. See, it's not on this picture, but there's another pool of blood you saw up there. That tells you where Alex is when his neck is sliced, when his head is stabbed, when his groin is stabbed, where those pools of blood are. There aren't any pools of blood right there. Ladies and gentlemen, that tells you Alex was not stabbed in that car. Those physical facts, those are not facts that are dependent on somebody's memory. Those are not facts that are dependent or that could be not encoded because of stress. Those are not facts that have anything to do with whether somebody has PTSD or not. Those are physical facts, and they contradict the defendant's story. I also heard about the defendant's license. This is another physical fact. Remember? And I asked her, I said, all right, and this is a direct quote out of the transcript of the defendant's story that she told on the witness stand just a few days ago. All right, you told Officer O'Neill you couldn't find your driver's license, correct? Her answer was, I think I was having trouble shuffling around. The middle console was full of lots of paper and stuff. She couldn't find her license in there. Well, what do the physical facts tell us about this one? Physical facts show us this is her license here, all right? That's her license on the driver's seat. And what do the physical facts tell us about the center console? She can't find this license in here, in this spot there. That makes no sense. She didn't want to find her license. She didn't want to get her license out because she didn't want to open that center console because she knew this knife was in that center console. She knew this was there, and she didn't want the police to see that knife that were there, because that might raise some flags with them. That might raise some concerns that maybe everything isn't all right. That's why she doesn't get her license out. She doesn't want anybody to see that knife. And what do the physical facts about the defendant's injuries tell us? Physical facts about the injuries tell us exactly what Dr. Tillotson told you. We're going to talk about why Dr. Tillotson is credible in a little while. The physical facts about her injuries tell you that those injuries were not inflicted by Alex in an attack on her. even just looking at them and understanding them yourself, it's clear. I mean, this, ladies and gentlemen, comes right from the exhibit, I think it's exhibit 195, and you saw this was part of the page that was put up on the screen, and this is what the chapter talks about as parallel, superficial, incised wounds. They're not talking about geometrically parallel lines. They're talking about lines that are going in the same direction, all right, as opposed to, lines that are going all over the place. And you can just imagine if you're kicking and moving and your leg is going all over the place, it's going to be impossible to cut a straight line. Lines are going to be zigzag, they're going to be starting, stopping, they're going to be all over the place. But this is talking about multiple parallel, superficial, incised wounds. And what do we see on the defendant? Not only do we see that, but we start with this one right here, which the defendant admits she did to herself. And take a look at that in comparison to these on her hand. Very similar depth, very similar looking wounds. Compare them to these right here on her leg. Again, very similar looking, multiple lines. Again, when you consider what the picture in the textbook itself shows, multiple parallel, superficial, incised wounds. Multiple, superficial, incised wounds. And you look at these, again, multiple, superficial, admittedly not parallel, but again, straight lines. Not something that makes sense with somebody who's moving and kicking and moving all over the place, which is the defendant's original story. And I'm not going to, for various reasons, show another one of the pictures which shows the even more superficial wounds in the most sensitive area. But she needs those there because she knows that Plan B has to include claiming that Alex was attempting to sexually assault her, so she's got to put some wounds there. She's got to put some wounds in that sensitive area. But what, ladies and gentlemen, you remember, she said her story to Detective Prock is, I cut my hand when I grabbed the knife. I grabbed it with my hand on the blade, and it hurt a lot. This is what Dr. Tillotson says it looks like when you grab the blade, and it hurts a lot to get it away from your assailant. And so the defendant's story has to change again. All right? She gets confronted with this when Dr. Tillotson testifies at a hearing before trial. She knows now that story about grabbing the knife by the blade to pull it away from Alex doesn't work anymore. So her story has to change. Her story changes to, I batted at the knife, and then I kneed him in the groin, and that's how I got the knife away from him. Her story changes when she's confronted by the facts. And her story on getting the knife then from there doesn't make much sense because according to her story, her glasses are off, she can't see more than a couple inches in front of her, and yet she's able to find the knife, pick it up, and use it without her glasses. Her story changes. Her story makes no sense. She's not telling the truth. And the physical facts, her own injuries tell you that. And her own injuries tell you how likely is it that Alex could have cut her exactly the same depth, exactly the same way as she admittedly cut herself, when Alex is supposedly doing that through her clothing. Ask yourself, does that make any sense? When we talk about the defendant's clothes, and what they tell us about her story. We start with the blood that's on her blue flannel shirt. I'm not going to take it out now, I'm going to take it out in a little bit. There's blood on her blue flannel shirt. And whose blood is on her blue flannel shirt? The defendant's blood. That's whose blood is on that shirt. And ladies and gentlemen, you heard the testimony, you saw the gold sweater. There's no visible blood on the gold sweater. How does the blood get from her skin onto the blue shirt without touching the gold sweater, without leaving a stain on the gold sweater too? We don't have magic blood that goes through that sweater from her skin to the blue shirt. Defendant's story is that she didn't take off any of her clothes, she didn't remove any of her shirts, she didn't take anything off, and she carved the word boy in her arm through her shirt. Now first off, how do you do that and be able to make a readable word on your body that you scratch into it with a knife through clothes without being able to see what you're doing? But more importantly, ladies and gentlemen, here's what she does and where she does it. And look at that in reference. This is the shirt that's closest to her. This is the shirt that is just above his gold sweater or gold yellow tiger shirt. But the one that's closest to her skin on her arm. How do you do this through this hole in that shirt? And if that shirt is pushed up or out of the way, why is this hole there? Hole is there because she creates the scene afterwards. She takes off the shirts, she carves boy in her arm, and then cuts them up to try to fit her story. She just doesn't do a very good job of it. I want to talk a little bit more about her clothes. The defendant's story is that Alex is cutting her through her clothes, cutting her legs. They're going to bleed. We heard that, you know that, and you heard that from the doctors. Those cuts are going to bleed. All right. So you'd expect right next to the cut, where the cut in her leg is, you're going to expect to find some blood. Makes sense. And you know what? We did find blood there. But what doesn't fit the defendant's story is the blood that we find right next to that big cut on her pants leg, right next to where that incision or that incised wound is in her leg, is not her blood. It's Alex's blood. Why is Alex's blood there? When Alex wasn't bleeding when this was supposedly happening. Why isn't it her blood? Her blood is found on this leg, or her hand would be, and her blood is found in a mixture farther away from the cuts in the leg. It's because she cuts those clothes afterwards. And she cuts those clothes after she's killed Alex and Alex's blood has gotten on her. And she cuts them when they're not on her. And then cuts her leg so she can create the scene. She also tells Detective Prock, when he's asking her where she's injured, she makes sure that she says, oh yeah, there's a cut on the pants here. I was injured over here on my left leg too. But there isn't one. Because she's trying to match up all the places that she remember she cut her jeans. She just doesn't have a cut there. And still more on the clothes. And here I want to show you the clothes and show you this. Because we got to take a look. And it's a muddy area where we're at. what do the clothes show us? Start with this yellow t-shirt, Alex Mengel's t-shirt. It shows us mud right here. There's mud on this yellow t-shirt. It shows us there's mud right here on this blue, what was described as spotted, but what she said was a plant shirt. And it shows us there's mud on this blue flannel shirt. But what it doesn't show us, ladies and gentlemen, doesn't show us any mud at all on the gold sweater. None. Ladies and gentlemen, considering that physical fact, the fact that there is no mud on that sweater, and yet there's mud all the way down to the yellow tiger shirt, that tells us that her story that she never took any of those clothes off is not true. Because how does the mud get through the flannel shirt, get through the gold sweater, get through the blue plant or spotted shirt to the yellow shirt? Why does it happen if those shirts don't come off? If she doesn't take off any of her clothes? It gets on there because she has to take them off to carve boy in her arm. It has to get on there because she takes them off so that she can set up that scene. That's why there's no mud on the gold sweater, but there is mud on the blue shirt and the tiger shirt. We need to also talk about Alex's clothes and what they tell us. You saw when Dr. Mills testified how with his clothes, with his sweater, his pants, his underwear, that those all match up. The holes in those clothes all match up perfectly with all of the injuries that Alex suffered. And you saw, and I'm going to show you again, Alex's coat. We're going to talk about that a little bit. Keep the gloves on for a little while because I need to talk about that a couple of times. But Alex's coat, and remember, he's got 2 stab wounds in the back. He's got 3 stab wounds in the side. And what do we see with Alex's coat? You see, yep. We've got, I'll do it from the inside, I think it's a little easier to see on the inside. two cuts in Alex's coat. Got one right here, shoulder area, and we've got one right here, the lower back. That's where we have two cuts in Alex's coat. What do we know about cuts to Alex? What do we know about where he was stabbed? Well, first off, I apologize, not the greatest picture in the world, but this is Alex on Officer Zwiefelhofer's squad video. You can see how the coat covers his side. Goes down, covers his side. It's important because what we know is that Alex has these two injuries labeled. And again, the labeling, the numbering, it's just arbitrary. We're not trying to say this was the 15th and that was the 16th injury he suffered. It's just how Dr. Mills marks them. We've got this cut here, and this stab wound here, and this stab wound here. They correspond to the two holes I showed you just a moment ago in the coat. But we also have these three stab wounds. Sharp force injury number 8, sharp force injury number 9, and sharp force injury number 10. And according to the defendant's story, Alex has his coat on the whole time she's stabbing him. The left side of Alex's coat, you can look all you want, you take all the time you want to look at it. There is not a single hole in Alex's coat on the left side. Not one. Look at it all you want, as much time as you want. You're never going to find a hole on that side. So ask yourself, ladies and gentlemen, if Alex is wearing his coat, if the defendant's story is he is, how did these three stab wounds magically appear in him? They go through his sweater just like they should. But those three injuries took place after Alex had taken his coat off. And the defendant's story is that doesn't happen until after she had stabbed him every time she's going to. Her story doesn't fit the physical facts. Her story is a lie. Just one more lie. So what does the DNA tell us about what happened on March 22nd? DNA doesn't lie. DNA doesn't have problems with memory. DNA doesn't have issues. DNA tells us facts. And it tells us where Alex's blood is, and it tells us where the defendant's blood is. But maybe more importantly, in many respects, it tells us where the defendant's blood is not, where her DNA is not. Because where her DNA is not also tells us that the defendant's story is a lie. So let's start with the inside of the car. This is a photo that shows, and we've added on to it so that you've got an idea of where things are. What the DNA tells us about whose blood is in the car. Remember, the defendant's story is that she is being cut while she sits in the car. She's or not sits, but lays down on the back seat of the car. That the cuts to her leg happen while she's laying down in the back seat of the car. That the cuts to her left hand happen while she's laying down in the back seat of the car. Those are going to bleed. We know that. We've heard that. Common sense tells us that. Whose blood is in the back seat of the car? Alex's. And only Alex's. If the defendant is being cut while she's in the back seat of the car, why is none of her blood? Why is not any of her blood found in there? They sampled a lot of locations in there, on the seat backs, all over. None of it's hers. It's all Alex's. If she was being cut there, why isn't her blood there? What does the blood and the DNA evidence tell us about the outside of the car? It tells us, and we've talked about this, I'm not going to repeat it, that the pools of blood are Alex's. But equally importantly, ladies and gentlemen, it tells us, and it's not shown specifically on here, but this trailer, defendant's blood is on two locations, 6 feet apart. You heard that testimony. Two different spots, 6 feet apart on that trailer, her blood's there. Her story does not explain why her blood's on that trailer. On that trailer because she's trying to set up a scene. Her blood is also, and while you can't see it in this picture, her blood is on the outside of this driver's side rear door. Big drop of her blood is there. It runs down the door. In her story, that door is never closed. How does her blood get on the other side of that door, a drop of it like that, under her story? It doesn't fit her story. It's not explained by her story. It's explained by setting up a scene later on when the door is closed and before she tries to pull Alex out of the car and leaves him in this position. She's cutting herself, she's making up the scene, and that's how her blood gets on the outside. And her blood on the trunk, we already talked about, that's a spot. She had to change her story to fit the facts. And ladies and gentlemen, maybe most importantly, what does the DNA on the knife tell us about whether this knife was used to cut the defendant, as she claims? What the blood evidence and the DNA evidence on this knife tells us is that, yes, there's blood. In fact, Kevin Scott didn't just do a presumptive test, he did a confirmatory test to confirm that there's blood on the blade, there's blood on the handle of this knife. And what does it tell us about whose blood is on the blade of this knife? Who was cut with this knife? Alex Woodward. The DNA evidence does not say that there's any of the defendant's DNA, any of her blood on the blade of this knife. Alex was cutting her with this knife. Where is her blood? Her DNA is on the handle as part of a mixture with Alex, where Alex is the major contributor and she's the minor. And that, ladies and gentlemen, makes sense that she's using this knife to stab Alex repeatedly, which we know is the truth. No blood of the defendant. No DNA of the defendant on the blade of that knife. And what, ladies and gentlemen, do these wounds, these deep wounds to Alex's neck, that severed the jugular vein tell us about the defendant's story? They tell us, ladies and gentlemen, that again, she changed her story to fit the facts, to try and fit the facts. It doesn't work very well, but she tried to. Because her story to Ryan Prock on March 24th is that Alex is on top of her when she slices his neck 3 times. Alex is on top of her. And if that's the case, ladies and gentlemen, when that wound starts bleeding like crazy, like it's going to, that blood is going to fall down right on top of the defendant, onto her shirt. She's got to change her story after the fact because Alex's blood isn't on her shirt. It didn't come down when she sliced across his neck like it would have. So she has to change her story and say, no, he's not on top of me, he's in front of me. Changing her story to try and fit the facts. Because the facts from the DNA do not support her story. She's also got serious inconsistencies. And again, the state totally agrees with Dr. Hopper that, when someone is involved in a stressful situation, a seriously stressful situation, that we agree, the science is clear that, they will concentrate on central facts. Absolutely agree that if somebody's sticking a gun in your face, you're most likely to concentrate on that gun that's in your face. Absolutely, we totally acknowledge that. But the inconsistencies I want to talk about are inconsistencies either in central facts that would be superencoded, that she would remember without any question, or for information that happens before that stress started. Remember that line that goes up, the stressful event is what starts that process of memory issues. The inconsistencies are relating to what happens before that, when your memory is normal. She told you, her story today is Alex was going to have her one more time. He was going to sexually assault her. But when Ryan Prock asked her about that situation, asked her what was going to happen, she said, well, I just think he was going to look at me. That's probably the first thing that came to her mind when she's talking about it then, but later on thinking about it, thinking, geez, that doesn't sound really good. I killed him. Doesn't sound great that he was just trying to look at me and I just got these superficial cuts. It'll sound better if I say he was trying to rape me. That sounds a whole lot better. That sounds a whole lot better to protect myself from getting convicted of first-degree intentional homicide. Ryan Prock asked her, why would somebody be cutting your clothes? And she told him, I don't know. Again, a central fact is what's going on here. And later on she remembers and she says, oh yeah, that's right. He cut my clothes once before. That's not something that was part of the stressful event. That's something that happened a long time ago. Supposedly, at least, happened a long time ago. And she doesn't tell Ryan Prock about that. She says, I have no idea. And while, I guess, probably not an inconsistency where she says one thing one time and she says another, but it's interesting when you listen to her statement to Ryan Prock about the events of March 22nd. When she's talking to Ryan Prock on March 24th, she says, when I got to that road. That's what she said. Well, that's interesting language because just think about it again, using your common sense. When you're driving somewhere, that's how you're going to describe it. But if you're a passenger, it's going to be more like, well, when we got there, or when we, when they got there, something like that. Not when I got there. Sorry about this. Some more inconsistencies. Again, central facts. Actually, the first one is a fact before the stress started. All right, remember, her testimony, her story is, I'm in the car trying to find something to get us unstuck. All right, both times, when she talked to Ryan Prock in March, and when she got on the stand and told her story was she was trying to find something. But when Ryan asked her, did you throw anything out? She said, nope, didn't throw a thing out, didn't throw anything out. Her story changed now to, I threw out the blanket, I threw out the pillow while I was hunting through there. From before the stressful event started, assuming you believe it was that stressful event, before that happens, when things are just being normally encoded, or memories are normally being encoded. Her description of Alex taking off the glasses, she never tells Ryan Prock that, and yet her story changes to that because it has to look better. It has to look like she can't see anything, so that her story can be better for her. And her story changes on where the first cuts were. Her story changes on that because remember, she told Ryan Prock, he first starts cutting on my legs. But she changes it, and she has to change it to fit the facts. Because she's got to change it to fit the facts that her first concern was when he's cutting her sweater and then she feels that prick in her stomach. And now she's on alert. That's when the stress starts. She's got to change it to that. To change in her story. Ladies and gentlemen, when you've considered all of those things I talked about, the defendant's credibility is zero. Her story is just that, a story. It's not the truth. It's not what happened. I want to spend a couple minutes, and I don't want to spend more than that because, frankly, Alex's journals are a distraction in this case. They're a distraction from what really happened, the defendant murdering Alex. But we do need to talk about them briefly. And I think the first thing you need to think about them is the unreality of the defendant's story about how she first met Alex and first got to know about these journals. Her story is, she goes into a bar and she sees Alex sitting there, he's writing some stuff up, and she asks him what she's writing about. Oh, that makes some sense. But what does her story then become? He says, yeah, I'm writing about philosophy and I'm writing about cannibalism. Ladies and gentlemen, think to yourself. And think about that situation. Use your common sense. Your common sense, what does it tell you? Does it tell you, A, that someone who just meets someone else is going to tell them I'm writing about cannibalism? And B, does your common sense tell you that someone who just hears that in a bar at night, what's their first reaction going to be to that? Is their first reaction going to be, oh, tell me everything you can about that area? Or is your first reaction going to be, oh, nice seeing ya, bye? That's your first reaction. You don't want to know everything you can about cannibalism from someone you've just met in a bar. But secondly, look at the defendant's description. She describes Alex's philosophy and says, and certainly Alex definitely has an interest in St. Augustine's famous quotation, love and do as you will. There's no doubt about it. He has many writings about that. of them philosophical, but he has many writings about it. And the defendant's story is that Alex told her that basically means I can do whatever the heck I want, whenever I want, I can take whatever I want, it's all about me. And taking whatever I want. Now, there was only two people to that conversation where this supposedly happened. The defendant and Alex.
Attorney, I'm sorry.
Alex?
I think a jury needs a break.
Oh, okay. All right, that's fine.
Sorry.
All right. And if that happens again, if somebody needs a break, that's fine. I know I can, my wife tells me I talk too long a lot, so. There's only two people to that conversation, defendant and Alex. And Alex can't be here in person to tell you that the defendant is lying about that. But you know what? Alex is still here to tell you the defendant is lying. Because Alex tells you it in the journal entry titled Desire and Will. One of the entries that's in Exhibit 697, the journal documents, one of the ones that the defendant didn't bother to bring up herself. Didn't bother to bring it up because it doesn't support her story. It doesn't support her story on what her discussions with Alex was about. Because that journal entry, and in that entry, Alex is here today telling you what he means. Telling you the defendant's a liar.
Objection.
Telling you...
Objections noted, overruled.
Telling you she's lying to you when her story is that Alex believed in taking. Because desire and will tells you what love and do as you will really means. Love and do as you will means it is an expression of an excellent morality. It is about giving, to give and give and give to the other. It is in fact, and Alex is telling you in that journal entry, it is in fact the exact opposite of the defendant's story. That Alex is about giving. He is not about taking. And finally, the defendant's story on this issue, when you listen to her and heard her on direct and cross-examination, just doesn't ring true. She's on the stand, she's on direct, reads a part of a thing and says, oh yeah, I remember absolutely clearly 100%. Alex and I, we talked directly about that. We talked about it and he said this and he said that, said this and he said that. But when I tried to cross-examine her on some of the entries that she didn't talk about on direct, well, no, I don't really remember that stuff. I don't remember anything about that. After months of time, she's able to, again, craft her story to fit her narrative. Just doesn't ring true. And I want to talk about the book Fear and Trembling. And frankly, ladies and gentlemen, this part is somewhat, I think, insulting to your intelligence, the use of this by the defense. Because the defense brought this book out how many times to show you the cover of this book? To show you a cover of a book that's about the biblical story of Abraham and Isaac. And I'm sure many of you may very well be familiar with the story of Abraham taking Isaac out into the desert at the angel's command to sacrifice Isaac because that's what God wanted. And Soren Kierkegaard in this book writes a book about that and the philosophical constructs of that and how that has to do with faith. But they trotted that book out all those times not to talk about the contents of that book because you didn't hear about a single word inside of that book during the testimony. All you saw was the cover because they want to insult your intelligence and think you're going to think because you see a book with a cover that Alex has that has a cover on it that has somebody with a knife at somebody else's throat, that Alex is somehow the one who is attacking the defendant here. The defendant is trying to insult your intelligence. Don't let that happen. And the other thing about that book is the defendant's testimony is, oh, Alex would read that all the time to me while we're having sex, while we're engaged in sexual activity. He'd sit there and he'd read it to me while he's having sex with me. Well, remember her testimony as well? Her story is they always had sex in the dark or with a dim candlelight. How is he reading a book to her while he's having sex with her in the dark? I don't think Alex had X-ray vision. He doesn't have the night vision capabilities of the latest iPhones, ladies and gentlemen. And ladies and gentlemen, let's take a look at what the defendant's story says about what had to happen after she stabbed Alex 16 times. Let's think about it. Her story is essentially this. I stabbed Alex 15 times while I'm in the car. Alex then walked away, went over by the trailer, stood around there for a while, said, I need your help urinating. So she gets up out of the car, walks over by the trailer. He grabs her again, and she stabs him another time in the left side. She said her story is she stabbed him again. He then lets go. She trots away to somewhere else. Alex then walks a little bit, takes off his coat that doesn't, by the way, have any stab wounds in the side, even though he does, and takes his coat off, lays down on his coat, well, he's still, got blood running out of his neck, coat that doesn't have big pools of blood on it from that, or the wound to his groin, as he lays on it. She then sometime collects her glasses, goes to the back of the car, her boy in his arm while Alex is just laying there on his coat. Not getting any blood on it. Blood somehow is getting onto the ground, but not onto his coat. She then goes back to the car, the inside of the car. Again, she's bleeding. Where does the blood go? Doesn't go in the car, but she goes in there somehow, rummages around, finds Alex's phone, takes off her other boot, and trots on away. And Alex then, after that, after she leaves, because he hasn't moved yet, Alex all of a sudden decides, oh, well, let's see, I think I better get up from the ground here, pick up my coat, trot back over to the car, get all the way into the passenger side of the car, because that's where his feet are when he's found, and take off his shoes, put those down on the floor, and then take his coat, neatly lay it on top of his shoes, and then proceed to die and fall till he's out of the car. That's what you have to believe happens. And let's take a look at Alex's position that he's in when he's found. Remember, he's sitting over here. He's sitting right here because you see where his feet are. Feet are down on the passenger side floor well. He's sitting there, and you can see the blood transfer on the seat where he's sitting. How does Alex fall into this position? Fall so that his right arm is wedged into the door, his left arm is somewhere there in the footwell. And his sweater is pulled up on his back. Now, ladies and gentlemen, what this shows you is that somebody tried to pull Alex out of that car. That's how the blood gets here. That's from his neck wound. And transfers there as they're pulling him across, and he ends up getting wedged because the defendant can't pull him out. That's what that shows you. And that's what that tells you. He isn't going to fall in a position like that. That makes no sense. But you have to believe that that happened for the defendant's story to be true. And ladies and gentlemen, let's talk about the defendant's story after she stabbed Alex 15 times, waiting for that 16th one to happen. What's her story? She's in the car. She's in the car. Alex is over by the trailer, and he says, I've got to pee. Come help me. Now remember, she's in that stage where Dr. Hopper told you, assuming she's telling you the truth, that her amygdala is in control, right? All right? Her amygdala is in control, telling her, not consciously but subconsciously, to do what instinct tells you. The instincts that we developed when we had to worry about large predators coming and eating us. The amygdala is telling her what to do there. She's not consciously thinking what to do. She's not consciously thinking, should I help him, should I not help him? Her amygdala is controlling her. And let's think about it in terms of Dr. Hopper's analogy of a lion comes walking through that door right there, and your amygdala takes over and tells you what to do. Is your instincts developed from when that lion might have been out there regularly eating you? Does it tell you to go up and give the lion a hug? No. It tells you to stay as far away from that lion as you can. Your amygdala tells you to freeze, maybe. Your amygdala tells you maybe to run. Your amygdala tells you get safe. And at that point in time, when she supposedly has been attacked by Alex and is fearful of Alex, she's in the car. Her amygdala is going to tell her, close the doors, lock the doors, you're safe. Her amygdala is not telling her to go up and help him pee. And what about as she's leaving? Now her story is she lost one boot during the struggle in the car, and she takes off the other boot after Alex is laid down. What's your amygdala going to tell you as it decides that you've got to flee the scene to be safe? It's going to tell you to get out of there as quickly as you can. So it's not going to tell you to take time to take off a boot so that you're moving with just in your stocking feet on a 40-degree day. Your amygdala is going to tell you, get out of there, don't worry about the boots, or the other option is put on the other boots so you can get out of there as quickly as you can. But it's not going to tell you to take time to take off a boot at that point. What about the defendant's actions at Don Sippel's house? I think these are important. And they're important because when you're scared, you want help. You want the police to come to protect you, to take care of you. But what is the defendant's actions? He gets to Don Sippel's house. He doesn't ask Don to call the police. He asks if Don can take him to the hospital. She doesn't want the police there. She doesn't want the police finding her there and possibly finding Alex's body because she hasn't had the time to clean up yet. And she can't remember anything, but she can remember Jason Mengel. And she can remember it enough to be able to, in fact, spell Jason's last name for the police. I want to talk a little bit about motive. Now, the judge has told you we don't have to prove that the defendant had a motive. Motive is not the same as intent. But that motive is something that you can consider. And if the defendant had a motive, it's something you can consider in determining whether or not she's guilty or not. And the defendant had a motive that day. And her motive goes back a couple days earlier to March 19th. March 19th, remember, is the day that Jason Mengel met Jenna Van de Zand in a bar. And Jenna talked to Jason about the situation between the defendant and Alex, and talked about the relationship they had, and told Jason, in fact, about the defendant's actions at Alex's apartment, where she was in the shower, she came out with just a towel on, and told Matt Schreiner, "I just broke up with Jason, isn't that great?" A big smile on her face. And Jason, when he gets home from the bar, calls the defendant and talks to her and confronts her about these things. Now, before that, they were trying to see about getting back together. They were still having loving conversations. You know, they still were meeting occasionally and staying in a hotel with each other and making love. They were still having loving conversations, talking about how each of them want to have children, but they only want to have potentially children with each other. They're still telling each other they love each other. But Jason calls her, confronts her with this, and hangs up on her. Defendant, what does she do? She immediately calls Jenna and says, "Jenna, you've got to fix this. You've got to take care of this. You've got to fix the problem you made." Jenna writes a note, leaves it for Jason that he gets on the 20th. And in the note, basically, she says, "Oh, there may have been some miscommunications, but I'm out of this. I'm washing my hands of this." Jason shares this letter, this note, with the defendant. When she shares it with the defendant, it's clear Jenna didn't do what the defendant told her to do. Jenna didn't fix it. And you can certainly understand why the hairs on Jenna's neck had gone up when she had that conversation with the defendant. Because now the defendant knows Jenna didn't fix this problem with Alex. She needs to fix it. And so she wakes up on March 22nd and comes to Eau Claire with fire in her eyes, as Jason described it. And she comes to get Alex to...
Objection. Note your objection, preserve it for the record, overruled, may continue.
And when Jenna didn't fix it, she is going to fix it. She's going to go to Alex's apartment, and she's going to go there, and she's going to get Alex to admit their relationship was wrong. It was a mistake. You heard that in her own words in the interview on March 24th. She said, "I went there, we talked about our relationship, I told him how our relationship was a mistake, it was wrong, and I asked him if he felt the same way, and he said no, he didn't." But she's got to fix it, because that's what's standing between her and the love of her life. Because remember that last Instagram exchange between Jason Mengel and the defendant the night of March 21st. An Instagram that's polite, but certainly not loving. An Instagram where the defendant tells Jason, based on her conversation with her father, my life starts now. And Jason doesn't respond to that with, our life starts together. He responds with 2 messages. 1, that's a good idea. 2, no more lies. And then the Instagram exchange ends with the defendant expressing her feelings are still there. She still loves Jason. She still wants to be with Jason by closing out that Instagram exchange with my husband. And Jason doesn't respond, my wife, he just responds, dream wildly. So the defendant's got to fix this problem herself. And the only thing standing in the way is that relationship she had with Alex. She needs him to say it was a mistake. She needs to get Alex out of the picture. And Alex says no. So she's got to get him to a place where she can make him say it was a mistake. A place in private. Louis Bjork's field. And when Alex continues to say, no, I'm not going to do that, she snaps, she gets into a rage, and she stabs him. She stabs him in the head. She slices his neck.
It's total speculation. Objection, this is total and complete speculation. You're not allowed to speculate.
This is an argument, and I'm going to note your objection. It's overruled.
That's what she does. When you look at the defendant's testimony, when she's talking about something that other people are present for, that other people can confirm or deny, she can't remember things. Don't remember that. Don't remember that, Bill. Ask her about the interview with Officer Reeves. I don't remember anything about that. Ask her about talking to the nurses. I don't remember anything about that. Ask her about anything that somebody else can confirm or deny it. She can't remember it. You ask her about things that only happened between herself and Alex. All of a sudden, her memory comes to light. And she remembers everything. That's not the truth. That's a story. Let's talk briefly about the experts. We've got Dr. Mills, Dr. Tillotson, Dr. Tovar, Dr. Benson, Dr. Thomas, and Dr. Hopper. Let's start with the medical experts. First thing that's important is both forensic pathologists who talked to you told you Alex died from sharp force injuries that the defendant inflicted on him. They confirmed the defendant caused Alex's death. And then you heard from a couple of experts, a couple of doctors on the defendant's injuries. And you heard from Dr. Tillotson. Dr. Tillotson, the only doctor who testified here who wasn't being paid to come here and testify, whose only interest, he told you what his interest is. His interest is in his patient and what's best for his patient. All he's trying to do every single day, and all he was trying to do in this case was help his patient, who was the defendant. And he told you and he explained why, and we've gone through why. His opinion is these injuries are self-inflicted that the defendant had. And if they're self-inflicted, ladies and gentlemen, if all of them are, the defendant's lying, obviously, that she's guilty. You also heard from Dr. Tovar. Dr. Tovar on that, who says, well, my opinion is they're consistent with being inflicted by somebody else. And that's what he writes in his report. And my opinion is that Alex's injuries are consistent with somebody acting in self-defense. And that's what he writes in his report. And the defendant told law enforcement the boy was carved into her arm by Alex. And that's what he writes in his report. A report that he can't even get Alex's last name right, except about half the time. I mean, puts it in there, I think it was 17 times, he gets it right 9 times, he gets it wrong 8 times. That's the type of expertise that you want to rely upon. But not only that, he writes his report in such a way that it sounds like he's supporting everything the defendant says. But when you actually ask him questions, well, yeah, no, it could be consistent with something else. It could be consistent with self-inflicted injuries. No, it could be, consistent with somebody killing somebody unprovoked. Yeah, no, that's right. I mean, yeah, you're right. She told law enforcement that she did it herself. But he doesn't put any of that in. And especially galling is the fact that he puts in there that she says that Alex carved boy into her arm when he knew without any question that Alex didn't do that. And yet he writes it in his report. What credibility does someone who does that kind of stuff have with you? I submit none. Dr. Benson testifies it's his opinion that she is diagnosed with PTSD, but he cannot tell you the exact cause of that PTSD. He can't tell you what it was from. And Dr. Benson, who gratuitously adds the statement, I'm not a hired gun, when nobody had asked him if he was or wasn't a hired gun, he just blurts it out, actually acted a heck of a lot like a hired gun when, on cross-examination, the state was asking him, does PTSD cause you to lie? And he says, well, that's a difficult question. You got to consider whether it's a lie of omission or a lie of commission. Making it clear, commission, if you know you're lying at the time you're lying, that's not explained by PTSD. When you try to get him pinned down, he just keeps changing and changing and changing the question so that he doesn't have to actually answer that question. That sounds like someone who has an axe to grind in the case, someone who has an agenda in the case, not someone who's just here, like Dr. Tillotson, testifying about what's best for his patient. And then we have Dr. Hopper, and frankly, ladies and gentlemen, Dr. Hopper is an expert. His science is very, very well accepted as to what happens. But Dr. Hopper was also not a hired gun. Dr. Hopper was telling you things, and he was being straight with you, and he was being straight with the defense, and he was being straight with the state. He doesn't know what the stress is that started that whole process, assuming it even started, of causing this super encoding of central facts and not encoding of peripheral facts. He doesn't know what that stress is. Although he did say that that stress could be someone being involved in a murder. That was his testimony. But he doesn't know what it is. And he was honest about that. And he also told you that while certainly her statements and how she presented could be consistent with someone who had undergone a stressful event, he also said it could be consistent with someone who was just lying. And again, we can't know the cause of that stress. So, let's take a look at the timeline. This timeline is important. The timeline of events is important because this timeline tells us right about 1:25 is when the defendant arrives at the scene where she ultimately kills Alex Woodward. And she arrives at Don Sippel's house about 4:15, the time of the 911 call. So we've got 2 hours and 50 minutes between that. 2 hours and 50 minutes between the time she gets there to Don Sippel's and the time she's arrived at the scene. Her description of what happened, her description of getting stuck once, getting it unstuck, getting it stuck a second time, looking in the back seat for something to get unstuck, and sitting on the trailer for a little while, and then going back to the car and the attack that her story talks about. An hour, maybe, at the most, to the time when she's heading to Don Sippel's house. 10 minutes to get there, that leaves her an hour and a half or more yet that's unaccounted for. An hour and a half in here that's totally unaccounted for by her story. And you know why? Because that's the time it takes her to set up the scene. That's the time it takes her to set up the scene after murdering Alex to make it look like it was self-defense. That's the time it takes her to try and get Alex's body out of the car. That's the time it takes her to try and put her blood in locations where she can do that. That's the time it takes her to cut herself. It's the time it takes her to take off her clothes, cut them, and then put them back on after she cuts herself. It's the time it takes her for the blood on her cuts to dry and then get to Don Sippel's house. It's the time it takes her to create a scene. So what do the physical facts, what do the evidence as it relates to the blood, what is the physical facts as it relates to where the blood is and what type of blood there is in various locations tell us about what happened? So ladies and gentlemen, those physical facts, that blood tells us that Alex Woodworth is outside of the car when he's stabbed. Those physical facts tell us, as we talked about, that the defendant is behind Alex Woodworth when she stabs him in the head. And that Alex is out somewhere in this area or here where those pools of blood are when the defendant slices Alex's neck. And that Alex retreats to the car to try and get away. He runs to the car, trying to get away, and as he's doing that, he's getting stabbed in the back because those stabs are through the coat. And he must take off the coat at some point in time to try and get it off. Maybe as he's getting stabbed, he's trying to take it off. And he gets in the car, and he's stabbed in the side 3 times while he sits in the car. So again, those stab wounds are perimortem, as Dr. Mills told you, close to the time of death. And we have cuts in the seat of the car that tell us that there's stabbing taking place in there. And that's what the physical evidence tells us. And the defendant then tried to get Alex out of the car, as you can see here, and couldn't do it. That's what the physical evidence tells us. The physical evidence tells us the defendant did this intentionally, that she did this not in self-defense, and that the defendant is guilty. So ladies and gentlemen, when you consider all of the evidence in this case, it is clear. It is clear beyond a reasonable doubt. It is clear beyond a reasonable doubt that the defendant sitting there is guilty of first-degree intentional homicide. It's time to tell the defendant, no more lies. You're not going to get away with just one more lie. Make her take responsibility for Alex's death on March 22nd. Find her guilty. Thank you.
All right, ladies and gentlemen, we are going to take a recess. I'm not exactly sure how long at this point in time. I don't know if we're going to have a snack or lunch, but we're going to have a break before the defense closing arguments. So, and Madam Clerk, I think what we ought to do is just have them order lunch. This is going to take a while, I'm sure, and we need to give the.
She wanted to live. She fought to survive. This is a case about self-defense. That's what this case is about. It's not about Ezra's relationships with other men. It's not about Jason Mango. It's not about the missing witness that you never heard from, John Hanson. It's not about whether she's posted racy photos of herself. It's not about all the drama going on at coffee shops in Eau Claire. This is about Ezra and Alex. What happened between those two people in the back seat of a car. A car stuck in the mud out in the middle of nowhere. This is a case about self-defense. Let's start with the fight in the car. Because I think the state is presented to you, and I'll eventually address some of their arguments that they've gone through, right? But I think what is clear, and I want to go through the evidence with you, is clear. This is about a fight in the back seat, right? Let's just think of the evidence. The state's theory is essentially this. After 15 days of trial, 19 months of investigation, 15 days of trial, their closing argument, they come up here and they tell you, she's lying. Just want to wipe it all away. That's what they want to say. As if he's Obi-Wan Kenobi talking to the droids in the first Star Wars and just says, ignore all this. You can wash it away with one hand. You can't do that in court. Especially when you don't bring anything else. At some point you're going to be shown the law. I'm going to talk to you about the law. The judge has already told you the law. But we'll remember from the first day that I spoke with you. If you can reconcile the evidence upon any reasonable hypotheses consistent with her innocence, you should do so. The state has not brought you any reasonable hypotheses whatsoever. And they certainly have not disproved, which is their burden. Their burden to disprove beyond a reasonable doubt the reasonable hypotheses that I stood here on day one of the trial in voir dire and talked about, on day two of the trial in openings and talked about, and presented to you and say, this is what happened. And then we call our witnesses. Ezra gets up on the stand. And what do they bring in rebuttal to all of that evidence? Jolee Post, a friend from high school and middle school, to say her personal opinion about another human being when she knows nothing at all about this case. That's what they do to rebut our reasonable hypotheses. But it starts with a fight in the back seat of the car. Here's the evidence that there was a fight in the back seat of the car, right? One is, she told that to Detective Prock on the 24th. And I understand the state says, don't believe that. Don't believe any of that. I came here on day one, and I talked about what happened here. And the state has brought you no evidence to contradict anything that we say about what happened there. They want to call Ezra and question her credibility about what happened in the months leading up to that. They want to call her a faker or a liar based upon her mental condition after that. But they have nothing to fill that in there. So I do present to you Ezra's statement. She told Investigator Proc 19 months ago there was a fight in the backseat of the car. What else do we know? Physical evidence. They talked about it. We put it up. He put it up on the screen. Alex's blood is in the back seat of the car. It's in the back seat of the car. It's on the ground around the front of the car. Can I have the screen on, please? Oh, thank you. So we know his blood is outside of the car, but we know his blood is inside of the car. It's in both places, right? So what we need to figure out is, logically, what can we conclude from that? We can conclude, like the state's trying to say, is there was a fight outside, and then he retreated into the car. Or there could be, there was a fight inside, he got out, and then he got back into the car. Because we know at the end of the day, he's in the car. So where did it start? The fact that there's blood in the backseat of the car is consistent with the defense theory. There was a fight in the backseat of the car. And I can talk about where it is and why it is. But just because he was cut doesn't mean he's going to bleed profusely right away. There's no evidence that says he would be dripping. There's no evidence that says about the blood, how it would be spurting. What we know is his clothes were saturated. And we'll get to that eventually. There's a defect to the rear back seat of the car, right? In Exhibit 6.1, right there, as well as right there. There's defects to the back seat of the car. Reasonable hypotheses, those are from a knife, a puncture wound from a knife. There's no testimony that they were there before. There's no testimony that says they're not from a knife. There's a knife in the back seat of the car. There's a fight in the back seat of the car. 4. Well, I think 4 is the one on the back seat of the driver's seat. 3 before is the one on the back seat in general. The displaced hat, as you recall, and you can see it from here. Up here, if you recall, there's a hat. It's on the back of the driver's side thing, and it's been displaced. It was as if somebody had originally took a hat and pulled it over like a skull cap over the top of the hat. And then it got disrupted. Something happened to that hat. And if you recall, what she had both told Investigator Proc on the 24th and what she testified when she took the oath and talked to you, is at some point she was pressed up against the back of that seat. Her head, her neck was pressed up against that headrest. That hat is consistent with what she says. There's a fight in the back seat of the car. The mud on the ceiling, right? We entered those pictures in at the close of our case. That's not something the state had done before. In Exhibit 709, you can see that mud on the ceiling in the back seat. It's documented again in 708. Exhibit 707 shows it with the sticker there. And Exhibit 710. Her testimony to Proc, or her statements to Investigator Proc, Detective Proc on the 24th is, she was kicking and kicking and kicking. Her testimony to you is, she was kicking in the backseat of the car. How do they explain that there's mud on the ceiling in the backseat of that car, other than from a foot scrape from somebody kicking in a fight to survive? If you remember the shoes, her shoes were muddy. Her shoes were at the scene. They weren't muddy from her leaving the scene, they were at the scene. And we'll get into his shoes before, but his shoes don't have much mud on them. Because she said beforehand, she got out, she was walking around the car, she was trying to move or trying to get the car out. She had mud on her shoes. She gets into the car, they get into a fight, she kicks and kicks and kicks to survive. There's a fight in the back seat. Her hair is in the footwell, right? She testified and she told Investigator Proc that at some point after he had put his hand up on her throat, he slid it around and pulled her hair out. And she said, I believe she said she screamed at that point. She said something at that point. There's hair on the bottom of that footwell, right where the hat was before, if you recall correctly. This picture here is the same footwell for this picture. That's on the bottom of that floor there, under the coat. Here's a picture of the coat. That hair is under that coat, which we'll get to later when we talk about the order of events. But remember, the hair is on the bottom. On top of the hair are shoes. On top of that is a coat. On top of that is Alex. There was a fight in the back seat of the car in that footwell. He pulled out her hair. In the exhibit, when we heard from the people from the crime lab, Kevin Scott, he tested that hair, and it was Ezra McCandless's hair. That's her hair in the footwell where the fight was. Alex's injury to his knee. I believe we spoke about that in opening. We spoke about that right from the beginning of the case. I told you, pay attention to the injury to his knee. There was something that happened to his knee, and there's no explanation for how that could have happened other than his knee being on a hard surface rubbed against it. Bottom left-hand corner there, if you can't see because of my, there's an abrasion. The state's medical examiner, Kelly Mills, testified. And Ms. Vishny asked her questions about that. She said, yes, that's an abrasion, and that occurred at the same time as the other injuries. That's what the state's expert said. And the state's expert also said, when they looked at the clothes, there was no mud on the knee right there. There's no mud. So how do you scrape your knee when you're wearing pants? You do it on a hard surface. Where's the only hard surface that could have happened where you wouldn't have got mud on it? The back seat of that car. That's consistent with a fight going on in the back seat. And if you'll recall, again, I said that in my opening. I brought that to you. In 15 days of witnesses, 45, 50 witnesses that the state called, 2-hour closing argument, not once did they rebut or disprove that reasonable hypothesis. They brought you nothing. Number 9, the back door, right? The crime scene, the back door of the vehicle is open. I think as we can see in other previous pictures, this door, now granted, that's at the crime lab, right? But I think we all recall that that door was open at the scene because we remember Mr. Woodworth's half in, half out of the car. How come that door is open? Somebody got in that door, right? But what we know is this, is when they tested the car, there is no blood on the door handle on the outside. Remember on the other, if you look at the one with the outside door handle with number 1 pointed on it, so this is the outside of the car door. You recall there's this right here where there's the blood on the outside of that door, right? But what they didn't do is they didn't find blood on that door handle. They didn't find blood on that door handle. Here's the other side of the car. There's no blood on that door handle, and there's no blood on that door handle. Which tells you this, nobody opened that car door after there was bloodshed. Which means the door was open before there was bloodshed. It's the only reasonable explanation. And why would the door be open on that car in the back? Because 2 people were in the back seat of that car. And there was a fight in the back seat of that car. That evidence, or the lack of evidence, supports the reasonable hypothesis there is a fight in the back seat of that car, ladies and gentlemen. Now, you saw all these pictures, and you've seen me, I'm struggling to even find the pictures sometimes. There's just so many pictures, right? But there's no pictures of the ground that show a struggle being on outside. There's blood on the ground, right? There's definitely blood on the ground, but there is no pictures whatsoever fish on the water here. It's right here. That's the scene, right? That's all the blood outside there. And we know it's muddy. We've seen mud on shoes, we've seen mud on pants, we've seen mud everywhere else. If there's a knife fight going on out in a muddy area out on that field, there'd be more mud on Alex's shoes. There'd be mud displaced all over in that area. Other than blood on the ground, which could come from a person who is cut walking and staggering around, there's no evidence of a struggle outside of that at all. Basically, the only evidence that they've got of a footprint nearby is what I'd asked. When I'd asked, I believe it was Deputy DeVries, and we talked about this footprint that he agreed was going in the direction towards the open door. Right? And that was the last print. Because if it's still there, if somebody stepped on over it, right? We all just know logically, if that foot's put there, that's because nobody else stepped on it afterwards. The state's theory is he runs into there, and afterwards she's standing out there stabbing him from outside the car and trying to drag his body back out. That footprint is at marker 5, right there. And it's in a direction going into the car. The absence of any struggle, mud, scrapes, falls on that scene out there outside suggests that where the fight wasn't outside. The fight was in the back seat of the car.
2 more points. It simply rings true. Use your common sense. 2 young people who had previously been sexual partners are in a car. The car's stuck out in the mud, on the middle of nowhere. They're in the back seat. It's not a crazy hypothesis. It's based upon common sense, all right? It rings true. It started in the back seat. Last point, similar to the first point, is Ezra's testimony. She came in here, she talked to you. She took that stand, she took an oath, she told you it happened in the back seat. And I understand they're going to attack her. They have attacked her. They'll continue to attack her. They'll attack her sex. They'll attack her gender. They'll attack her anything. They'll attack any way that they can. But I submit to you this. She went through that on March 22nd. And you heard the tapes of her on that day afterwards. You heard her hysterical. You heard her in that trauma. And she got back up here again and told you what happened. There was a fight in the back seat of the car. I'm going to come back later and talk to you about why the state's theory makes no sense. Makes absolutely no sense. It started in the back seat of the car. But I want to take a step back before I go back into some more facts and just let's talk about the law for a second, right? Because I think this entire case, it's very good that we need to frame it in a court of law. This isn't an argument down at Lacy's. This isn't somebody sitting at the kitchen table with their parents gossiping about a case. This is a great duty that you've been selected to serve upon. And it's a big weight. I think the judge even says that in the instructions later, that it falls upon you. But the good news is you have the law. And the law, as the judge said in the beginning, we live in the United States of America, the greatest country in the world. And oftentimes what many, many, many people say is the greatest country ever, is because of our legal system. The rule of law, right? Don't want to go too far into history, but back in the 1700s, when this country was founded, it wasn't founded based upon a particular religion. It wasn't founded on a particular ethnicity. It wasn't founded on a race. It was founded by people who came here, and they were mixed, right? If you lived in Pennsylvania, you came from a very different place from Europe than if you lived in Massachusetts, or if you lived in Delaware, or if you lived in Georgia. And of course, there were many people that didn't come here of their own free will. But what our country, when it was formed on the law. They wanted to say, we want to make our own laws. Not a king, not a monarch, not anything along those lines, but followed on the law, voted upon by the people, and most importantly, the right to a jury trial, decided upon by a people. 3 principles that govern that system: the presumption of innocence, the burden of proof, and proof beyond reasonable doubt. So let me talk to you a little bit about those. That's the instruction that the judge read to you, right? First thing, the defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty, unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that she is guilty. Those are long instructions. I remember back here at about 8:30 when the judge read those, and it was about, 45 minutes or so of reading of those. I think there's like 20 plus pages. I submit to you, I should probably double check, but I'm pretty sure that the only place that the word requires is found in those pages is that sentence. This presumption requires a finding of not guilty. That's for you. That's something that you get. She is presumed innocent. The second part of that is that the burden upon overcoming that is on the government. They have to bring evidence to you, as it says there. You've probably read it by now. The burden of establishing every fact necessary to constitute guilt is upon the state, and will doubt that she is guilty. We don't have to bring you anything. They have that she is guilty. We don't have to bring you anything. They have to overcome and bring it all to you. So if you, as you sit there, you have unanswered questions, you think, well, this doesn't make sense. It wasn't explained to me.
Objection, Your Honor, it doesn't properly state the law.
Sustained. Go ahead and continue.
The law speaks for itself, right? Later on when I talk about it, you can consider reasonable doubt. You can consider both the evidence and the lack of evidence. If they haven't brought it to you, it's because it doesn't exist. It's their burden to do that. The third part of the law that you should consider is what's that level of proof, right? In these cases, it's the highest level of proof that we have in the law, in the land. In civil cases, all right, if somebody's been wronged and they want to sue another individual, and the only way we can do that in the United States of America or any place for that matter is you sue them to get money, okay? In order to do that, the plaintiff has the burden to prove by what's called a preponderance of evidence. And the best way to think about that, I like to think about it with these reams of paper here, all right? So if one side's got a ream of paper of evidence, and the other side has a ream of paper of evidence, and this is the plaintiff, they don't win. You can bring all of this, and you don't win, because this isn't any more than this. Make sense? But all they need to do in that scenario, all right? One side, another side. When it's the lowest burden of preponderance, they just need one sheet of paper. You put one sheet of paper on that side, and they've met their burden. There's a middle burden as well. In Wisconsin, it's called clear and convincing evidence. And that's in cases where if the government wants to take your child, right, or if there's other civil matters, they need to convince, bring a level of proof that's called by clear, convincing, and satisfactory evidence. And it's a little muddled, certainly in my mind, but what does that mean? And a jury would need to decide that, but I would submit to you that in that situation, clear, convincing, and satisfactory would be when one side has twice as much as the other side. Makes sense to me. It's pretty clear that the burden has been met in that scenario. In this case, it's the highest burden of proof that's necessary. The state needs to prove beyond a reasonable doubt. The meaning of reasonable doubt, right? A doubt based upon reason and common sense. A doubt for which a reason can be given arising from a fair and rational consideration of the evidence or the lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. That's what reasonable doubt means. And you can read on. It also talks about what reasonable doubt isn't. But the line before that really is what changes it. And I've talked to you about that. If you can reconcile the evidence upon any reasonable hypotheses consistent with the defendant's innocence, you should do so and find her not guilty. So, in this situation, it's no longer one side have more than the other side. The plaintiff in a case like this, the state, stack as much as they want over on this side. Put it all up there. That's fine. But if you don't make reasonable doubt go away, it doesn't matter. They have to eliminate reasonable doubt. And from the get-go, I stood here, looked you in the eye and said, here's what our reasonable hypothesis is. Here's what happened. Prove beyond a reasonable doubt it didn't happen. And they haven't. They haven't brought you that evidence. And they haven't brought you that evidence because that evidence doesn't exist. If it did, I submit this whole group, prosecution team, certainly amongst the prosecution team, they'd have found it and they'd have brought it to you. But after 15 days, they haven't. And they haven't because it doesn't exist. And it doesn't exist because she's innocent. Right? That's what the law says. And in this case, it's about self-defense. So let me talk a little bit more about self-defense as well. This is I believe we all agree, a fair reading of the law on self-defense. I'm going to give you a second to read that while I take down this other one from distracting you. And it may be that that is not legible enough, so I want to bring up the other one. I apologize for not having a PowerPoint. Scraping the stuff together here. I believe that's the accurate reading, similar to that. Self-defense, when it's an issue, it allows her to threaten or intentionally use force only under certain situations, right? There's basically three parts to it, okay? First two are her beliefs. That's a subjective standard, right? Did she believe? That's what your first consideration is. Did she believe that there was an actual or imminent unlawful interference with her person? Second is, did she believe the amount of force she used or threatened to use was necessary to prevent or terminate that interference? And we're going to talk about those. I'll go through the evidence that shows she had those two beliefs. If you find that she had those two beliefs right away, she's not guilty of first-degree intentional homicide. They have to disprove, and this is where it gets into these double negatives, right? But they have to prove to you beyond a reasonable doubt that she did not have a belief that she was in actual or imminent, there was going to be an actual or imminent unlawful interference with a person. They have to prove beyond a reasonable doubt she did not believe that. You have to prove beyond a reasonable doubt she did not believe the amount of force she used. If they haven't done that, right away she's not guilty of first-degree intentional homicide. You don't even need to consider intent, which I'm going to get into here later. The third part of self-defense is an analysis for you to decide, were her beliefs reasonable? Right? And that, I want to make sure I get that correct. Page 8 and 9 of the jury instructions talks about that. And you're going to get a copy of these jury instructions. Is that legible? And here it's talking about it. Here it's talking about it in regards to second-degree intentional. Apologize for chunking it up like this, but the jury instructions break it out into different parts. So that third part of self-defense is, were her beliefs reasonable? And this is what you need to consider, all right? They need to, for second degree, consider whether or not that a reasonable person in those circumstances would not have believed she was preventing or terminating unlawful interference, or 2 or 3. But what I want to focus on is the last paragraph there. The reasonableness of her belief must be determined from the standpoint of Ezra at the time of her acts and not from the viewpoint of the jury now. The standard is what a person of ordinary intelligence and prudence would have believed in the position of Ezra McCandless under the circumstances existing at the time of the alleged offense. We started out with, there's a fight in the back seat of the car. Those are the circumstances. That's the position of Ezra McCandless. We're going to talk about that more, but I wanted to frame that up for you because post-traumatic stress disorder is certainly something you need to consider. As well as what Dr. Hopper talked about regarding how the defense circuitry works. And when there is an attack, how the amygdala overtakes your prefrontal cortex, your rational part of your brain. And then people begin to act. Ordinary and prudent people, all right? People of ordinary intelligence and prudence, when they're following their amygdala, they are relying upon habits and reflex. Habits and reflex. That's the circumstances under which you need to consider self-defense. So with that, let me just step back out of it now. Let's go back to some of the facts that we talked about, right? I already talked to you about the facts establishing that there's a fight in the back seat of the car. Let's talk about the order of the events, because the order of the events is very crucial here. The state says that there's a particular order that this alleged crime happened. I submit to you that the order of the event is what Ezra says happened, and it's supported by the evidence. I think some of these I may have talked about a little bit before, but I want to address them regarding the order of events. The back door is open, right? And no blood is on any of the door handles. To me, that leads us to believe that the door was open before the stabbing and the cutting. That eliminates the states that stood up here and said He got stabbed, he ran away, he went to open up the car door, he opened the car door, he got into the car door, and she chased him, stabbed him in the back. I believe that's what he stood up and said here to you was their theory. The order of the events, that there's no blood on that door handle. Because under their theory, he gets stabbed outside and he's bleeding all over. That's what explains all of the blood on the ground. Well, there'd certainly be blood on his hands. We saw all the pictures. His hands are covered in blood. And certainly if what their theory is, however odd or unlikely it is, under their theory, she'd have blood on her hands. That door was open. And that door was open because people were in the back seat of the car. And people were in the back seat of the car before any fight happened. That's the order of the events. Second point, there's no blood on the wallet, right? Picture of the front seat with the wallet. Put that back up there. That's the front seat of the car. There's no blood on any of that, on the piece of paper, on the Visa card, on the wallet, on the dollar bill, on the $20 bill. There's no evidence whatsoever that there's any blood on any of those items, let alone on that front seat. So, what does that lead us to conclude? That wallet was taken out before any blood was shed. That wallet was taken out first, right? And what is the state's theory? And I think we agree. Where was the wallet? The wallet was in the center console. And where was the knife? The knife was in the center console. That happened first, all right? That happened first. There's no blood on the center console opening it up, which means somebody was in that center console rummaging around prior to anything blood being shed. That's the order of events. No reason for Ezra to be rummaging around in her own center console, pulling out her own wallet. Under the state's theory, she had this knife and that was her plan all along. Why would she have been rummaging around through the center console to get it? It's the person who was just looking for stuff and came across it. That happened first. 3, Ezra's sweater, right? That's Ezra's sweater. She was wearing that sweater. There's no evidence to the contrary. There's no evidence that she took it off. What we do know is it's got no blood on it. 0, none, nada, zilch. No blood on that sweater. Why? Because Alex cut the sweater first. Under the state's theory, she cut it later, right? Under 2 ways. How would she be able to cut it? Scenario number 1, she pulls her shirt out and she cuts it. Well, the knife would certainly be bloody. There's no knife, there's no blood on that. The hand marks from somebody with bloody hands would be all over that. There's no blood on that. Nobody with blood on their hands cut that sweater. That happened first. The state's theory, as strange as it is, and the first time we heard it is today, is that she took it off. She took it off, and somehow, after this stabbing, covered in blood, she takes it off, yet there's not any blood on that sweater. There's no blood on that sweater because Alex cuts it first. Makes no sense that Ezra would have cut it herself before any of this. Why would Alex be around if he sees somebody else cutting their sweater? Alex cut that sweater first. That's the order of the event. The blue button-up shirt, right? Now, you listened to Mr. DeFore's closing, but I heard him say, her blood's on that shirt. That's wrong. Flat out, completely, totally wrong.
I'm objecting. It misstates my closing argument. I never said what was on there. I said it was on the blue flannel shirt.
Maybe I misheard. Fair enough.
Sustained.
But the bottom line is this. There's no evidence of blood on that shirt. There looks like there's reddish-brown stains, right? But the state, who owns the crime lab, who has the crime lab, who sent all of this other evidence to the crime lab, didn't test that shirt. Didn't test it in any way. They didn't test that shirt. I believe the evidence was that there's reddish-brown stains, and you may recall from your own observations of it, that there was a reddish-brown stains up in this area, through this area, and on this little flap. Not to mention, on that flap, if my tie's like this, and this is the shirt, right? And then it gets cut, and the flap falls down. There's blood on this side of that flap. Shirt's whole, there's blood on the outside of that. Shirt gets cut, falls down, there's blood here. How does that blood get there on the inside? It only gets there on the inside if it's cut first. The shirt is cut first, it's exposed, and then somebody bleeds on it. And a reasonable hypothesis, consistent with the evidence, that they chose not to try to even attempt to disprove, is that blood is Alex's blood. All that blood is Alex's blood. It's just as reasonable. They say that he's bleeding all over the place. That's his blood on the inside of her shirt after it's been cut. That's the order of events. Sweater gets cut, blue shirt gets cut. That's how it happened. Now, how did it drip down on there, right? Depends, and we're going to go through Ezra's statements. But when they're face to face in that footwell and she's fighting for her life, she wants to live and she's fighting for her life, and her shirt's up again, they're in its close proximity, she can get blood on her at that point, right? That's when the blood can get transferred onto that shirt from Alex. Order of the events, what else? Alex's DNA. It's on the knife handle. And if you recall, Kevin Scott came, he testified, I think there's 3 of his reports here, right? It was item O in the evidence, and he tested it for blood, and on the handle, there was 2 sources, Ezra's DNA and Alex's DNA. And what his testimony was is, it was confirmatory for blood. But he can only confirm if it's one person's blood. So he could not rule out the possibility that it's Alex's touch DNA and it's Ezra's blood on that knife. They cannot rule that out. A reasonable hypothesis consistent with her innocence, he's holding the knife. And if he's holding the knife, it's because he's cutting her sweater, he's cutting her shirt. That happens first. The only reasonable hypothesis consistent with the evidence is that there's a fight in the back seat of the car. She struggled for her life, fought to survive, and when he stopped moving. He stopped strangling her. He stopped fighting with her. He stopped grabbing her. She stopped. He gets out of the car and he staggers around. And he staggers around so that there's blood, his blood, on the ground. Right? And if you recall in the testing, all right, his blood, cigarette with his DNA, cigarette with his DNA, his blood, number 12 is his blood, right? A boot with his blood on the outside of it, a boot with his blood on the outside of it. 5 is the footprint. This is all Alex's blood. Consistent with him being stabbed, getting out of the car, staggering, walking around. Every one of the medical experts, aside from Dr. Tillotson, I understand he's a medical expert, he didn't talk about the scene. Dr. Mills, Dr. Tovar, Dr. Thomas, all talked about somebody with the wounds that Alex Woodworth had would have still been able to walk, would have still been able to talk. And I believe the state essentially conceded in their argument just now. They just said, he ran, right? He ran. I don't know whether he ran or he walked, but we know it's medically possible for him to be walking around out there. That's the only reasonable hypothesis. Marker 15. Did you already give me that one? Here it is. This is marker 15. That's the front tire, right? This here's the front tire, it's stuck in mud. That's the number 15. That's Alex's blood. That's well in front of the front door. The front door, you see here, right? That's marker 12. We can't even see 15 in the dark in this picture. 15 is in front of that. So he's up there walking around, he's here walking around, he's here walking around. There's something that happens. Inside, he gets up. It's reasonable hypotheses consistent with her innocence. He's walking around outside. So let me just briefly talk a little bit about before I do that, I apologize. Alex's clothes. I believe we saw this, and I apologize, and just fair warning for everybody, I'm going to put up a picture of Alex. Those are his pants. He's standing up. Use your common sense. He's been stabbed. But that appears to me, I think using my common sense, that there's a person standing and blood is doing what blood does when they're in a standing position. Gravity has it run down their body. That means he's in a standing position after he got stabbed. State's theory is he stands, he gets stabbed, he runs into the car, then he falls down in the car, right? This happens really quickly. You saw his blood, his clothes were saturated in blood. Saturated in blood. Under the state's theory, he got stabbed and he's laying down in the car within seconds. Right? I mean, that's their theory, is he got stabbed, he ran away, and he got into the car. That would take 5 seconds, 10 seconds at the most. Probably not even that. That doesn't happen there. That's somebody who's standing. He got stabbed, and he's still standing. And we're going to talk about that a little bit later when I talk about the reasonable beliefs, because if he's still able to stand, he's still able to move. And remember, they're going to come back up here, I'm sure, and say 16, 16, 16. They're going to say it over and over and over and over again. But we know this. He was still moving even then. He was still moving even then. So is it reasonable for a person to believe that even though they've used a certain amount of force and that person's up and they're moving, right? It didn't stop him. He's still up and moving. That's what his clothes show, right? That's the order of events. Again, we already talked about Alex's footprint not being disturbed. The blood evidence on the door frame, on the entrance to the door. So this is the, you'll see here's the car. Oops. So that's the picture of the car. I'm going to show you the next picture, which is going to be this area here, the back of the door frame, right? 16 and 17. This is the blood evidence. That's Alex's blood. somebody's getting back into the car in that, and his blood's on that part of the car. There's a close-up of 16. Here's 11, which is the footwell in that same area. So as you come down on the car, this is down by the feet. This is the footwell here. His blood, if you look at the pictures, his blood is around all of that entrance to the car. Somebody who's out of the car, bleeding, getting into the car after that. There's pictures of the top of the car. This is that's the outside of that same car, right? It's hard to see on the, permission to hold in my hand, Judge, and show the jury? So in this area here, there's blood smear. That's Alex's blood. And that gets there, not from somebody who's running to retreat into a car. That gets there from somebody who's struggling and leans on the car in their own time to get into the car later, consistent with her testimony, consistent with her statements. That's the order of the events. We know it's medically possible. We know Ezra says he's outside the car when he leaves, right? Mr. DeFore got up here and said to you, she changes her story every time. She changes her story all the time. You confront her with evidence and she changes her story. You know what she did when she talked to Investigator Prock? She said, he was outside when I left. And then she left. You know what she said on the stand? He was outside when I left. She wasn't there when he got back into the car. If she's some big faker, some big set up the crime scene, some big person who's planned this whole thing out, right? She just missed that fact? Like when she's making up this story, she just forgot that according to Mr. DeFore, she left him in the car and tried to pull him out? And then when she sets up this big lie that she's going to say to the state because she's some big liar, she just forgets the fact of where his body is? No. The gist of her story stays the same. It stays the same all the time. He was outside of the car. And then we know it's medically possible for him to get up. We know that. We know the evidence around the scene is he could have got up. He's standing. The footprint, he got into the car. He's the last person to leave a footprint in that area. That's from his shoes. I believe if we can even, right, I've shown that before. Because that's the footprint, right? That's his shoe. That's his shoe. You'll recall probably her boot prints, or her boots that were out there, right? Reasonable hypothesis, that's his print. He's the last one there. We know this. There's no drag marks in the ground. There's no drag marks in the ground whatsoever. Nobody carried him into the car. She couldn't physically do that. You can argue about her weight, what her size is, but she's not carrying him into the car. Certainly not without getting blood all over every article of her clothing. And we know from his shoes, right? The back heel, you're dragging somebody into a car, you're probably going to drag them with your hands under the arms. The back or the bottoms of his shoes don't have mud piled up on the backs of the shoes or on the bottoms of the shoes in the heel area. Certainly not on any of them. Just a little bit of blood, a little bit of mud. Not on the tops, not on the heels. He's not dragged into the car. He walks and gets into the car. That's what the evidence shows. And we already went through the blood evidence on the door film, all right? So let's talk about this. Ezra's credibility, dare I say it. The state wants to attack it. The state wants to attack her. The state wants to say, don't believe it. Well, let's go through some things that I think we know. March 22nd. 4:10. 4:15, I apologize, all right? I got that wrong. 4:15 is the testimony, was when the 911 call is, she's at Mr. Sippel's house. You heard the recording of her. You heard how she sounded. You've heard from medical professionals who basically, everybody agrees, she's not in the right state of mind there. Is their claim she's faking all that? Remember, their theory is her plan A is to do something and then she gets the car stuck. Plan A, I think their plan A, I think they said was she was going to not let the police, that's it. Plan A, they said, was she's going to kill him, not tell the police where it is so that she can go back there and clean up the scene, right? That's what they said their plan A was, right? But then they find the body, so then she has to come up with plan B. And plan B is, well, I was attacked, I was sexually assaulted, and all those things. But they're also standing up here and arguing plan C or D or E, I'm not sure, where they're saying she cleaned up the whole scene. Right? They came up here and say, she cleaned up the whole scene, she set up the scene, she did all of those things. Well, if she set up the scene, then why is she later making these statements that you say she is? Because she has to go back to the scene to clean up the scene. Why even go to Don Sippel's house? I mean, you could go on and on and on about how much their theory makes absolutely no sense with the evidence, with common sense. First thing is, she's in a dissociative state. That's what the doctor said. That's what the medical records show, right? Dr. Benson got up here and testified, and I understand Mr. DeFore gets to make his arguments, but I submit to you, he's about as credible as a witness you'll ever see anywhere, anytime. And he diagnosed her with post-traumatic stress disorder with depersonalization and derealization, childhood onset, based upon the incidents that happened March 22nd. Can't say what the incidents were, we get that. She's in this dissociative state. On the 22nd, when she arrives there, she doesn't know her name. She's some master planner that's trying to set this whole thing up. Why would I think I'm going to try to fake a mental condition? That makes absolutely no sense. And what we do know is when she got to the hospital, they put her in the hospital based upon her mental condition. So she just fooled all of these doctors, all of these other people, but the state knows better. People with medical degrees know better. No, they've done nothing to disprove that she was in that dissociative state. What else do we know? We heard from Dr. Hopper, who talks about trauma and how trauma impacts the brain as far as memory goes, right? Yet the state wants to come up here and say, well, we get it, there's central details and peripheral details, and we agree with everything that Dr. Hopper says, but then when they say this would have been a central detail, they ignore what Dr. Hopper said. Because what Dr. Hopper said is, look, we don't get to decide what another person's central details are. We don't. I wouldn't know what any of your central details would be as I'm speaking right now, let alone if you were under attack or had some traumatic event. And if you think about her statements, and I'm going to go through it in detail, what the Dr. Hopper talked about was the gist of it. Remember, he had that slide. He said basically at the end, it's really just, it's the gist of it. That's what we need to think about. And he talks about the tree and the trunk, and that's the main idea, and the details are the leaves. Well, what does she say right away to our farmer Sippel, right? She says, I was attacked. I wanted to get them off me. And I understand there was some confusion about pronouns because her and some of her friends at that time used pronouns that maybe aren't in the mainstream way of some other people using pronouns. But she was consistent. The gist of it was she was attacked. She needed to get somebody off of me. She spoke with Emmer Shields. She spoke with Joe Wayne. She spoke with Corey Reeves. She spoke with the SANE nurse. She spoke with Jennifer Morris. She spoke with the social worker, Swartos. She talked about fear. She talked about being scared. Right? That's the gist of it on the 22nd. She's in a dissociative state. She talks about fear. On the 23rd, when she meets with Mr. Proc, Detective Proc, she tells him she was scared. I understand, we're going to get back to the 23rd, right? She doesn't disclose everything. She doesn't share everything. But the gist of what she says, and when I asked Detective Proc, he said, yes, she said she was scared 9 times. She used the word scared 9 times. That's the gist of it. She said Alex was upset, I think 11 times, maybe 12 times. You guys took notes, you can check that yourself. That's the gist of it. And then on the 24th, she says the same thing. Eventually, when she's in a position, place to share, she talks about being attacked in the back seat, defending herself. That's the gist of what she says. We know about PTSD, right? And we know about that diagnosis that she got. And we heard from Dr. Benson that one of the conditions of that is somebody would not want to talk about that. And I think I forgot a point. Just want to make sure that I get to it. Green notebook. Right there, thank you. What did Mr. Sipple say about this? I just want to go back, because you know what? We're talking about witnesses. Remember 90-year-old Farmer Sipple came in here and he talked to you guys. And what did he say? She was visibly shaking. She was really upset because what she went through. That's what he said. She was visibly upset because what she went through. Sounds like Don Sipple believed her. PTSD. We move on. There's this avoidance, right? That's a symptom that we know it is. Somebody wouldn't want to talk about it. It's in the DSM-5, right? Exhibit 720B. Well, first off, page 275, individual may experience dissociative states that last for a few seconds to several hours or even days, during which components of the event are relived and the individual behaves as if the event were occurring at the moment. Some of that. The individual commonly makes deliberate efforts to avoid thoughts, memories, feelings, or talking about the traumatic event. I get it. They want to put everything in the scope of she didn't talk about it. That means she's deceptive. That means she's doing that deliberately to mislead them. Or a reasonable hypothesis consistent with her innocence is she was attacked. She fought for her life. She was in a dissociative state, she was suffering from post-traumatic stress disorder, and she was overwhelmed. A 20-year-old young lady. Completely and totally overwhelmed. And she buried her head in the sand. I get that. She buried her head in the sand. And they want to say, because of that, you should convict her. Don't believe her because she acted like trauma victims act. She didn't want to talk about it. They want to talk about the denial, this line about memory. Again, I understand she didn't say that. What they don't have is her line about the stabbing. They don't have that. She's not lying about the stabbing, right? They want to talk about lying about boy. And that is an odd fact in this case, right? I think we can all agree that is a completely and totally odd fact in the case. But that doesn't make her guilty of intentional homicide or reckless homicide. It doesn't mean she wasn't acting in self-defense. If anything, it's confirmation that she had trauma, right? And this is a response to trauma. What else do we know? Again, she never lies about the stabbing. The gist of the event is consistent. She's attacked, she's scared, he's upset, he keeps grabbing her, she wanted out and away. She doesn't lie about the how, the who, the when, or the why about March 22nd in the backseat of that car. We know about stress impairing retrieval, right? So even if the memory was there, depending upon how much stress she was under at different times, it's not organized in the way that a lot of other things of ours are organized. It's fragmentary, it's images, and it's not going to be in this time sequence, all right? And again, I suspect it was difficult, maybe it wasn't, for Detective Prock when we went through the transcript of his interview, right? And maybe it feels to you as if we were attacking him. That's not the point. The point was, if they're going to judge Ms. McCandless on what she did or she did not say, you need to evaluate the way in which she was interviewed, and when she was interviewed, and how she was interviewed, and was she in a position at that time for somebody to get all of the information? Because I suspect the state wants all of that information. We wish we had all of that information. You wish we had all of that information. Because if that context and cues would have been there, she had them, right? But for whatever reason, on that day, for lots of reasons, her mental state, all right, the PTSD, the stress impairing retrieval, perhaps her own denial or avoidance, right? And the lack of context or cues, she was not in a position to tell all of the information. But now they come to you later and say, well, she must be lying now because she's telling you different stuff. But what we heard from Dr. Hopper, remember my last questions to him were about, we know that over time, recall can improve. Not memory, not the encoding, that's already done, not the storage, that's already done, but the recall, the retrieval, the going and getting it out of our head and sharing it with somebody else. That can improve over time when the stress goes down. And so what's going to happen to basically anybody in a stressful situation when they're talking about things is they're going to, what we think of as, remember things later. They're going to be able to talk about things later that they couldn't talk about then. That's just the nature of trauma. And so for them to say, we agree with all of their research, he's fine, but then they come in here and they just are on the other side, they attack her and they say, no, she adds stuff, she does this other stuff, therefore you can't believe her. That's contrary to the science from the expert that they say knows it all, right? That's contrary to the science. Her having information later, that's consistent with actually being a trauma victim. The inconsistencies that they do talk about, and I'm going to go through some of these, those are about peripheral details, and again, that's common for what people in her position would do. What she does tell, what she says, it's corroborated by the evidence. I went through that. What she says is corroborated by the physical evidence. There's a fight in the backseat of that car. Her clothes were cut before that fight happened, all right? That's corroborated also by what she did earlier in the day. Everything she says about that day is basically corroborated. She leaves out a non-event. She didn't tell the police about knocking on a door and nobody answering. Okay, I get it. She left that out, but I think we'd all agree it's literally a non-event, right? She also didn't tell them when she stopped at a red light. She didn't tell them other things that I imagined somebody would do in the morning. She didn't tell them those things. It was an unimportant, who cares detail, all right? She was openly with Max telling her she's going to go to Alex's. She's not trying to hide the fact that she went to Alex's. We have witnesses to her disassociation and stress, all right? How about her injuries? How about the mark to her neck? right? We've seen that picture. Permission to publish in person, Judge? You ready? You've seen this, right? Picture of the mark on her neck. The state didn't talk about that at all in their closing now. They didn't talk about it to begin with, right? So I suspect when they get back up here, because they get 2 shots at this, when they get back up here, they're going to talk about this. So I want to have a chance to know what they're going to say, because they've kind of sandbagged on that, not talked about it at all. But what we know from the evidence when people were up there testifying is the same nurse saw it, she documented it, she put it in her report. They're going to say, well, nobody else saw it. Well, okay. But nobody else was doing an examination of her that the same nurse was doing. And what we know for sure is she was under constant supervision. Every witness that got up there, because they asked, did you see the mark on the neck? And they'd say, no, I didn't see the mark on the neck. And then I'd come back and say, but she was under supervision the entire time. Nobody saw her put this mark on her neck. Are they saying that she put this mark on her neck in the hospital? She was never alone in the hospital. She was with people all the time. You know why they would make such a ridiculous argument? Because they want this to go away. And they can't make this go away. This is real. She was strangled. And their only answer to it is they just want to make it go away. Talk about denial. Talk about denial. This exists. It's in evidence. It happened. And it happened because what Ezra said happened is what happened. Let's think about it really. What are the main challenges that they have to her credibility, right? They want to bring in, and I'm sure they're going to talk about it next. They want to talk all about this other man, John Hanson, right? Tell me one piece of evidence that they brought to you other than this photo that they're going to show you. This photo of a young lady that took of herself and shared it with somebody, right? And they're trying to use her sex. They're trying to use that against a young lady. People say, no, I'm not going to use that. Read the instructions, right? Read the instructions, what the judge told you about what you can consider regarding this. But what she says about John Hanson, you saw the interview about that, right? They brought in nothing to say that that wasn't true. Where's John Hanson? Where's John Hanson? They didn't bring in John Hanson because he had nothing to add to their case. Because what Ezra said about John Hanson is what happened. She drank too much, she was vomiting, and she had a sexual encounter with somebody under that circumstance. She didn't call the police. She didn't call it all of these terms. Sounds like she regrets it. But that's what they want to bring in to attack her credibility, is her prior sexual behavior. In 2019, they want to shame a woman for having sex. They want to bring in Jason Mengel, former boyfriend. What does he say about her credibility? They didn't ask him about his opinion about her credibility, right? They brought in this Julia Post, middle school, high school friend. They didn't bring in Jason Mengel to say she's got this reputation. There's all this background information about that. They want to bring in, right, the word boy. And that's what their main inconsistency is. She didn't talk about boy. How about this? Grabbing the knife. They talked about that a little bit. I want to go through that with you. It's on Exhibit 290. Because this is where they say it's an inconsistency. And the main part of it is on page 44. You're fine. Page 44 of the transcript is where she talks about it. you recall, Mr. DeFore stands up here and says, she lied and changed her story about the knife after Dr. Tillotson testified in some other hearing, right? He got up here and looked at you and told you she said she grabbed the blade and pulled and got it away that way. That's what he said, to try to convince you that she's a liar. What does she actually say? Right? I started to try to wrestle him and fight him off of me, kick and do whatever I could, but I got the knife and then I just started. How did you grab the knife? I grabbed it. I grabbed it from him and I pulled. What did you grab? The blade? I grabbed the blade the one time and that hurt a lot. Okay, so I tried grabbing the base of it. Okay, and then I don't know. She doesn't say she pulls on the blade and pulls it from him. That's not what she says there. Absolutely, that's not what she says there. And I believe that other parts of the transcript, she talks about how she got the knife. Okay, page 40. Which, remember, this is page 44, right? So just chronologically, before she gives this description, here's the description she gives at the bottom. And I cut my hand because I kept trying to grab it. And then, so he kept grabbing me and stuff, and then I finally got free, and I finally got the knife away from them, and then he kept trying to grab me. That's what she says about how she got the knife. She doesn't say there that she pulls it away from him. She doesn't say that. And I believe in another even spot, top of page 44, that's where he says it, just before the other quote that I had. And then, so we have the first one, I did 40 in the middle. I didn't do it in chronological order, I apologize. I started to try to wrestle him and fight him off of me, kick and do whatever I could, but I got the knife and I just started. She said in her testimony, she kicked him, she kneed him, she got the knife. She says to Proc, I tried to wrestle him, fight him off, kick and do whatever I could, and I got the knife. And the state stands here and asks you to convict a young woman who's in a fight in the backseat of her car, struggling to survive. And they say, no, she said she pulled the knife from him. No, she didn't. She didn't say that. She never said that. She said she kicked him, she fought him, she got the knife. Ezra's testimony about Alex. They say, well, she's never said anything about Alex before. If you remember from the testimony, she interviewed with Investigator Proc on March 1st. And on March 1st, she talked about Alex. They were saying what happened with John, and then she said, after I saw John, I went and saw this other friend, Alex, and something happened, and it hurt. It's unclear what she said by hurt, but she said it hurt. She says that on March 1st. On March 23rd, when she speaks with Investigator Proc, on page 14, she talks about it, where she's talking about Alex. And she says, line 609, let's go through it. What were you scared of on line 599? Being hurt. By who? Alex. By him doing what? Him harming me, making me want to do something he wanted. He was upset, all right? And then as she says at the end, on line 616, he would kind of get upset when I was too sensitive or in pain and stuff during those interactions, during sex. She told him Proc on the 1st that sometimes this happened. She tells Proc on the 23rd that sometimes this happened. She tells Proc on the 24th that sometimes this happened. She tells you in her testimony sometimes it happened, and they get up here and say, she's never said this before. She didn't say it all before. She does say it. She says it there. She talks about his journals as well. So let me just... We went through the gist, right? Let's talk about the state's theory just a little bit. Because one of the first things that the state talked about in their closing was, just make sure we get the law right. The first charge the state stood up and argued for, they're saying she had the intent to kill, right? Bottom of the instruction, intent to kill, that she had the mental purpose to take the life of another human being or was aware. Those are two ways that they can prove intent. She's never said she had the mental purpose whatsoever. She said all along, I wanted to get him off. I wanted to get him away. I didn't even want this to happen. I didn't want any of it to happen. That wasn't her mental purpose. And then they have to say that she was aware. Not that she should have been aware. Not that anybody else might have been aware. Not that a reasonable person could have been aware. They have to prove actual awareness of this young lady in that moment, at that time, in order to prove intent. And I submit to you that they can't. And that's why they made the argument that they did. Because if you read the law, she had no intent to kill. She didn't have it. She wasn't aware of it. On the next page, on page 5, when it talks about deciding about intent, right? Intent to kill must be found, if found at all, from her acts, words, and statements. Certainly not from her words. It's certainly not from her statements. And it's certainly not from her acts. Her acts are, she stabbed him until he stopped. Once he stopped, she stopped. When she left, he was still alive. We know that because when she left, he was on the ground and he got up and he moved. She didn't have the intent to kill him. Talked about some of this. They talk about her evolving story, and I need to go through this, I know, but what are they, again, we talked about the different plans that she said that they had. She went to Sipples, fakes this dissociative episode, pretends to lie about this all, because she doesn't want anybody to see the scene, right? And then she lies about Owen Park. Read the transcripts. She doesn't say she was at Owen Park. She says, maybe I was. She talks to Reeves and the people at the hospital about a park. She doesn't say she was there. There's some confusion, no doubt. But this theory that she's trying to keep them away from the scene, all right, is contrary to their own theory where they say she staged an event so she could set up self-defense. If she staged the event to set up self-defense, why wouldn't she just go and tell Farmer Sipple, I was attacked, he's over there, he tried to rape me, he tried to do this. That's, their theory makes no sense. It undercuts their own theory. They talk about her purpose is going there to confront him, to get him to change his mind. Again, use your common sense. If I want to have a relationship with a person like Jason Mengel, why would I need to worry about somebody that's over there? They're not in the way. She saw Jason Mengel that day. She wanted to be with Jason Mengel. She could have been with Jason Mengel. Alex wasn't in the way. She didn't have to confront Alex to get him out of the way. Her and Jason were fine. They'd been talking back and forth. They were fine. They had like 637 texts the day before, Instagrams the day before, that I'm sure they're going to get up here and talk to you about, right? But then why would she be worried about somebody that's off over there? She didn't do that to confront him. She's there for 45 minutes beforehand, and everything's fine. Their whole plan about she goes there with the knife in order to do something, a house full of guns, and 5 foot 2 inch, 120, 130 pound woman says, I think I'm gonna go kill somebody and I'll get in a hand-to-hand combat in the backseat of a car out in a rural secluded area. That's their theory? That's what they say happened? Does that ring true in any way, shape, or form? Is there any evidence to even support that? Frankly, it's ridiculous. They tried to impeach her with the car getting stuck, right? Well, why didn't she just back up? If you recall pictures from the scene, all right, as you see, she's driving up, somebody's driving up, Alex driving up, hers driving up, and we'll talk about that later. These are glared, so. There's no vehicle that gets stuck on the way up on the top of that hill, right? The car gets up over the hill, and then as you heard the witnesses say, then there's southern exposure, and things are softer and warmer, and then the car gets stuck. And once the car gets stuck, a car gets stuck. He's like, well, you should have turned around before you got stuck, but they didn't know they were going to get stuck until you're stuck, right? And so the car gets stuck. It doesn't even make sense. And then he says, well, she should have done something. She should have asked for help. She doesn't have a phone, if you recall. I doubt there's wireless out there, right? She doesn't have a phone. They try to say that she must have had some guilty intent because she didn't do what her dad said. She didn't do what Jason Mengel said. She drove into Eau Claire. 20-year-old woman with her own car, driver's license, decides to go to Eau Claire. Her dad didn't want her to. Fine, fair enough. That doesn't mean because a 20-year-old doesn't do what their dad says that they're some evil intent. She's never said anything about, they talked in here about scratching boy into her arm on the road. That's not what she said. She's never said that to anybody. She didn't say that to you. They talk about Joe Carlin and the knife. She's got 3 knives in the car. There's just knives in the car. She's trying to set up some attack. Why would she have some of the other knives? Why would there be knives in the trunk? If they have some evil intent that she says that they have, why would she have just left some of the weapons there? Doesn't make any sense. She doesn't ditch the knife or the phone, right? If she has some evil intent, she wants to throw them away, she'll throw them away. They're right along the side of the road. Speaking of which, I think I forgot to mention before when we were talking about the clothes and the knife and everything like that, their theory is, because the knife doesn't have her blood on it, that somehow she wiped the blood off? Is that what they're going to say? Right? Alex's blood was on the blade, right? I believe the officer, the Kevin Scott said he took a Q-tip along the entire blade, from the tip all the way to the bottom, from the tip all the way down, and he found Alex's blood on there. All right? But what's the state's theory? The state's theory is she cut him and then cut herself. So if that's the state's theory, that she cut him and then cut herself, why wouldn't her blood be on that blade? It doesn't support, so I don't even know what their argument was, to be honest, because it doesn't make any sense. But what we do know is if he cut her first, and then she got cut, defended herself, his blood would be there. And then she does what she does with Boy. Let's talk about that for a second, because the evidence of her shirts, I think we've already got it up here. They claim it had to be when she took it off. This is the first shirt she's wearing, right? That's the flannel. There's a cut on the sleeve. Just watch. I got sleeves on my shirt, right? When I go like this, you know what happens? The sleeve comes up. So they're trying to say like she took off all of her clothes and then tried to cut through. No, there's a cut there. It just got pulled up. What's her next article of clothing then? is the sweater, if you recall, and the sweater's got holes in it as well. And we were talking about the sweater with Kevin Scott. Remember the size of that hole with Rich Day? And then I talked about this sweater and the size of that hole, how that was just a little bit smaller, but it was in the same spot. And then we have the blue button-up, which has a hole here, right? That's consistent with somebody starting in the outside layer, making a hole, making another hole, making a third hole. And then that's her, all right? That's never tested. That's in evidence, right? So we don't know whose blood is on any of that. But it could have been his blood got transferred onto that sleeve right there. Again, their arguments don't make any sense with the evidence. They talk about her wanting to lie so that she can buy time to clean up, right? What evidence is there that she couldn't have walked out of the hospital at any time that she wanted? There's no evidence that she couldn't have done that. She was in a hospital. If she needed to get out of the hospital, she gets out of the hospital to go clean up the scene. It's a ridiculous theory. Totally ridiculous. That she's trying to avoid to try to buy time for it. The phone fell apart. Again, she said she was running, phone fell down. Alex's injury to his head. You heard from Dr. Tovar, right? And just makes common sense about a fight. If you're in a knife fight, it's dynamic. People are going to be moving around. The fact that he got stabbed on the right side of his head, they say makes her guilty of stabbing him from behind. But he's also stabbed on the right side of his neck. Like, people move their heads all around at all kinds of different times. She doesn't know when and how it happened. That's not evidence that she did it from behind in any way. I'm looking at you. Now my right side of my head is exposed. I mean, that's what happens. And people are moving around in that situation. Their theory that that's what they're going to hang their hat on, that's what the hook that they're going to say, she must be lying because she couldn't have stabbed him in the right side of her head. That doesn't ring true. That doesn't make any sense. The center console with Officer O'Neill, they try to tell you that she doesn't open the center console. There's no evidence of that. Officer O'Neill never got up here and told you that she did not open the center console. That's not what he said. He never said that. Check your notes. Check your memory. He didn't say that. That's what their theory was, is she wasn't willing to open up the center console because she didn't want to expose this knife that was in the center console. She said in the tape, as you heard, I'm looking for it, right? You heard that in the tape. And she produced something. We don't know eventually, even in that picture that I showed you of the wallet in the front seat on the ground, nobody's testified. Oh, I take that back. Ms. McCandless testified that her license was in her wallet. Dr. Tillotson, I understand again about his testimony. Remember, he saw her for 20 minutes. 20 minutes. And his testimony was about, well, you'd have this type of injury. And their whole thing, you'd have this type of injury if you grabbed the knife and pulled it away. That's their whole theory was based upon that. If you grab the knife and pull it away, you're going to get cut like this. Well, we just went through what she said about the knife, right? She never said she grabbed the knife away from the blade. This is they're trying to misdirect you. They're not going on the facts. They're making stuff up. They're just making stuff up. Dr. Tillotson saw her for 20 minutes. He never came back, consulted any other evidence. He didn't say anything else. What she says, what the other doctors talked about, Dr. Tovar, Dr. Thomas, of somebody, it's dynamic, right? If your hand hurts, you got to pull it back. It could get superficial. It could be a defensive wound. Again, I put in here Tillotson, grabbing of the blade. Look at that. They talked about, I believe the state put up one of those pictures and said that her blood was on the clothes, right? I believe the only shirt that had her blood on it was the blue flannel on the outside. And as you can see here, her blood, I believe, was tested on the sleeve, right? So where she cut herself, her own blood was there. And then her blood is on this L1 stain that you can see in the other spot, which again, if her left hand is cut and she goes like that once, that's going to be her blood there. There's no other blood that they've tested on there because she's wearing that like a jacket and it's open. And this fight that happens in the backseat of the car happens quickly. And it's done, it's over. They're upright against each other, he gets out, and then it's over, right? He's not dripping, he's not bleeding in that situation, he walks away. It's not going to get blood all over her if she's trying to set up the scene. That's when it's going to get blood all over her. That doesn't happen. Speaking of which, his clothes. They want to talk to you about, well, his clothes, if you looked at the evidence, his coat had his blood on it. They stood up here and told you, no, it didn't. I submit to you that, yes, it did. The testimony that you heard from Scott, and I believe that's on Kevin Scott, Exhibit 339, item B4 is the coat recovered from the rear of the driver's side. All right, on Report 9, page 3, DOJ 806 of Exhibit 339, Alex Woodworth is the source of this DNA. So again, he got up here and said, Alex's blood isn't on the coat. Yeah, it is. Their own crime lab said it is. And their own crime lab came here and told you that it is. It had 2 marks in the back, but they're right, it didn't have marks here. It didn't have marks on the side. And what we know is Alex had been stabbed on that side. Yes. I submit to you, this is his sweater, right? That's the back of his sweater. His clothes are moving all over the place. He's got a coat on. His coat is open. He's stabbed in this area. It could very well have happened with his coat open, not through the coat, right? But we know he's stabbed here. If you look at the photos when we do that, I don't want to pull them up there again, but if you recall, it's on his side. That, look it up on the top there. You have my pointer? Thank you, Hannah. This is the back of the sweater, right? That's the upper right shoulder where they say he got stabbed in the back. This is the back of the sweater. There's the other stab mark in the back. These 3 punctures are in the back of the sweater. But he didn't get stabbed in the back on that side. He got stabbed on the side. Because when you're in a fight, when it's a dynamic process like that, your clothes are moving all over the place. And so for them to say she must have stabbed him when he didn't have his coat on makes no sense with the sweater evidence either. Because according to them, he'd have 3 puncture marks in his back. But he doesn't. That's on the side. Because you know what? Clothes move when you move. Especially if you're moving quickly and a lot. The clothes are going to be moving all over the place. Some of this I've covered already. The clothes are moving. I don't want to belabor the point, just... So lastly, let me talk a little bit about the scene, because they might come up here and talk about the scene. So if this is the car, right? I'm going to just put up the picture of the back seat of the car, if I can find it again. This is the picture I want. This is a big blood stain, right? That's the big blood stain. Alex gets out of the car, he walks around, he lays down, as Ezra said. He's got his coat off at this point. That's how the coat gets off. He doesn't take his coat off in the car. He gets back into the car and then he sits down on the edge of that seat. Sits down right like that. That seat is that seat. That's what this is, right? And then at that point, he's moving around in the back seat. I submit to you that, where's the front seat with the marker 33? That's the driver's seat, right? So if this is the back seat, this is the front seat, that is right here behind me, right? So if you're sitting back here, you need help. Alex was up, he got into the car, he needs help. He puts his hand on the driver's seat and he pulls himself forward and he tries to honk the horn, right? Because we know his blood is there on 33. We know his blood is there on 31, right there. And it's not anywhere else on the seat. How does his blood get there? Because from the back seat, he reaches forward, tries to honk the horn. That's what explains that. And then, on the other side, we have the painting, right? And his blood is on the painting here. His blood is on the painting in this situation. Well, if that painting was sitting up in the seat, this is the front seat and that's the painting, he puts his hand here, he reaches over, knocks that down, goes to do that. That explains the blood there. He's not in the front seat with the blood, he's not moving around after that. The state's theory makes no sense. That makes sense. That's how we explain that evidence, right? So I'm probably overstaying my welcome, and I need to move on to talk to you about what I think are probably the two most important things. So, Judge, I probably have about a half hour left. I know I've been talking for a while. Happy to go on.
I think we need a break.
I don't need a break. I'm asking if anybody else.
All right, anybody in the jury need a break?
Yes. I heard yes.
Here, yes, okay. I think we'll take a 10-minute recess. You think that's sufficient, Ms. Jones? Okay, all right. All rise.
Appreciate your patience. I understand this is long. I only get one chance. I only get one chance to stand up here and talk to you about the last 15 days. I only get one chance to make this last argument, this last fight for her life. So I appreciate that it's long, and I'm sorry that I might stay up here too, but I don't want to sit down. She's innocent. So if you'll indulge me, I want to talk about two more categories that I think are crucial to your doing your duty and coming back with the not guilty verdict. Because you've been here for 3 weeks, right? 3 weeks. And every day when we finish, the judge says, you can't talk to anybody about it. Don't talk to anybody about it. Don't talk to anybody about it. We're all talking to everybody about it. We're talking amongst ourselves about it every day. I imagine that they're talking about it amongst themselves every day. I imagine everybody out there is talking about it every day. And you haven't had that chance yet, right? But you're gonna. You're gonna go and deliberate. And if you do your duty, you'll find that she was acting in self-defense. And then on Monday or Tuesday or whatever day that is that you go back and you enter into the world, or Saturday or Sunday, you're going to see your friends. You're going to see your loved ones. You're going to see your work colleagues, everybody else. And they're going to say, where you been? What you been doing? And you can get to tell them, well, I was on this jury, right? I was on a jury, on a homicide case, on an important case. And I'm sure they're going to ask you, what did you do? And why did you do it? And when you tell them, it's my duty to follow the law. And I took that serious. I took that serious when the judge says you have a duty to follow the law. And we looked at all the evidence, and when I did that at the end, I had to conclude she's not guilty. And they'll say, but how? How can you do that? She stabbed somebody. And you'll be able to say, you know what? She was acting in self-defense. And my hope is that I can tell you now so that you can explain it to your loved ones, your colleagues, everyone else out there. And you can be proud how you did your duty and you followed the law and supported the woman in a backseat fighting for her life, acting in
Objection, Your
self-defense.
Honor. Asking them to support someone is inappropriate argument.
Don't believe it is, but I'll move on, Judge.
All right, thank you.
To consider Ezra's beliefs, right? We talked about before, there's three things. First two are, does she have an actual belief? And before I get into it, I just want to talk a little bit about the instructions, right? Because there's 4 different counts that she's charged with, right? And so I think of them as, the first one is first-degree intentional homicide. We talked about that already. They have to prove that it's intentional, and she didn't have these beliefs. If you find, nope, she had these beliefs, then you move on to the next charge, which is called a lesser charge of second-degree intentional. And again, you'd need to consider whether it was intentional, which I submit to you, there's no evidence that it was intentional. The theory of motive is frankly bizarre. It's not supported by any evidence, certainly not evidence beyond a reasonable doubt. We talked about intent and her lack of awareness of that. At second degree, you need to consider whether it's intentional, as well as self-defense. If you find it's not intentional, you can then go and consider a different crime, which is first-degree reckless. And there's definitions of recklessness, and you also have to consider whether there's utter disregard for life. You might say, look, there's no utter disregard for life, and the judge defines it and how you can consider that, and then you'd have to consider the last choice, second-degree reckless, which would consider, again, cause of death, recklessness, and self-defense. But what I'll submit to you now, and which I want to talk to you about, is self-defense, and the way that I'm going to talk to you about it right now, washes all of those away. Right? So when you go back there and you deliberate, if you conclude she was acting in self-defense, you don't have to analyze intent, you don't have to analyze recklessness, you don't have to analyze all those other things. Self-defense, she's not guilty. So let me talk to you about self-defense, right? We said it was this belief. So what's the evidence that she had a belief? It's her actual belief, her subjective belief, her personal belief. Not whether she should have had it, not any of that, but those first things are, did she believe that? Well, we know this, right? So it's a state's burden to prove beyond a reasonable doubt. Meaning if you pause, remember a reasonable doubt is a doubt that would cause a person of ordinary prudence and intelligence to pause or hesitate when called upon to act in the most important affairs of life. It doesn't say stop. It doesn't say turn around. It says it to pause or a hesitation. So that's reasonable doubt, right? It's the state's burden to prove beyond a reasonable doubt she did not actually believe, 1, there was an unlawful interference, and 2, she needed to stab him to get him off and get away. Or, I think as the law calls it, right? That she believed the amount of force she used or threatened to use was necessary to prevent or terminate the interference. So what's the evidence that she believed it? What's the evidence? The evidence is, at Farmer Sipple's house, she told Farmer Sipple, I was attacked. She said, I had to get them off me. That's her first words when she's in this dissociative state. Hyperventilating, hysterical, crying, uncontrollably sobbing, we heard from witnesses. You heard it yourself. In that state, she still says she was attacked. She had to get them off of me. That's her belief. At Farmer Sipple's house, what's her appearance like? Second thing to consider, right? We have her words, and the state says, but those are just her words. Those are just her words. Don't believe her words. Well, fine, let's look at her appearance, right? Everybody says she looks like, my words, she's a wreck, a total and complete wreck. Again, she's crying, she's sobbing, right? She sounds hysterical. She looked hysterical from all the witnesses. This isn't just her words. This is her appearance. This is her demeanor. This is all of it. All of it. She was scared. That's her actual belief. Dr. Benson's diagnosis, right? He says it's consistent with, or it's because of trauma, right? Now, we don't know what trauma, sure, fair enough. We don't know what trauma it is. But it's certainly consistent with her having that belief. His diagnosis is consistent with that. At the hospital, same thing. Her appearance, her behavior, her statements talk about her belief. She was scared, she was attacked. On March 23rd, her statements to Proc that we talked about already, she says 9 different times, and we've gone through that, how she was scared. On the March 24th, she talks about how she has these intrusive memories, right? She was, and I think it's on page 55. I'll just read it to you. Line 2499. Because it was just so scary and I can't get it out of my head. She can't get it out of her head because it scared her to death. She's never fought like that before. That's what she told Brock. Listen to the recording. She says that on the recording. I don't think, this is where you have to listen to the recording, all right? She says it was because she was scared. Intrusive memories consistent with her having this fear from the trauma. Again, also on the 24th, she consistently says, she tells him about the attack. She says how she was scared. It starts on page, you may want to review the records when you go back there. You may not. That's going to be up to you. Maybe you won't need them. But right from the get-go, I believe it's on, well, I'm going to use my version because it's easier to, it's marked up. Line 1790, starts on page 40 at the top, right? 39, line 1775. What, actually even before that, line 1754. What do you remember? This is where it starts. Her first words when she starts to disclose it. I remember being really scared and in a lot of pain. She then goes on, what happened to Alex? She says, I got him off me. Line 1781, it's just really painful. It's not clear there whether she's talking about the pain of talking about it or the pain of what happened. She says, it's just really painful. Then they ask, basically, what happened? She says, he grabbed me again, he put me in the back of the car, he seemed really upset, and he kept grabbing me, and I didn't know what to do. He started cutting my pants. 1808, he started cutting my pants. I didn't know what to do, and it was really scary. And then he started cutting my shirt off me, and I didn't know what to do. And I went to go make him stop because he had this arm. And then she goes on, and she talks about how she was grabbed and she was afraid. She was afraid and she was grabbed and she was attacked. And they're going to attack her again. But the gist of it is, and these are her central details, the gist of it is, she had that belief. She believed something was happening, and she believed she needed to do that. That's what she believes, that's what she says on those dates. We already went through, are her beliefs supported by the evidence? The evidence is, I submit to you, there's a fight in the backseat of the car. That's consistent with her having this belief, right? She had those actual beliefs. Now, Dr. Hopper also testified about what happens to the brain under attack, right? The defense circuitry and how the amygdala takes over and it's the reflexes and habit, but that's because of the stressor. That's the stressor that happens. She had that fear. She had that belief. That's consistent with the evidence. Alex's journals. There's an instruction on how to use Alex's journals. Let me just say this. This case is about Ezra McCandless's state of mind. I understand that it also involves a young man by the name of Alex Woodworth who lost his life. This is a homicide. It doesn't get more serious than that. And it's tragic. As Ezra said in her statements, she didn't want it to happen. And there's a death of a young man. And his parents, his family, they've been here a whole week, 3 weeks. And I just want to acknowledge, I'm up here speaking of their son, right? And I don't mean it in that way. I'm sure it feels that way. But we need to talk about some of this stuff to try to figure out what was Ezra McCandless thinking. But I want you to follow that instruction. This is not meant to disparage or label Alex Woodworth as a particular character or person, right? I know from the evidence what Ezra McCandless has said he said. We know what he wrote. We know what she says happened in the backseat of the car. I want to talk to you about that. But I just wanted to acknowledge we get it. And I think I'll move on. But his journals, right? She had a belief. And her belief in some way was based upon his journals. And you'll recall from what the judge says the instruction is, a belief may be reasonable even though mistaken. Right? A belief may be reasonable even though mistaken. You have heard absolutely no evidence whatsoever that Ezra McCandless is a philosophy major. That she has a degree in philosophy or a master's in philosophy, or that she's an expert in philosophy, or Kierkegaard, or Derrida, or Caputo, or anyone else for that matter. And we could go on and on down the list of philosophers. We don't have the evidence about that, right? We know what he wrote. And I'll tell you this, it's confusing, right? I don't know that anybody necessarily understands it. But the point is this supports that she would have that belief. Might have been wrong, I'm not here to say that our interpretation or the state's interpretation is right. I think to some degree, that's beside the point. The point is, there's some stuff in here that I think needs to be interpreted, and it's some scary stuff. It's not your everyday writing. I think we all agree with that. It's not typical. It's not usual. I imagine that none of you have ever read or had friends read to you their journals about cannibalism. Right? But in the end, he writes about this. Metaphorically, literally, he writes about some stuff in here that might cause a 19, 20-year-old woman, she was 19 when she met him, 20 years old at that time, to start thinking at some point, and not initially, right? We understand she went to his house, she wasn't afraid of him on the 22nd. She got in the car, she wasn't afraid of him. She wasn't afraid of him until the knife came out and the words attached to the knife she started to hear. And that's when this stuff starts flooding into her mind, as it would, I imagine, anyone. So let's just talk a little bit about this, because the state talks about the journal from December 20th, desire and will, and how this is the true meaning of his journal, is this one entry on December 20th. Might be. And that portion of it from DOJ 2531 reads, love and do as you desire transforms into infinite obligation. It says, if you actually love, you'll give and give. No matter what your love asks for, that is your desire. Is he talking about himself, or is he talking about Ezra? Is he talking about himself, or is he talking about Ezra? If you actually love, you'll give and give. No matter what you love asks for, that is your desire. Because you remember, she testified and talked about how he would test her, push her to be vulnerable. Close your eyes. Be blindfolded. No safe words. You need to basically fully, completely, and totally commit to this. And for reasons that are perhaps unique to Ezra, perhaps they're not unique to Ezra, she maybe didn't always want to be completely and utterly, fully vulnerable. Right? So this meaning, this interpretation, it may be that Alex is looking to give, but it may be that he's talking about what he expects from somebody else. If you love me, you need to give me all of this. You need to give me. You need to give me. You need to give me. Because we know what he writes in other places. On 25:11, there is love, so do as you will. Don't worry about self-control. Be excessive. If you want to, that is, there's nothing you ought to, anything goes. He also writes that. He writes, do as you will so long as you love, which gives far less freedom, as one cannot do anything when one loves, and love can cause quite limiting obligations. Later on February 3rd, he starts talking, I love you all, each and every author, reader, writer, you. Know that, whatever becomes of me, for this unconclusive postscript is my suicide note. It will only be found post-mortem. Always prefer life and never stop affirming survival. I love you and am smiling at you from wherever I am. That was from Authors and Others from February 3rd, 2018, DOJ 2566. I'm smiling at you from wherever I am. That's what he writes in February. Previous to that, in January, in Giving Space, on DOJ 2546. Say that I come to absolutely know you, but you do not know me. In this I gain complete power over you, and you will lack the ability to resist me. This is the case even if absolutely knowing was reciprocal. Later, or previous to that, on November 24th, when probably writing about Ezra, on DOJ 2501, he writes, I am not even sure that I do love you, yet I feel that I can do what I want, which is, I suppose, a sort of indication that love is occurring. These are the things that he wrote that she had read or had heard from him. So when she says she had certain beliefs, that he said these things to her as well, this corroborates that. They're like, well, how else would anybody know what he said to you? Well, that's fine. But he wrote it. He wrote it. If he wrote it, it's a reasonable hypothesis, consistent with the evidence, that he said it. And that he said it to her, if he's writing about her.
I guess I just want to point out that there is some type of pink note on the front of what counsel keeps showing to the jury, which is clearly not evidence.
Okay, very good. Note is removed.
So to then say she didn't have this belief, her belief is supported by the collateral information. She says she believed this because there's a journal out there that says it, right? And again, she may not have believed it before, but when there's a fight in the back seat of the car, and the person that's got the knife is saying things to you, and it's consistent with what they've written before, and it's consistent with what they've told you before, that supports the fact that she actually had that belief. Their theory is she's just making that all up. And of course, the belief makes sense if there's a fight in the back seat, right? And we've went through already, established, there was a fight in the back seat. There's a fight in the back seat. The reasonable hypothesis is a person in a fight in that back seat would have those two beliefs. The one leads to the other. Her beliefs, and this is where we get to it before, is the gist of it, right? Her testimony, her statements, or as the state would say, her story, right? In some pejorative sense, like all of a sudden that's a bad word. She's not making anything up. The gist of what she says is consistent throughout. She was attacked. She was scared. She believed she had to fight for her life. She had those beliefs. You find that the state can't disprove that. If the state has not convinced you beyond a reasonable doubt that she had those two beliefs, then you have to find her not guilty of first-degree intentional. You have to. You're required. Then the last bit is this. Her beliefs were reasonable. Right? And we talked about that before. So I want to find the part to put up on there, the standard for you to consider when considering whether her beliefs were reasonable before I go through this. So, were her beliefs, well, let me say this too before I move on to that. Because one of the things the state's going to say is, you know what, she's a faker. They've said that already, right? Don't believe her because of her demeanor when she gets up on that stand. That's what they said, right? They say, put a camera in this young lady's face, put her on trial for 15 days, judge everything that she does at any moment, any time, because if she does something, we're going to point it out to you. If she cries, she's trying too hard to cry. If she doesn't cry, she's cold-blooded. If she has this emotion, she's guilty. If she has the opposite emotion, she's guilty. If she has the middle emotion, she's guilty. She couldn't do anything, no matter what she does. No matter what she does, they say, that's proof of this. Yet we know from the experts, response to trauma is unique to every individual, right? Who amongst us could say how a person would respond in that life-threatening situation? Who amongst us could say how a person would, could, should respond when they're on trial for their life at 20 years old, with cameras all over the place, a professional, experienced lawyer cross-examining her about any little thing that she's ever said or done or picture shown anywhere or man she's ever flirted with or had sex with. And then they have the audacity to get up here and tell you, judge her based upon her demeanor. judge her based upon her emotion. That's fine. The cameras do that all the time. Whatever. Let them do that. That's not you. It's not how we do business. That's not in a court of law. You should consider all of those things under jury instruction 300 to determine her credibility. But remember, she was 20 years old. She's fighting for her life. She's got 1 year of college and she's up on that stand. And no matter what she said or did, her demeanor is going to be criticized by the prosecution team. A team of professionals who get together every night to try to figure out how they could show she's this faker. But they haven't done that. Is this, usually it says a reasonable mistake. Apologize, sorry, there's a lot of laws here, right? All right, so we're going to get that in a moment, but let me tell you what the evidence is regarding the reasonableness of her beliefs, right? Because it's, again, under the circumstances at that time, and it's reasonable even if mistaken. So those are the two lines that you need to look for, and I can find it right there. Here we go. A belief may be reasonable even though mistaken. The reasonableness of Ezra's beliefs must be determined from the standpoint of her at the time of her acts and not from the viewpoint of the jury now. The standard is what? Oops. A person of ordinary intelligence and prudence would have believed in the position of Ezra McCandless at the time of the alleged offense. That's the standard, right? So let's look at it. Under these circumstances at that time, what's the place? Back seat of a car stuck out in the middle of nowhere with a man with no phone, alone. That's the circumstances. Back seat of the car, stuck out in the middle of nowhere, right? What else should you consider, right? Alex's words. What did Alex say? She got up here, she told you. He said, I deserve you. Believe, and I want to make sure that I deserve you one last time. That's what she testified to. Those were his words. And you might say, well, I mean, there's the issue. Did he say that? And we talked about that. Read his journals. What was his statements that he's made in the past? Is that what I would consider, I think you should think, is that a credible threat?
Your Honor, I'm going to object. The counsel is arguing that they should use the journals as propensity evidence, which is improper.
Sustained.
I didn't mean to imply that. If I did, I apologize. We've talked about the journals. The journals support her belief is what I'm trying to articulate, right? The journals support her belief that it's reasonable, meaning she's read his journals, she has this opinion. Might be wrong, might be right, but it's reasonable from her standpoint to say this is a credible threat. This is a person who's wrote these things and said these things to me. And now he's in the car, in the back seat with a knife, and he's making statements. That's a credible threat. And they're, as I said, they're credible because of what she's read and because of what he said. And now he has a knife. And we went through the whole issue about who has the knife, all right? Who had it first, and I'm not going to go over that again. But I think the evidence supports he had the knife. He cut her clothes. We went through all of that. That makes her beliefs reasonable. He's cutting her clothes. He's cutting her. He's cutting her. The state says, don't believe any of it, right? She's got that injury to her leg, right? That's consistent with him cutting her, him stabbing her. We know that from Dr. Tovar. We know that from Dr. Thomas. Dr. Tillotson, granted, he gave his opinion after 20 minutes. And if you recall, what he said right away at that time was, it's all about boy, 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 boy. Here's this woman who comes into his office, and he says he wants to care for her to get her the help that she needs. And she's hysterical, she's not making any sense, and she's got the word boy carved in her arm, and from there, it seems obvious she did that herself. How much analysis is going on the other stuff? Who cares? At that point, it's like, I want to care for my patient, let's go and get her some help. Because whether these happened by her or by somebody else, this, he concluded, happened by her, send her up to the hospital, get her the treatment he needs. That's the 20 minutes. I appreciate that he had that opinion, and his reason was because he wanted to help her, but think of it in that context. He doesn't get information after the fact. He doesn't get the pictures later. He doesn't get the marks that show the puncture wounds later. He doesn't get to see the clothes. He doesn't read the journals. He doesn't see the other, the scene. He doesn't see any of the other evidence. That's consistent with him cutting her. He's cutting her. Her beliefs are reasonable. He's not letting her out, right? And that's, again, even if mistaken. There's a fight. It's in the back seat of a car. There's not a lot of space. The door's open. There's one way out. She's trying to get out that door. Maybe he's trying to get out that door. Maybe he's not. I don't know. But two people in a small space, they're going to be bumping, hitting, going up against each other. If her belief is, he's not letting me out. Because she's, as she said, I think at one point, she's freaking out. As well as she should. She's in the backseat of a car with a guy with a knife who's maybe just trying to use this as knife play and a sex thing, but she's not into that today. Don't want that today. Because I'll tell you this, and I think the state might come up here and say that. Consent in November isn't consent in March. Consent in December isn't consent in March. Consent in January isn't consent in March. Consent in February isn't consent in March. It is disrespectful and disturbing.
Your Honor, I object. The state's never argued.
I don't know what they're going to argue. It's his argument, Judge. I can make argument.
Well,
I can make argument just like I can make argument.
it's just, I'm overruled, just go ahead, but I don't believe that the state made that argument.
If they get up here and make that argument, the implication through questions was, she wasn't afraid before, she's agreed to this before, she liked prone position before. If the implication was there, that's not consent on March 22nd. Any person, doesn't matter their gender, gets to decide that on an individual day. And they're in this small space, he's got a knife, she tries to get out, he's not getting out of the way. She talks about in her statement how she tried to scoot around through the side. Her beliefs are reasonable even if mistaken. He's not letting her out. Another reason, Alex is strangling her. We've seen the neck mark, right? I showed you the mark on the neck. She says he's got his hand up against her. He's pushing her head up against the back of the car seat. Remember the car seat where the hat was? And there's punctures in the back of the rear of the seat from a knife, right? She's got the knife. She's trying to get out. He's not letting her out. He's holding her there. She can't breathe. That's a reasonable belief at that point to say, you know what? I got to get out of here. If he gets the knife, it's over. I can't get it. Can't get it back. That's a reasonable belief. Reasonable belief, another one. He's up and moving. I talked about this before. If he's up and moving outside of the scene, he's out in front of the marker 15, out by the front tire. He's alongside the other parts of it. He's up and moving. He's mobile. He's capable of doing all of that stuff. Then it's certainly a reasonable belief to say, I haven't stopped him yet. He's still moving when he's inside the car and they're fighting. That's a reasonable belief. And the type of wounds, right? They're going to talk over and over and over, like the amount of force that this was. And they're going to say 16, all right? But let's break this down a little bit. One of them is to the finger, and they don't know when or where. It's just, there's 3 to the neck, but I think all of the experts said it could have been 3, it could have been 1, depending upon that dynamic process, right? And then even Dr. Mills in her testimony, a few of them deeper, correct. Most shallower, yes. Most soft tissue, yes. So the amount of force on most of those, they weren't that deep. They weren't that hard. There wasn't a lot of force. Which makes sense, because if she's not stabbing hard enough, he can still fight back, and he is still fighting back. And what her testimony was is, look, I remember at some point a neck, and I remember the head, and it all stopped when it was over at the head. Which makes sense, right? But that's the reasonable belief part of it, is the number doesn't matter if he's still moving, if he's still attacking. She believes that he's still attacking. That makes it reasonable. The belief of her is reasonable, right? And while we're talking about his wounds, let me just say, this abrasion to his knee that we talked about before, about the back seat of the car, there's no testimony. If the state gets up here and tries to argue that that happened after death, post-mortem in some sort of attempt to drag him or something, first off, there's no evidence to support that at all. There's no evidence of that at all. His injuries, even despite that, he's still up and moving. Her testimony was she left, I think it's on page 54 of and she said he was not moving anymore once he's down on the ground. She left, she stopped, right? She thought he was dead. She left. She didn't go back to stab him anymore. Now I know we have the stab outside of the car, right? There's the fight inside the car, and then he gets out and he wanders around and she sits at the edge of the seat and he's there. And the state says, well, that makes no sense with what Dr. Hopper says, but their analogy was, is if it's a lion. Nobody's saying he's a lion. This is a human being. This is a human being that she cared for, that she had a relationship with, that she wanted to go and talk to so that she could see if they could sort some stuff out. Some stuff happened in the back seat that's horrible, that's horrendous, that nobody wanted to happen, she didn't want to happen. But then when he said, I need to help, I want to pee, I need to pee, I need to go to the bathroom, the amygdala is not there now. Things have now stopped. It's a different. And she reaches out to go and help him. She gets scared again, whether he's grabbing her to pull her down or whether he's grabbing her because he's going to fall down. It's reasonable for her to believe, oh no, it's all happening again. And as she says, she's in close to him and she reaches around and stabs him one last time. That's what her testimony was. She's going to make up some story. Why would she say that? Why would she talk about that? She'd initially told the police, Investigator Proc, right away, stuff happened in the car, I got out, I got scared, I reached around, I stabbed him. I think she said in the side, right? Whether that's on the left side or on the back side. But she left before knowing, because she stopped when she had to stop. Two other things. The reasonableness of this you can consider. Post-traumatic stress disorder. The judges said you can consider that in deciding the reasonableness of her beliefs. And what you heard from the experts and was uncontested is that's who she is. Under those circumstances at that time, we're talking about a 20-year-old woman with PTSD. Whether she had it in that moment, I guess I can't exactly say, but childhood onset trauma, he does say. Aspects of depersonalization, he does say. You can consider that in deciding a person under those circumstances. What would their reasonable belief be? What would her reasonable belief be at that time under that condition? And then what we know is Dr. Hopper's testimony about defense circuitry, right? What happens when the stress happens and there's a response and the defense circuitry goes on and the amygdala takes over and you're doing reflexes or habits. Her initial habits are to not fight back, are to freeze, to lay still, to let this happen. She doesn't say she's getting cut up, or she doesn't say she's fighting when she's getting cut up. She says she's laying there. She's laying there. And then at some point it's like, oh, and it changes, right? She gets cut near her vagina, and it changes. She says she rolls over, pulls her right leg over to protect herself, exposing her right outside of her hip. When it gets punctures, she starts fighting back, kneeing, kicking, right? That's the defense circuitry. And in that situation, it's not as if you're rationally thinking. Any person under that situation, that's what Dr. Hopper said, anybody, short of a Navy SEAL, certainly there's no evidence that this 20-year-old vulnerable woman had any training whatsoever. She's under those circumstances, at that time, those beliefs are reasonable. On day 2, I told you about a young lady who ran to a farmer's house and rang the bell over and over and over again. Now a farmer from our community opened the door, brought her in, found a chair, made a call, got her a blanket. She'd been hyperventilating, she'd been crying, she'd been sobbing. Remember his words, something along the lines of, looked like she'd been through a lot. He didn't judge her based upon her character. He had no legal obligation to give her the benefit of the doubt. But sometimes, perhaps the best among us out there in the world on a day-to-day basis are able to give the benefit of a doubt to another human being. And in that situation, Don simply did that. He brought her in, he did his moral obligation, he protected her, he took care of her, he gave her the benefit of the doubt. Now here she is, in front of you. She fought for her life once. She's asking you to do your duty. You only get one chance to do your duty. So go back there. Think about the case. Use care, caution, rationale. Remember what I told you about how you can use the evidence so that when you leave, you hand in that verdict form, that one verdict form that says not guilty, and one of you amongst you gets to take and sign that form and submit it to the judge. And you go home and you put your head on that pillow tonight, tomorrow, sometime, right? And then you wake up the next morning and you do like probably all of us do, right? You wander into the bathroom at some point, you rub the sand out of your eyes, as they say, and you look in the mirror. And you can be proud American, to say, I did my duty. I followed the law. And when this young lady had to fight for her life, and she was in trial and attacked again and again and again, you analyze that evidence and you see she was acting in self-defense. You know, there's a saying, and I'm sure I'm going to misquote it, but I'll paraphrase. Our communities are often judged by how we in the community treat those who are the oldest among us, or the youngest among us, or the weak, or the vulnerable. This is our community. Don Sipple is a part of our community. She's innocent. She's fighting for her life, acting in self-defense. She's innocent.
She's right.
So I get to do a rebuttal argument to essentially rebut what the defense states. So it might be a little disjointed, but I'm simply just responding to some of the defense's arguments. When you think about this case, there's a saying in law school that when the law's on your side, you argue the law. When the facts are on your side, you argue the facts. And when neither the law nor the facts are on your side, you distract from the truth. And ladies and gentlemen, that is what the defense has been doing for the last 3 weeks. Trying to distract you from the defendant's lies. Trying to distract you with Alex's journals. When you go back to the first week of testimony, witnesses are up in that witness stand testifying about what they saw, what they heard, and the defense cross-examines them by reading from these journals to distract you. Just like the Soren Kierkegaard book, to distract you from the cover. When the defense mentions these journals, it's important to note that the defendant admitted that these were metaphorical in nature. She knows they're metaphorical. And when you consider whether she had this belief that Alex was this type of person, you got to use your common sense. If she was afraid of Alex, would she have drove out there that day to see him? Would she have walked into his house, gone up the stairs, shut the door, sat on his bed? Would she have said, let's go in my car, let's go for a drive? No. The defense is trying to use these journals to distract you from the defendant's statements and what happened that day on March 22nd. The defense had a number of experts. We spent a couple of days talking about psychiatrists and psychologists, talking about how brain circuitry works. But let's call a spade a spade. The defense hired professionals to try to explain away the defendant's repeated lies and try to make the facts in this case fit. So I'm going to go through some of the defense's closing arguments. And they talk to you about reasonable self-defense and what the self-defense standard is. But there's nothing about the defendant's statement that is reasonable. Her statement does not match the crime scene. It does not match the physical evidence. When you consider the reasonableness of her statements and of her actions, you need to ask yourself. So she testifies that there's this fight in the backseat of the car. Despite the fact there's hardly any evidence of blood in the backseat of that car. And then she wants you to believe that after this person, Alex, has attacked her, that she goes out there because she's a nice person to help him pee. That is not reasonable, ladies and gentlemen. If you are afraid of someone who just attacked you, such to the fact that you had to stab them 15 times, you get the heck out of there. You run and cry for help, you take that cell phone and you call 911. The defendant doesn't do that. And that makes this self-defense argument unreasonable. The defense brought up this mud on the mud on the car. I know it's a little bit hard to see. And this is the defendant's statement when she testified in court earlier this week. And she states, yes, one of my boot had come off. Do you know which one it was? No. And did you later take off another boot? Yes. Had you done this at this point yet? No. So in order for the defense's argument to make sense, she'd be wearing her boot. She's not wearing her boot, and that is not a boot mark. That is clearly not a boot mark. The defense states that there's no evidence of a struggle when you look at the mud of the crime scene. There's no evidence of a struggle here outside.
Can I see that? Sorry.
I'm sorry, it's the...
Can I see the DOJ number?
Judge, can we approach?
Okay, so the defense is talking about how there was not any evidence of a struggle in the mud outside the car. But then you need to remember that she told Detective Prock in her March 24th interview, the first place she thinks she stabbed him is in the head. And when you look at that stab wound, you've seen it enough, I'm not going to put it back up there, it's angled towards someone coming behind them. And then you think about the amount of force to go through the temporal bone, the amount of force. And so Alex is outside, and the defendant comes behind and whacks him right in the head, through the brain, through the temporal bone, completely disoriented him. And there's no evidence in the mud, according to the defendant's story, that Alex was laying on the ground. There's no handprints of Alex laying on the ground. There's no mud area showing that Alex was laying on his coat. The defense tells you that you heard the defendant in hystericals. She was hysterical in that squad video of Trooper Knutson when she went to Don Sipples. But you need to remember the testimony of both Don Sipple and Emmer Shields. No tears. In fact, Deputy Shields testified that she was trying to be upset. Jolee asked her about specifics, and she's able to say, Jason Mengel, a medic. M-E-N-G-E-L. Jason Mengel, she's able to remember. The defense tried to state in their closing that the state said that Alex opened the car door. The state has never said that. The state has never alleged that Alex opened the car door. In fact, so these little stickers are indicating the DNA results. Alex Woodworth's DNA is on the handle. He's getting in that car to get away from the woman who's stabbing him to death. He's trying to pull that door shut to get away from her. The state never alleged that Alex tried to open that door. The defense then argued about Alex's pants, but you need to remember the testimony of Dr. Mills. She testified that the blood on his pants was not consistent with someone standing up. Rather, it was consistent with someone sitting down when you looked at the rear.
Judge, objection, that's not what she said. That's the mistake.
Well, it's up to the jury to decide what she said.
The defense also stated in their closing argument that if the defendant was concerned about getting rid of Alex's body, getting rid of the crime scene, that after she was in the hospital, she just would have gotten up and walked out of the unit. But that is also a misstatement. There was testimony that she was in a locked unit. She was not able to go back and fix the crime scene, and that is why she had to resort to Plan B when Detective Prock confronted her. The state has never claimed that the defendant carried Alex. The defense argues that, so the defendant says that Alex is outside of the car when she leaves. That's what she testifies, or what she tells to Detective Prock on March 24th. She states he's laying on the ground, laying on his coat, and I think he's dead or something. When she testified here in court, this was a news story. A news story where she states that she stabbed him 15 times in the car, and then he goes over to walks away, and she goes over to help him pee. And this is just ridiculous. It's not reasonable. This is when you use your common sense. The defense talked about, do you have a picture of the crime scene? Could I have this screen? So the defense talks about the footprints at items 4 and 5. And the state does not dispute that Alex was back in that car. That has been the state's theory. And that is what the evidence shows. That when you look at all the blood outside that vehicle, he was stabbed outside that vehicle. And as I said earlier, she came behind and absolutely disoriented him, and then stabbed him in the scrotal sac across the neck and took him by surprise. He goes in that vehicle. Of course his footprints are going to be there. His footprints are facing in that car so he can get away from the woman who is stabbing him to death. I'm done with this screen. The defendant's own expert, Dr. Tovar, testifies that Alex's wounds could have been post-mortem. Their own expert, Dr. Tovar. And then they talk about how if she had really committed this homicide, if she had killed Alex, why did she go to Don Sipples? Because her car was stuck. She had no place to go. So she goes to Don Sipples. The defense tried to infer that the state used this John Hanson information as an attempt to attack the defendant's sexuality. That is not the reason why the state used any of that evidence. The state did not call John Hanson because this case is not about John Hanson. This case is not about Jason Mingle. This case is about Alexander Woodworth. That is why he wasn't called. The only information that you got about John Hanson with respect to the text messages, which were sexually explicit, was in response to the defendant's statement that this was a BDSM case, which is, again, new when she testified, that this was some sort of BDSM. And if you remember that text message of John Hanson, it's about, wanting to get tied up. That is why the state used that evidence, in no way to judge the defendant. The defense in their closing statement talked about the knife and the DNA on the knife and how the defendant's blood, we don't know whose blood is on the handle. But we know that there's blood on the blade and that it's Alex's blood. But you need to remember that the defendant she absolutely admits she carved Boy in her arm after she stabbed Alex. After she stabbed Alex, she uses that knife. So the defense is just trying to distract you. There's no question that she used that knife because she admits she used it after she killed Alex. So I don't have the timeline, but Mr. Dufour went through the timeline. And we heard the defense come up here and argue, this happened quickly, super fast. But what happened for 2 hours and 50 minutes down that mud road? What did the defendant do? She staged a crime scene. Can I have the screen again? Sorry, Anna. That green trailer has the defendant's blood on there in 2 different spots, about 6 feet apart. How does her blood get there? You saw her wounds and scratches. They didn't even need a Band-Aid. So how do you explain that blood there? And how do you explain her blood on that door? A long drip of blood. This is the defendant staging that crime scene for the 2 hours and 50 minutes that she had. This is the defendant tearing her clothes, creating injuries, trying to get Alex out of the car. The defendant, sorry, I'm done with that, thank you. The defendant told law enforcement, nurses, medical staff that she was attacked. That she's scared and that she's attacked. But what doesn't she say? Anything about Alex. Anything about the fact that Alex is dead down that road. The defendant said that, or testified here in court at the trial, that Alex said, "I deserve you one last time." And go back to her interview with Detective Brock. When she is asked specifically, "Do you think Alex was going to sexually assault you or something?" And she says, "I don't think so. I think he just wanted to look at me." She makes no mention of, "I must have you one last time." This is a defendant who is continually changing her story to try and make it fit the facts of this case. The defense wants you to have a specific explanation for every piece of physical evidence. And that's just an unreasonable burden. The physical evidence is a huge part of this case, but what the state does is follows the physical evidence. And the physical evidence shows that this attack happened outside the car. Because you use your common sense. The blood is outside the car. I have the screen again. The defense in their closing was talking about the abrasions to Alex's knees. And this picture illustrates Alex's knees stuck in between the two seats. And his sweater pulled up. This is the defendant trying to get Alex out of that car and not being able to in the 2 hours and 50 minutes she had to try to figure out what to do after she lost it and killed Alex by stabbing him 16 times. Let's talk about the defendant's injuries. The defense likes these photographs from the SAIN exam, where they're distorted. I mean, it's bad lighting, they're not very accurate. But this is the next day. This is the defendant grabbing the blade of the knife. Defense stated that in her March 24th interview that she never pulled the knife. And she states, "How did you get the knife from him?" Respondent, "I grabbed it. I grabbed it from him and I pulled." Thank you. Can I go back to the screen? This is again a defendant who realized you can't have that type of wound from grabbing the blade of the knife. So now I'm going to switch my story around. And I'm going to say, I kneed him and then picked up the knife despite the fact that I can't see and I didn't have my glasses on. This is a defendant who is trying to distract you and trying to conform the evidence to the facts of her case. The defendant likes to talk about the mark to the defendant's neck. The next day, that mark is gone. This is from, March 24th. I apologize, it's 2 days later. March 24th, you do not see that mark. In fact, the defendant's own expert, Dr. Tovar, testified that that red mark under the defendant's jawline could have been a rash. And then their other expert, Dr. Thomas, testified that a mark like that red mark from the SAIN exam wouldn't likely be caused by skin-on-skin contact. The defense wants you to say, this mark is from her being pinned in the back of that car. But she was never pinned in the back of that car. She attacked Alex from the back, and those facts show that. These facts show that. Jennifer Morris testified there was no petechiae in her eyes. She said in her experience, if there's strangulation, she sees petechiae in her eyes, and she never saw that in the defendant's eyes. I think I'm good. Oh wait, no one more on the screen. There's also this. The defense had again the SAIN one, which makes it look a lot different than it does there. And you need to remember this is on the right thigh, right where your hand would fall. And you see those long parallel lines and those two that are off to the side, which are parallel to one another. Okay, thanks, Anna. And when you consider the testimony of the defendant's experts in this case, let's take you back to Dr. Tillotson. Dr. Tillotson, who is extremely clear, these are self-inflicted wounds. And his description made so much sense. It's so common sense. I mean, if she admits that the bullet in her arm was self-inflicted, and if someone is holding you down, you're not going to get that same depth. And you compare the arm to the hand, to the thigh, to the groin, and they're all very similar depth. And then you go back into characteristics of self-inflicted wounds. Parallel lines within the non-dominant hand. She's right-handed, in the left hand, left forearm, right where she would reach on her right outer thigh, and in the groin. And albeit the groin is even less deep than the other And then you have to consider, so if Alex was cutting the defendant, as her story states, he's outside the car, he's cutting her in the groin through the clothes. He would have to, the marks go, I'm not going to show them to you given how late it is, but the marks go up towards the defendant's left side, up to the left. So in order for that to happen, Alex would need to be positioned over her using his right hand and curving it up. It just doesn't make sense, ladies and gentlemen. It doesn't make sense. And then you consider what Dr. Tillotson said about hesitation marks. How a person can get similar depth because, ouch, that hurts. Ouch, that hurts. But I need to put these wounds on me because I just killed Alex. And they're all of similar depth because as a hesitation mark, you know how to control. Dr. Tillotson, who has been a doctor for 30 years, said that he doesn't even know until he gets the scalpel in, and that's what anesthesia is for. Now the defendant's experts, Dr. Tovar, Dr. Thomas, want to say that these could be inflicted by someone else or they could be self-inflicted. But when you consider that Dr. Tillotson is not being paid, was actually trying to help his patient, and saw the depth of these wounds, and you use your common sense, it is clear that these are self-inflicted wounds. Very briefly, the defense talked about intent to kill, and that the state's motive makes no sense. The defendant's testimony is that she came over to Alex to try to be friends and try to get on, But I want to show you briefly the journal that she wrote. This is journal number 2 that she writes from the night before. She states, I would consider suicide daily. My mind would tell me I'm a failure and a monster. Become one of them. Told what to do and what to feel, using intellectual advantages against someone vulnerable and confused. I was so blind and followed the progression mindlessly. I was so close to ending my life. And this is how she describes Alex. I never gave their number or name in my contacts. I would look at them and not see beauty, but a big nose, a red nose too big for a face, where eyes looked dead, a brow jutting out of a large bulbous forehead, a smile that would make me cringe. Pores and veins stuck out on pasty, translucent skin, all felt like bugs under my skin. The scar on their wrist, red and deep. Who was I kidding when I lied and told them otherwise? That was the defendant's feelings about Alex the night before she killed him. Briefly want to go over the reasonable doubt instruction because the defense showed you part of it. I want to show you the rest of it because this part is important. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. The doubt which arises merely from sympathy or from fear to return a verdict of guilt is not reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth and give the defendant the benefit of a reasonable doubt if it arises in your minds after you've carefully considered all the evidence in this case. Ladies and gentlemen, there is no reasonable doubt. There was no attack on the defendant. When you look at intent and you ask yourself, did she intend to kill Alexander Woodworth? Absolutely she did. You can look at not only the number of wounds, 16 times that she stabbed him, but you can consider the locations in that intent. The locations in the back of the head, slicing the neck, the scrotal sac, in both lungs. That shows intent to kill. And then you can think of her actions after. She takes his phone, destroys it and ditches it, doesn't call 911, doesn't get help for Alex, That shows that she intended to kill Alexander Woodworth. So when you go back in the deliberation room, you're gonna have to pick a 4-person, and then you're gonna have these 4 different crimes for you to consider. But you start at first-degree intentional homicide. If you don't believe the defendant's story, there's no question. You stay at first-degree intentional homicide. Then and only then, if you cannot all reach a consensus, then you can go to second-degree intentional homicide. But the facts of this case show that this was intentional. At the end of the day, this defense relies on an admitted liar with everything to gain and defense experts that have no firsthand information of what happened in this case. Regardless of any motive, there is no doubt that she intended to kill Alexander Woodworth. The defendant viciously stabbed him 16 times and left him there to die. And instead of getting help, she distracted law enforcement. Go to Owen Park. Forget about the man that I just stabbed and left there to die. When you look at these wounds, this was not anger. This was rage, and this was personal. The defendant needs to be held accountable for her actions. The state has shown beyond a reasonable doubt that the defendant, the self-described Tricky Fox, has committed the crime of first-degree intentional homicide, and I ask that you find her guilty. Thank you.
All right. All right. Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and, as upright citizens, render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offense charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 5 forms of verdict will be submitted to you concerning the charges against defendant Ezra J. McCandless. 1 reading, we, the jury, find the defendant, Ezra J. McCandless, guilty of first-degree intentional homicide as charged in the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? Another reading. We, the jury, find the defendant, Ezra J. McCandless, guilty of second-degree intentional homicide in violation of Section 940.05 of the Criminal Code of Wisconsin at the time and place charged in the information. If you find the defendant guilty of second-degree intentional homicide, answer the following question, yes or no. Did the defendant commit the crime of second-degree intentional homicide while using a dangerous weapon? In the third reading, we, the jury, find the defendant, Ezra J. McCandless, guilty of first-degree reckless homicide in violation of Section 940.02 of the Criminal Code of Wisconsin at the time and place charged in the information. If you find the defendant guilty of first-degree reckless homicide, answer the following question, yes or no. Did the defendant commit the crime of first-degree reckless homicide while using a dangerous weapon? In the fourth reading, we, the jury, find the defendant, Ezra J. McCandless, guilty of second-degree reckless homicide in violation of 940.06 of the Criminal Code of Wisconsin at the time and place charged in the information. If you find the defendant guilty of second-degree reckless homicide, answer the following question, yes or no. Did the defendant commit the crime of second-degree reckless homicide while using a dangerous weapon. And the fifth reading, we, the jury, find the defendant, Ezra J. McCandless, not guilty. It is for you to determine which one of the forms of verdict submitted you will bring in as your verdict. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court, and the court may ask each of you if you agree with the verdict. All right then, Madam Clerk, if you would swear the officer, please. And also, the court is not going to sequester you, and I'll put my reasons on the record after you leave the courtroom. So what we'll do is you begin deliberating, and we'll ask you essentially for your input in terms of how long you want to go tonight. If you feel you're tired and you want to reach a consensus as a group, then we will retire for the evening and come back tomorrow. But I'll have to have all of you, including the alternate, come back into the courtroom for an instruction like we've had every day before we let you go home. I believe that you've been out and exposed potentially to things throughout this trial. I believe you've all followed the instruction, and I have no reason to believe that you would not continue to follow that instruction once you begin deliberating. But you may, again, and we'll cover that when that time comes, but we'll seek your input, and you'll be in charge essentially of how long you go tonight, okay? All right, swear the bailiffs.
Do each of you swear to keep all jurors on this trial together in a private and convenient place? You will not allow any persons to speak to them or to speak to them yourself, except to ask whether they have agreed on their verdict, and that you will not communicate to any person the state of their deliberation or the verdict they have agreed upon, so help you God.
I do.
Okay, all rise. Okay, pen. Okay, you may be seated. All right. Anything counsel would like to put on the record related to rebuttal argument?
No, Your Honor.
All right.
Sidebar, at some point I asked for a sidebar, essentially objected to the displaying of a demonstrative piece of evidence that I believe was a photo entitled DOJ 110 from the crime scene photos, and that underlying photo had not been marked or offered into evidence, so that was my objection. The state then took the down, but it was displayed to the jury for a minute or two.
All right, and is the, I haven't seen this, so I have no idea what it is. Is it anything different than what we, so many photographs in this case?
I mean, I'll admit, it's extremely similar to DOJ 111, which is a marked exhibit, but technically that photo wasn't into evidence, and so.
All right.
Yes, Your Honor, it's very similar to previous ones. When the state narrowed down exhibits, that was one that we must have inadvertently narrowed down. It's very similar. It shows an overview of the crime scene with the different marker numbers. It just, this one had the DNA stickers on it, so the state just then put the actual photograph that was very similar to it up on the screen.
All right. All right then. Anything further at this time? Okay, now I'm going to put on the record my reason for not sequestering the jury. Both parties have made it clear that they're not requesting that the jury be sequestered. The statute does give the court the discretion. There is, again, some concern when juries are sequestered that they may feel rushed in their deliberations, it may be less comfortable, and this group, in the court's opinion, they've been instructed every day not to discuss the case or research, or, again, they've been given the instruction every day. I'm not going to repeat all of what it is. Some days it was a shorter, improvised version. Some day, much of 150 was read to them, and the court is confident this jury will be dutiful and follow the instructions. And if they deliberate into the evening, again, I think the jury would be more comfortable being in their own home, in their own bed, and to come back tomorrow to continue their deliberations. Now what I would like is there's often questions, especially early on, requests for exhibits and that sort of thing. So if counsel is going to, if someone is going to stick around, okay. So we just want to be able to get everybody assembled as quickly as possible so that we can address the questions and the issues again as quickly as possible for the jury. And it's already 5 o'clock, so I imagine we'll be ordering some food for the jury, and then we'll give a period of time where we'll have a break where you can go and get something to eat if you wish. But if you do leave, we just ask that at least one member of the defense or the prosecution provide a number where the clerk can reach you. Okay, anything further at this time?
Judge, I do know some family members live a ways away. I just want to know, if and when a verdict, comes in, how much time you're going to allow for people to respond to the courtroom?
Well, that's a good question. I don't imagine, I'd like to get them in within 15 minutes or so of being advised that there's a verdict. People want to be here when there's a verdict, and they just have to be here. That's the building will have to remain open. We'll just make sure that that's clear. So people can come in and out, and I don't know yet how late we'll go tonight. So in the past, we've gone quite late on cases, so, but we'll leave that up to the jury. If they feel they want to come back and get a fresh start tomorrow, we'll honor that request. Okay, anything further at this time? Okay, thank you then. We'll be in recess. Be seated. All right, well, I've got a list. I don't know if counsel or approach one counsel from each. I got a list of the exhibits that the jury is requesting. I don't know what they are, so we have to go through them one at a time. Go through those?
Photos, Judge, and then there's a necklace and a leather bracelet, it's just a leather, so that's the main issue, what is it when they want physical?
Did they have any? I thought I looked at, they all looked like appear to be photos.
Number 500 is number 500, not.
Right here.
These are all.
Can you come in, they want physical evidence?
I think, well,
What is your practice in this county when jurors ask for physical evidence? I mean, I can tell you.
Generally in homicide cases?
I don't think you're seeing many of those. There's a different practice in Milwaukee County for physical evidence because in Milwaukee County, the bailiffs are always sworn deputies in the sheriff's department office, and the sworn deputies come in to the jury room. They retain possession of and let the jurors view the physical evidence, and then they leave with it. So it's different because you have civilian bailiffs here. That's why I'm asking what you
Yeah, I think we'll have to, I guess, discuss that on the record.
Right, I'm not taking it.
Wouldn't let them.
I'm just saying I have not.
Well, we're not on the record right now, so I think maybe rather than repeating, we ought to just go on the record.
That's fine.
can go through this. Okay. All right, so we're back on the record. It's 5:50 PM. The jury has sent a question out, a copy, or a request for exhibits, and a copy's been provided to each, the defense and the prosecution. The jury is requesting exhibits number 331, that's actually on the list twice. Exhibit number 3, exhibit number 6, exhibit number 174, exhibit 633, 634, 174B, which 174 and 174B are basically the same, 668 to 673, and then 662 to 667, so that really is like 662 all the way to 673. Then there's 308, 311, 312, 314, and 316 to 327, 329, and again 331 I've already mentioned, 642, and then 500. And my understanding is that there are either, most of these are photos or those transparencies they're requesting.
All except for exhibit number 3 and exhibit number 500, they're all photos. Exhibit 3 is the autopsy report from Dr. Mills, and 500 is the necklace and bracelet. Your Honor, the state has no issue with any of these being sent to the jury. As far as the necklace and bracelet, however the court feels the best way to allow them to view it is fine with the state.
All right, what is the defense position?
We're talking about something right now.
Okay.
I'm writing notes.
Judge, we don't object to the request of any of those exhibits being provided to the jury. To the physical evidence, number 500, the necklace and the leather bracelet, again, defer to Your Honor, but we don't have an objection to Officer Moen being provided the physical evidence to walk in there, and I trust he would do nothing other than this, so I'm not implying anything with him, but just he could go in there and show them, but he's not to answer any questions verbally or, speak to them in any way other than, to facilitate their observation of whatever it is they want to see.
So you'd be wearing gloves if you did that? I'm sorry, what? I assume you'd be wearing gloves?
Yes, sir. Again, if somebody else has a better idea, I'm certainly open to that, but we don't. Officer Moen wants to do that, that's how the court wants to handle it.
Okay, do we...
Your Honor, what I'd suggest is when the court sends in the answer that it explains that he'll be coming in, showing it to them, they shouldn't ask him questions, he won't say anything, he'll just show it to them, and they should not deliberate or discuss the case while he's in there. Of course.
Yeah,
Judge, the only other question, I guess, is 174, the version without, 174, I know that I think of it as 174, the non-blacked out version.
I'm not sure, let's take a look.
And so if that was not actually published to them, I don't think that they should get it. I think 174B is the one that they should be able to get, but I don't recall exactly.
174B definitely has the blackouts. Do you have a 174?
174A is the DVD.
I'm sorry?
174A is the DVD.
Oh, okay, that's the DVD, so I would just tell them that the only printed version is 174B.
But is 174B?
Right.
Okay, which would be the...
It's got the blackouts on it.
Right, that's what I meant.
Yes.
Okay,
I just looked at it. If you want to look, counsel, that's fine, but it does have them.
I believe you.
All right.
I just didn't know which was which.
Yes.
So, not 174?
Right, 170, and probably when you send the note back, maybe just say 174 is just the disc that has the images that are printed out that are in 174B.
Okay.
And they are black.
Okay, so my note to the jury with the exhibits will be dated today at 5:55 p.m. Members of the jury, I am sending in the exhibits requested except 174. Exhibit 174B will be sent in. 174 is just a disc that 174B was made from. Exhibit 500, physical evidence will be sent in with a deputy who will show it to whoever wishes to see it, but he cannot be asked any questions or give any answers. He will display the exhibit and return to the courtroom. Remaining exhibits on the first request will be sent in. Is that satisfactory to both parties?
That's fine, Your Honor.
Okay, well, I'll print that and then make that,
You didn't say that.
send in a copy and then we'll...
Your Honor, do you have, I'm sorry, was there anything on there about deliberation while he's in there?
About what?
About the jury deliberating while the deputy is in there? That should be on there as well.
Okay.
They should not deliberate.
Okay. Okay. Okay, so I add the sentence. There shall be no deliberations or discussion of the case while the deputy is in the jury room. Satisfactory?
Yes, Your Honor.
Okay. All right, then I'll print that. Okay, now we're printing the back. Okay, and then who's going to take the exhibits? Okay. Wait, I'll go and give them the note, and then I'll let the bailiff know that the deputy will be coming with physical evidence. Okay.
Thank you, Your Honor.
Well, we'll be in recess. All right, we're back on the record. It's now 6:50 p.m. We have a second note from the jury, received a short time ago. I believe a copy's been provided to counsel and by the clerk. And the jury is requesting the following exhibits: number 72, number 4, 635, 636, 637, 638, 4B, 696, 8 through 16, and 5 through 7. Okay.
Your Honor, as far as the state, first off, there were, as it relates to 5 through 16, there were only exhibits 9, 14, and 16 that were actually admitted. So those would not be there. 4 is the electronic version of the PowerPoint presentation of Dr. Mills. 4B is the printed version.
Okay, I have to have you go back a minute. So 5 through 16 only, which were admitted?
9, 14, and 16.
Okay. And then exhibit number 4 is Dr. Mills' PowerPoint?
Yes.
And what is 4B?
4B is the printed version of it.
Okay. And then what about 635, 636, 637, and 638?
Those are photos of the defendant. I'm not sure which series of them they are for sure, but they're photos of the defendant and some of her injuries.
And 696?
696 is Dr. Tovar's report.
And 8, or yeah, we already talked about 5 through 16.
Right. And 72, Your Honor, which we hadn't talked about yet, that's the scene outside at the crime scene, showing the car and some of the evidence, and a number of the evidence markers.
Is it a photo or?
It's a photo, yes.
It's the main photo of showing the markers 3 through 12, I believe.
Okay. So do you want to go through these one at a time, or?
We don't have an objection.
Okay.
And we don't have any objection to any of them either. Obviously, 4B would be the version that'll go, 4 being the disc, that would not go, but 4B, we have no objection to any of them going.
Okay, so. And I'll just note that what I am doing is typing a note back to the jury and stapling a copy of their note to that note. And then the clerk will get the original note with a copy of my note to maintain it for the record. And so I'm going to do a note here. And I'm going to ask them also to put a time on any the subsequent notes or questions that they have, so that we can keep track of them by the time. Is the Exhibit 4 on a disc?
I'm sorry?
Exhibit 4, is it 4?
4 is the electronic, 4B is the,
Okay, but is it in a disc form? If they wanted to see it, could we play it for them in the
I
courtroom?
apologize, this has a gold sticker that says 4 and a blue sticker that says 4B.
Okay. But is it, I'm explaining why I'm not sending them 4, so it's
4 is on a disc.
on a disc.
Yeah.
And do you have your computers in here if they wanted to come in and see it?
We can bring it.
Okay.
that's for 5 through 7.
No, we don't have them.
Okay, so this note, again, today's date, 6:54 PM. I'm not putting a case reference on it because it'll be in this record. It saves time. Members of the jury, I'm sending the exhibits you requested except for Exhibit 4, which is a PowerPoint on a disc that would have to be displayed in the courtroom. I am not sending that. Exhibit 4B is the paper printed version of Exhibit 4. Please put the time on subsequent notes so we can keep an accurate record. Thanks, Judge Peterson. Any objection to that
Do you
note?
want to put a note or include that, because you're only sending 9, 14, and 16 are the ones.
Oh, that's right. I'm
requesting,
sorry, yeah.
That only those,
Okay, all right.
That the other numbers go to. I mean, the numbers that exist, but there are no exhibits that correspond to. So
Okay, I'm gonna have to change this then. Okay.
yeah, because I think the rest of those were all part of.
Okay, so I changed it. Again, date, time. Members of the jury, I'm sending the exhibits you requested that have been received, except for Exhibit 4, which is a PowerPoint on a disc that would have to be displayed in the courtroom. I am not sending that. Exhibit 4B is the paper printed version of Exhibit 4. Exhibits 5, 6, 7, 8, 10, 11, 12, 13, and 15 have not been received.
6 has been received and has already been provided.
I'm sorry?
6 was received
Received and provided.
already and already sent to them?
Yes, the first.
Yeah, 6, that's correct. 6 was already sent to them.
Okay.
That's correct.
Okay, so then I change it to say 5, 7, 8, 10, et cetera, have not been received. And you should have Exhibit 6 already. Okay, but just that change. Agreed?
That's fine, Your Honor.
Okay, all right, then I'll print that out and we'll get that to the jury. Thank you, please be seated. All right, it is now approximately 7:50 PM and we received another request from the jury a few minutes ago for exhibits 290, 176, and 426. And First Estate, any objection to the?
Your Honor, we don't, 426 was not admitted, only a very small portion of 426. That's the March 1st interview of the defendant by Detective Prock. Only a small portion was actually played, and.
Is that a recording?
That obviously was not admitted. 290 is the March 24th interview of the defendant, the transcript of it, and 176 is the March 23rd transcript. We don't have any objection. I understand the defense may, and I will respond after that.
Okay, Mr. Nelson?
Judge, we object to the transcripts, that is Exhibit 290 and Exhibit 176 being provided. I think if the jury wants to listen to the interviews, they can listen to the interviews. I've listened to them, and I know that there are at least one error that I think is significant. pointed out, maybe everybody agrees, but regardless, I don't think they should just get the transcript, I think they need to.
Well, Your Honor, testimony, first off, they were admitted without objection.
Well, they did object to them, actually.
There may have been but they were admitted. Secondly, Detective Prock testified that he listened to them, that after listening to them, he reviewed the transcripts, and the transcripts were accurate to the best of his ability. So I believe with that testimony, there's certainly, there's enough indication of reliability and accuracy, and so I would submit that they should be submitted to the jury. If they wanted to listen to the recordings, they could have asked to listen to the recordings. They didn't ask for that.
Judge, just as Honor noted, I objected from the get-go to the transcript. We've never agreed to their authenticity. I understand the court's prior ruling. I understand Detective Brock's testimony. However, he is not a certified court reporter. That most transcripts, in order to be admitted, are of that nature. And so that is our concern regarding 290-176.
So 176, what is, 426 is the March 1st transcript?
For 426 is not offered, it's not been received. I don't believe that there is a transcript. No, I think there is a transcript that was provided in discovery, but it's not part of evidence.
The 426 is the March 1st, right?
Correct.
And then 290 is the March 24?
Correct.
Yes.
Transcript. And then 176 is the March 23rd?
Yes, Your Honor.
Oh, yes, 23rd, excuse me.
March 23rd. And that's the Detective Prock?
Yeah.
It'll be March 23rd. Wait, well, Mr. Nelson, what is the error you believe that is on the transcript?
Can I see 290?
On the top of page 41 on line 1824, the line reads, "My life, because I've never ever felt that way in my whole life." I believe it should read, "My life, because I've never ever fought back in my whole life." So instead of felt that, it should read fought back.
So, what about bringing the jury in and having them listen to the two recordings?
Yeah.
It's fine. I mean, if that's what they want to, that's what they want to do. That's what we do.
Well, Your Honor, I guess I don't agree that this characterization of what's said, if we want to, we could listen to it in the courtroom and have the court make a decision if it's a correct transcription or not, just that small portion.
Can we get to that portion?
The whole of it was played.
I know, but I wonder how quick.
There is actually I'd have to go get my computer.
There's a timestamp on it's 5101 is immediately after that, so it would be, around the 50-minute mark.
Is that the March 24 transcript?
That's the March 24th transcript.
There's also a part of the transcript that says inaudible, but we played it during the redirect of Miss McCandless, where she says on the tape that Sipple was the name of her high school teacher, and it's transcribed as inaudible, but if you listen closely, you can hear her say she had a high school teacher by that name.
And she testified to that, and they heard that testimony.
Well, you've challenged everything about her testimony as being a liar, so I think hearing the actual tape is important.
Well, I think what I'm inclined to do is send a note back and say that at this time we're not sending transcripts back, but if you wish to listen to the recordings that were played during the trial, we'll bring you into the courtroom for that. Right, but can we locate that?
I had it before, I can find it on my computer and play it, certainly. I know we had it, we'd have to figure out what the number, I'd have to go grab my book and we could figure out where that was marked. I believe it was
What day?
693.
What day was that, Officer Bain?
Oh, it's not Bang. This is during cross-examination. I crossed Officer Vang regarding the portion of his interview in which Ms. McCandless spoke about Alexander Woodworth. It was about a 60-second or less clip, at the end of which our point of contention was she says it hurt.
Okay, so that was the Brock interview of the Hansen investigation.
Correct.
Correct.
Your Honor, I have a suggestion, because of the fact that, the two recordings between them are about 2 hours long. Rather than having the jury have to come back in and listen to the whole thing, my suggestion is that the one section that that the defense has an issue with, that we give them the rest of the transcript, leave that page out, and let them come in and listen to approximately a minute and a half of the recording, and then go back.
Again, there's at least two. So on page 2 of Exhibit 290, on page 2, line 43, Ms. McCandless, the transcript reads, "It sounded familiar to me because I..."
Okay, and that's fine. They can listen to that portion too.
Finishing,
no problem with that.
Finishing my sentence, the rest of the sentence read, "Because I, inaudible, last name Civil," and it was the defense's position, and Ms. McCandless testified that it was her words on the tape were, "It sounded familiar to me because I had a teacher with the last name Civil," or something along those lines.
And I have no problem with listening to that portion too, Your Honor, but it just seems like that would save a lot of their time, the court's time, and everybody's time.
And Judge, with all due respect, we've been here 3 weeks. This is a very serious matter. We either play the tape or we don't. And our position is we play the recording. You might want to ask the jurors, look, we're going to ask to play the recording. Do you want to hear that now or do you want to hear that tomorrow? Or however Your Honor wants to do it. But I don't think we play portions of it. You just play the whole tape.
I think that's what I'm going to do, because either that or we're going to have to... All right.
And then the question, I guess, then Judge, sorry to add confusion to it, is, of course, the state's portion that they played had the transcript with it. That was played underneath. I have a version that I could play on my computer that's identical, that does not have the transcript, or we could just play it without the visual, so that they can listen to it.
Yeah.
Well, the concern I'm going to have is that portion that is disputed as far as the accuracy is a pretty significant portion of that transcript. And so, all right. Okay. 8:03 p.m. Members of the jury, I'm not going to send the transcripts in the jury room. Into. If you wish to hear the recordings or portions played in court, we will have you come back into the courtroom. However, it will take approximately 2 hours. You want to do that tonight or tomorrow morning? Any objection to that, Mr. Nelson? State?
That's fine, Your Honor.
Okay.
I apologize, did you want to let them know that 426 was not admitted? Or is that just to...
You would still play that portion.
That's fine, I just wanted...
Yeah.
I don't think we should be told that right now.
And there is no transcript for 426.
One exists, but it's not been entered into evidence.
Correct. Yeah, but it's not in evidence. Okay. So I think we just leave it like this here
I think that'd be better.
for now. Okay, stand by, because we're probably going to answer pretty quick. We've been informed that the jury has reached a verdict, so we'll be bringing the jury in shortly. Well, if you have some people that you want to let know.
Yes.
Okay, then we'll tell you how much time you need.
5 minutes, if not.
Okay, so we'll just hang on. All right. Hannah, when everybody's in here, would you? All right. Again, it's 8:20 p.m. and we've been advised the jury has reached a verdict, and we'll be having the jury come in shortly. Now, I would ask that, I know there's a lot of emotion in this case on both sides, and since March 22nd of 2018 until now, if there's anybody here that does not believe that they can keep still and hold their emotions in check, now is the time to leave the courtroom. I'm going to ask that anybody in here not show any emotion, and there do not be any outbursts. All right? Understood? All right. Are we ready for the jury? Yes, sir. All right, let's bring the jury in. All right, you may be seated. Excuse me. All right, members of the jury, have you reached a verdict?
Yes, Your Honor.
All right, and would you please give the verdict and the instructions to the bailiff? All right. Mr. McCandless, please rise. We, the jury, find the defendant, Ezra J. McCandless, guilty of first-degree intentional homicide as charged in the information. And the answer to the special verdict question is yes. Use a dangerous weapon. Again, you may be seated. All right, ladies and gentlemen, is this your verdict? All right. I'm going to do what's called polling the jury, and I'm going to ask each of you if this is your verdict. And I'm going to ask you by your juror number. All right, I'm going to list off your juror number, and I'd ask that you simply answer yes or no. Okay, juror number 30. Is this your verdict?
Yes.
Juror number 20, is this your verdict?
Yes.
Juror number 67, is this your verdict?
Yes.
Juror number 2, is this your verdict?
Yes.
Juror number 36, is this your verdict?
Yes.
Juror number 56, is this your verdict?
Yes.
Juror number 73, is this your verdict?
Yes.
Juror number 90, is this your verdict?
Yes.
Juror number 133, is this your verdict?
Yes.
Juror number 135, is this your verdict?
Yes.
Juror number 98, is this your verdict?
Yes.
And juror number 64, is this your verdict?
Yes.
All right. Ladies and gentlemen, I don't think there's enough gratitude I can express to you for your service in this matter, in the sense that you've devoted 3 weeks of your time and limitations on your liberty and so forth. And we do have a standard closing instruction, which I have momentarily misplaced. As you can see, we use a number of pattern instructions, and occasionally we stray off of that a little bit, improvise, but in any event, now that your service in this case is completed, some of you may have questions about the confidentiality of the proceedings. You are free to discuss the case with any person you choose. However, you do not have to discuss the case with anyone or answer any questions about it from anyone other than the court. If you do decide to discuss the case with anyone, including the media, keep in mind that your fellow jurors fully and freely stated their opinions and may not want their opinions made public. Please respect the privacy of the views of your fellow jurors. If any of you have questions for the court before leaving today, please let the bailiff know before you leave the jury room. And if you do wish to remain, and I will answer any questions you may have. Again, there are limitations on what the court can and cannot do or say. But we do have some information for you. In a case such as this, often the things that you see or hear throughout the course of the trial can have, I think it was brought up during the trial, secondary trauma. If we have some information for resources, if any of you feel that you're struggling in any way with any of the things that you've seen or heard about or had to deal with in connection with this case. So we'll provide that to you before you leave tonight. Again, if you have any other questions for us, we can help you with that. But members of the jury, on behalf of Dunn County, the court would like to express its sincerest gratitude and appreciation for your service in this case. The court recognizes that you have devoted significant time and tolerated restrictions on your normal activities during the trial. Your service is a necessary and essential part of the justice system guaranteed by the Constitution of the United States. And I hope you found the experience to be a rewarding one. And I know that, it's not an easy thing to do. So with that, we are going to excuse you. And again, I do wish to express, as sometimes a pattern instruction doesn't really fully express, our appreciation for the service and what you put up with while you serve on a jury. But we are going to excuse you. But again, if you do have any questions, you may remain. If not, you're free to be on your way. And I'll just note for the record that we kept the alternate until after I polled the jury, so then you can also notify, would like to give the information to Mr. Tyerman as well, and he can be excused if he wishes, and if he has any questions, then he can remain. Okay, so we're going to excuse the jury. All rise. All right, thank you. You may be seated. All right. Any motions?
Yes, Your Honor. Based on the verdict, the state has two motions it would wish to make. First off, we would move for a judgment of conviction based upon the verdict. Secondly, we would move to revoke bond at this point in time.
All right. Well, does the defense wish to be heard at this time?
No, Judge.
All right. Court will enter judgment on the verdict of guilty as rendered by the jury, and the court will also revoke the bond at this time, and Ms. McCandless will be remanded to the custody of the Dunn County Sheriff, and we will set a sentencing date. So we need a date. I'll order that a pre-sentence investigation be prepared. It is a mandatory sentence. However, there is a parole eligibility date. So we'll...
February 24th?
How about, we'll have the record for scheduling.
Stand standard in Dunn County, but in Milwaukee County, I've always asked for a court order that defense counsel be present during the pre-sentence interview. I have never been, no judge has ever declined to order that. I'm aware that the probation department would not let a defense lawyer in, but they will comply with a court order. And that, so I'm asking for that order.
All right, does anybody have any objection?
Oh, I'm sorry. On that issue, no.
Okay, all right, well, I'd ask that you prepare the order for the court's signature.
Usually if you just put it on the order for the pre-sentence, they'll comply,
that
but
too.
in case not, we can get something to you next week. That can go to DOC and it'll have Mr. Nelson's office.
Okay, are we on the record for that, Madam Reporter? Okay, so, but off the record for scheduling, kind of ways out there.
Just a second. Friday, February 7th is fine at the state, Your Honor. AAG Hahn is not available, but we should be fine.
Mr. Sneed, does that work for you?
Yes. What
What's that?
time? I'm sorry, I didn't catch it. Did you want all day or half day?
Oh, Your Honor, it might be better if we had more than a half a day, it sounds like. I think there are quite a few members of the family that may wish to be making statements, so it may take
Starting
more.
at 9 a.m.?
What's that?
Starting at 9 a.m.?
9 a.m. for the rest of the day, maybe, just to be sure.
All right, with that on the record, sentencing this matter will be set for Friday, February 7th, 2020, beginning at 9 a.m., and we'll reserve the rest of the day for this matter. All right, anything further, counsel?
Nothing from the state, Your Honor, thank you.
All right.
I just have a question. How do you want that ordered, the defense counsel may be present for PSI interview?
Shall be present. Yeah, put in there, shall be present.
Okay, thank you.
All right then, with that, we'll be adjourned. Okay, then any reason we cannot proceed with sentencing today? All right, Ms. Noroff, are you ready to proceed?
Yes, Your Honor. I believe the first statement will be from John Woodworth, Alex's father, but I believe it will be read by a friend of his. No? By me. Okay, it'll be read by me.
Okay, just again, keep in mind that when you read, just read at a pace that the court reporter can sustain.
At Alex's memorial service, we had over 300 people attend, and we received well over 500 cards. It was touching to see how many people Alex had touched over his short life. In one of the cards, we found a letter from some man we didn't know. He told us that his son was suicidal but ran into Alex at the Lacy's coffee shop where Alex worked. The two of them started talking, and the boy told Alex about his intent to kill himself. Alex was able to talk him out of it and helped him find the resources to deal with his issues. The father ended the letter letting us know that his son was alive because of Alex. As much pain as we have felt over the loss to us, what is hard, if not harder, is knowing that if Alex had this much impact in only a few years, how much more of an impact he could have had if he had a full life. It is this loss of potential that hurts as much as the loss of Alex himself. By killing our son, not only has Ezra robbed my wife and myself of our son, but has made the world a darker and colder place by destroying the light that Alex could have been.
Okay, thank you. That's John Woodworth.
Yes. The next statement is from Joan Woodworth, Alex's grandmother, that she would like to have read as well. Ezra McCandless lured my grandson to a remote location with the express intent of murdering him. Alex was our oldest grandson, who we spent every minute with growing up and continues a very close relationship with through college. We took the time once a month to drive the hour and a half to see him, take him out to lunch, shopping, and just spend time with him from the time he started college in Eau Claire. We often picked him up or drove him back after weekend or holiday visits. These were some of our most cherished times with him. Her selfish act has robbed our entire family of any possibilities of seeing him reach his dream of becoming a professor, of spending another birthday, weekend, lunch, or holiday with him, ever see him get married or have children of his own. These were all robbed from us. His loss has been the worst nightmare of our lives. We have suffered great mental anguish, unbearable grief, and loss. We have not been able to have a joyful holiday in 2 years. Robbed each year from joy and only knowing sorrow of the one who will never be with us again. This has also greatly affected his parents and younger siblings. Due to a hearing we attended, my husband Marv had a heart attack and spent 20 days between 3 hospitals last December. The health toll on us can't be measured. Knowing that she intentionally killed him for selfish reasons, stabbed him 16 times, watching the blood and life drain from his body, is a picture that I live with every day. Watching her reactions at the hearing and trial, knowing that she didn't even show an ounce of concern, remorse, or sadness for his loss, was something I believe shows her true character. As a Christian, I know that God has forgiven me much in my life, so I must also forgive her. However, I do know that God expects accountability for our sins and actions. I then feel it is only right that she does suffer the consequences of this brutal, selfish murder by spending many, many years in prison and get mental help. I feel if given the opportunity, she definitely will kill again. And my prayer is that she will never be able to harm another person like she did Alex, or put another family through what we have been through.
Thank you.
And I believe the next will be Scott or Amy Clark, the uncle and aunt to Alex.
You can come right up here and right to the witness stand. All right, because it is sentencing, I don't think it's necessary to place a person under oath. We just thought that would be a good location to make a statement from. You may be seated if you wish. You can stand if you'd like as well.
I'd like to.
Okay.
You took a life. You took away a son, a brother, a grandson, a nephew, a cousin, and a friend. Alex was loved by so many. He did not have one ounce of meanness or anger in him. He indeed was about giving and helping. He was funny. He was kind and respectful. He had such an intelligent and witty mind. He was such a kind and loving man that despite him knowing how unstable you were, he was still willing to give you compassion. He left with you that fateful day believing he was going to help you in some way, and instead you took his life. He definitely is not the monster you attempted to portray him as. Seeing and hearing how you brutally took his life will forever be etched in our minds. Although we try to Replace that with fond memories of Alex. There will be a lifetime of emptiness for our family, and especially for Alex's parents, Kim and John, and his younger siblings who looked up to him. But more heartbreaking than the loss of your child, your world is turned upside down, and a piece of your heart will be missing forever. Alex touched so many people's lives in the 24 years he was with us, and now we have been robbed of seeing what his potential could have been. He had great potential of touching many more people's lives. As we would hear it argued in court by this defense team, that Alex could have been up walking and talking for up to 30 minutes with his injuries. We hear that as Alex could minutes. And what more awful to imagine is your child or family member suffering for any period of time. You caused pain and suffering to Alex, and you have caused pain and suffering to our family. You were never the victim, and there will be no forgiveness from us for what you have done. This is our last chance to advocate for Alex and the precious life that you took. We know this won't bring him back. Having seen how Alex's life was brutally taken by you, we want the harshest sentence of life in prison. Going through this process, it has felt as though we have had to go through losing him again. You took a life, and we can only hope the rest of your life is misery as the rest of our life will be misery, missing Alex and wondering where Alex's life would have taken him.
Okay, and when you start, can we just get a spelling of your name? How Krista's spelled?
Krista, last name Hall, Hall.
Thank you.
Sister to Kim Woodworth and Alex's favorite aunt. That's been an ongoing joke amongst the aunts with all of our nieces and nephews from the time they were little enough to bribe with candy. There's a quote that I read not long after Alex's death, and although I don't recall the author, I wanted to share it today because of its simplicity, which rings true in regards to grieving. Mourning is one of the deepest expressions of pure love. As we continue to mourn for Alex, and will continue to honor his life by sharing the memories he left us with over the years. We will all mourn for a loved one in our lives and experience the heart-aching depth of despair that creates. Even if you didn't know Alex, human nature is to be respectful of the family and show some empathy or compassion. Going into the trial, we weren't sure what to expect, but I knew although it might be awkward, I certainly wouldn't have any hard feelings against Ezra's family. And I thought surely they might feel the same about us, right? There were no words, no idea what to expect. When my sister Kim said good morning to the family's members of Ezra as we entered the courtroom one of the first mornings, there was no reply. No eye contact, nothing. I was appalled and angry. My sister lost her son. For those of you that didn't know Alex, to put it simply, he was incredibly smart and witty. We all look forward to seeing him during the holidays, noticing the changes that take place from a high school graduate who goes off to college, watching him develop into the young man that he was, finding his place in the world, pursuing his interests. Conversation with Alex was never boring or dull. Until this trial, I don't think any of us really understood what an incredible writer he had already become. The brief excerpts that we heard in court were only a fraction of what he was trying to say, and yet it was plain to see that his gift for philosophical studies and theories was apparent. He was a thinker, analyzing, studying, and questioning every aspect of life and love, and submersing himself into philosophical theories of other writers. Anything that gave him inspiration to write. He would have been an incredible philosophical
professor, and he had the ambition to pursue his education and earn a doctorate. There's so much to life that he had yet to experience. A lifetime of wonder, exploration, love, friendships, and memories, and you, Ezra, took that away from him. Selfishly. Sadly, he never experienced what it means to truly love and be loved by another. But perhaps if there's any comfort in knowing, even if for a brief period of time, he thought he was in love and happy with you. It's been 1 year, 10 months, and 16 days. And Ezra, while we continue to mourn Alex's passing, it's hard not to notice that throughout the trial, we never saw any sign of sadness, shame, compassion, or the slightest bit of remorse in what you had done. You're so caught up in your own lies and behavior, consistently taking advantage of those around you. You took somebody's life. It was never a situation of self-defense. Maybe for Alex as he struggled trying to save his own and get away, but never for you. In the years to come, you're going to have ample time to yourself. Rather than continuously thinking about how you've been wronged or what society owes you, I ask that you start reflecting upon your actions. Stop thinking about yourself as the victim. As we've learned throughout the trial, it seems to be an ongoing excuse for all of your poor decisions, lack of accountability, and actions in life. Everyone you see in this courtroom today has suffered some type of traumatic event or been victimized in some way. Life is hard. If you are lucky enough to experience freedom again someday, do something good. Get a job, be responsible, take ownership of your life, and contribute to society in a positive way. And if you're lucky enough to find someone who will look past your faults and accept you for what you've done and the person that you are, just as Alex had done, treat them well, love them unconditionally, and expect nothing in return. Beyond the violent wounds that you inflicted on his body, the pictures of which were horrific, lest we forget the unseen emotional wounds that you've created as well. You disregarded his friendship and compassion. He was there for you when you needed a friend, when you needed a place to stay, when you needed comfort and a soft place to fall. He was there for you. You knew he accepted your past and accepted us as you were when you were together. Remember the quote, "Come as you are, flaws and all." You made him believe that you actually loved and cared for him because it was convenient for you at the time. When that was no longer the case, and he was more of an obstacle in your grandiose scheme and plan, you discarded his feelings and ultimately his life. Your actions have pierced the heart and soul of those who loved him. Our family, our community filled with neighbors, former teachers, classmates, co-workers, and so many friends he's made over the years. Those wounds will never heal. Ezra, you cannot fathom and will likely never know the love that a mother has for her child. For that itself is truly a blessing. And I hope you never have the opportunity to experience it because I don't think you're capable of truly loving another person and nurturing another human. My sister Kim has not only lost a child, but I had to endure the trauma with knowing how he died. And endured a public trial. And I'm listening to you, Ezra, and the defense team create a fictional story of what happened, painting Alex as a demonic person. It's incomprehensible. I can only imagine the agonizing heartache that tears through her every day and night. As a mother myself, I can't pretend to understand. but my heart aches and my tears flow, not only for Alex, but for my sister. Behind her smile and her kind, gentle demeanor is her humanity. She's stronger than anyone I've ever known, putting everyone else's needs before hers. Her faith is deep. She exudes patience, love, and acceptance to everyone she meets, just as Alex did for you.
My name is Dale Hall. I am an uncle-in-law to Alexander Woodworth. I want to apologize up front, as I've been a part of the system in law enforcement for 25 years. I don't want to remember dates of bad things that have happened, because the dates will come back to haunt us in law enforcement. So I'll give estimates on dates in my statement. In late March of 2018, I was asked by my family to see if I could get information because Alex was missing. When I got a hold of the investigator that day, I was advised that Alex wasn't missing, and that Alex was at the medical examiner's office. Being in law enforcement for as long as I was, I knew why he was at a medical examiner's office, because I knew he was dead. And then offered to do death notification for the family, because this family, the family that Alex was part of, the family that I had been part of for 22 plus years at that time, family is their top priority. And then went and spoke with Kim, Alex's mom. By the time I destroyed her by giving her the worst information that a mother could get. And then called John, as he's away on business. And then I destroyed him by giving him the worst information that a father could get. After speaking with John, I then went to my mother and father-in-law's house, Alex's grandma and grandpa, and I destroyed their lives as well, giving them the worst information that anybody could have. I've given a lot of death notifications in my 25-year career. And I will say that this has been the most difficult because this destroyed me as well. Over the next several months I sat idle, which also destroyed me, but that hurt was nothing compared to the pain of the family not being able to lay Alex to rest. As this system, the system that I've been a part of for so many years, jockeyed with Alex's body, labeling him as evidence, keeping him from his family, was beyond any part of reasonable, objectively reasonable, or even humane. Around 4 months after Alex was murdered, we finally got to lay him to rest. Just 2 months after Alex was found murdered, there was a request that the defense be allowed 60 more days to hold on to his body so they could work and do their work with the information given by the state. That's my request for the honor. 60 years. 1 year for every day that Alex was withheld from us, laying there, and with us not being able to touch him. As we looked at the photographs of the injuries that you had suffered, Ezra, I agree that like is like. And what I mean by that is, the marks that you admitted to doing yourself were exactly like the marks that you accused Alex of doing. If you believe that, like is like the jury must have, then you can honestly say that the knife was never in Alex's hand. Now that I believe that the knife was never in Alex's hand, why do I believe that? Because of character. We all know people and people's character. I can tell you, and tell everybody in this courtroom, that Alexander Woodworth never raised a knife to you to hurt you in any way. There was no self-defense. He just didn't have it in his character to hurt anyone. So, if the knife was never in his hand, then Ezra attacked and destroyed one of the most caring people in this world. She took away one of the most beautiful minds that I've ever known. People lose friends, family, cousins, uncles, every day, but to lose a child should never happen. To bury our baby, Kim's baby, is not the way that life goes. We watched for 15 days in this trial, where Ezra's family was able to speak, hug, and touch her, and we had to sit watch, knowing that we'd never get to touch Alex again until we are not bound to this earth. Watching that was very painful. I ask they give the victims us the same benefit. And we'll never have to sit and watch Ezra laugh, touch, hold her family again until we are unbound by this earth and get to be with Alex. I hope that she stays in prison for as long as we all lived, the friends, the cousins, mother and dad. I've always preached that the system has two prongs. First prong, to rehabilitate, to give offenders the tools that to be productive members of society. Second prong, to protect society from offenders that can't be rehabilitated. Ezra shows no remorse for what she's done. There is no AA group or prison program that would be able to give her any caring for human life. I ask the judge to please protect society. Protect future victims from suffering the way that Alexander Woodward did on that cold March day, where he was driven to an isolated area, attacked and murdered, alone and afraid.
Thank you, sir.
Your Honor, I've been provided with a written statement this morning from Samantha Cobbs that she would like read. Her last name is spelled K-O-B-S. Honorable Judge James Peterson, my name is Samantha Cobbs. I write to you in an attempt to summarize the impact that the loss of my dear friend Alex has had on me and others over the past 23 months. How does one begin to explain what it feels like to lose somebody so suddenly and so senselessly? I can only hope that this letter sheds an ounce of light on the turmoil that I have had in my heart. To my knowledge, I was one of the first, if not the first, friend to find out that Alex had been killed. I did not find out until I picked up my phone and called his parents on Sunday morning, March 25th. I was calling to tell them that his friends were about to hang up missing person posters and that we were sending our love and support. You can imagine my shock and horror as his father stayed silent on the other line, then interrupted me to tell me that Alex was already found, dead and deserted. I will never forget the words that he used or the pain in his trembling voice. To say that I felt stupid would be an understatement. Not only because I felt I was invading their privacy as they mourned, but because up until that moment, I had been ignorantly optimistic. I consider myself a very strong person, but March and April of 2018, I was not strong. I slept with my lights on for weeks. Bedroom lights, kitchen lights. I would even prop a chair against my bedroom door before I fell asleep. I was afraid to start my car in the mornings before work. I was afraid to be alone in my own home. If my roommate was gone for a night or weekend, I would stay with friends to feel less anxious. Perhaps it was because I knew the defendant knew where I lived, and I didn't know whether they would meet bail. I may have been thinking a bit irrationally, but this was my reality for a very long time. And to be quite frank, nothing in this case seemed rational. I moved out of my apartment at the end of May 2018, which was about when Alex should have been moving in. I couldn't bring myself to stay there, to try to find somebody to take over his part of the lease. It felt wrong, and I felt unsafe. Imagine how anxious I felt having to call my landlord and explain that the kind young man she'd met just a few weeks prior was now a homicide victim. Imagine how I felt when I asked to break my lease, to move out of a beautiful apartment that I loved, because I didn't have the emotional strength or energy to try to find somebody else to replace him. I spoke at Alex's funeral, his initial funeral, where his family was unable to bury him because of ongoing autopsies. The church was packed, and so many people had stories to share. I was there when his bedroom was cleaned out and his belongings were being removed from his favorite city, a city he truly belonged to. I was there when his remains were finally buried just outside his hometown many months after he was killed. I watched his mother scream in agony as she collapsed over his urn on that beautiful summer day. Last fall, I was there in the courtroom to testify in front of the jury and the cameras. My face was plastered all over the internet and local news stations. I was attacked in the comments of social media posts. In promotional videos from court TV, my face was the first face shown, second only to that of the defendant. Imagine how uncomfortable every time one of my students walked up to me and said, "Hey, Miss Cobbs, I saw you on TV last night." Or even worse, when complete strangers said the same exact thing. Alex's murder has impacted me beyond measure, and I am only one of the many friends and family members to have experienced these traumas since March 2018. Alex was such a beautiful soul. Again and again, stories have been told of his intellect, compassion, and curiosity. If he were still here, I have no doubt he would be working towards receiving his PhD in philosophy as a McNair Scholar. And knowing Alex, probably getting an additional PhD in something completely different just because he could. He was the smartest and most humble person I knew, and I continue to feel his absence as my life moves away from these difficult times. I was there in the courtroom as the jury announced that it had found the defendant guilty, beyond a reasonable doubt, of first-degree intentional homicide that day late in October. For many of Alex's family members and friends, we simply desire a sense of closure. We trust in our judicial system to appropriately penalize those who are found guilty of crimes, and we trust that the sentences for such crimes are fair and just. I ask that you consider the inconsistencies of the defendant's stories, the lack of remorse, and the continued denial of wrongdoing, in addition to the unanimous guilty verdict when deciding on the sentence for the defendant, Ezra J. McCandless. Sincerely, Samantha Cobbs. I believe the next statement will be from Allison Kexel.
What's the last name?
Kexel, K-E-X-E-L.
All right, thank you.
Ezra, I looked forward to this because I've been angry and I thought that I would know what to say to you today. But the truth is, I don't. I don't think there's any string of words that can express how deeply you've hurt all of us. There's no statement powerful enough to move you. You've shown no shame, no guilt, or remorse for the crime that you've committed. You severed a single thread in my life, and I watched so many others completely unfold. The morning I found out that you...
Judge, I don't want to be rude to Ms. Kexel or anybody, but...
Everybody else got to read their statements?
Hold on a second.
I think that it would be appropriate. I'm not saying that she shouldn't read her statement. I'm not trying to say that. I just asked that she address the court.
because I think
This is personal.
Well, I think it's appropriate for you to address the court. You can, you can state what it is you want to say, but I think we just address the court. I think that we'll just leave it at that.
The morning we found out Alex was dead, I knew it was the defendant. I don't know how, I just knew. I sat in a living room full of our old friends, my friends, and cried. For months we held one another, sobbing, struggling, trying to understand the sweetest man that we all loved. He was soft and gentle. He never once made me feel bad. He was receptive to my feelings, understanding, kind, compassionate. And I'm not only heartbroken, but I'm full of rage. I'm sad that so many times Alex told me about his siblings who he loved so much, and to see them at his funeral, something that I can't grasp. Being the youngest of my family, my brothers pretty much raised me, and that is a pain that I just can't fathom. Alex will never get to go to grad school. He's never going to be a professor to share his passions and his ideas with like-minded individuals. He'll never be loved, to live a full life. He'll never grow old because you took that away from him. You took away from so many of us someone that we loved. And as your friend, the friend of the defendant, you will never get to experience a full life either. You are so talented, and I would have loved to see you flourish and to create great art, but selling it for an appeal will be your highlight as an artist. I'm angry. I've spent so many days trying to get by, so many nights screaming and sobbing, and being held in return by our old friends, and watching them break over and over. You will never know the extent of the irreparable damage you've caused. Not only to all of those that I love and to Alex's family and to all of those that Alex knew, but to sexual assault victims as well. Your numerous and ongoing lies have and continue to discredit those who have suffered, and as a woman and a victim myself, I am disappointed. I don't believe in locking people up like animals or fighting violence with violence. I think prison is just slavery disguised. However, your crime was so heinous, so shameful, and so disgusting that I do believe you should serve a life sentence without parole. I hope in time that you grow enough to at least admit for the first time to tell the truth, just what you've done to all of us in this room and outside of this room and as a community.
Thank you.
Next, I'm going to read a impact statement by Sarah Lowe, L-O-W-E. I know this is cliche, but this is what immediately came to mind when I started reflecting on what to say today. Why do bad things happen to good people? Because Alex was genuinely a good person. Good people are people who help unconditionally, respect unconditionally, and love unconditionally. Alex was a good person. Here are some ways that Alex demonstrated these qualities in my life. One way that Alex helped me unconditionally was when I was studying for the GRE. He took the time to come help me almost every day of the week for multiple weeks. I wasn't even paying him. That's a lot to do for someone. Alex didn't think it was that big of a thing to do. Also, Alex showed unconditional respect for me, for my brain, for my dreams, for my beliefs, for my potential, and for myself.
When I first met him, we went on a few dates and started seeing each other. When we had our first kiss, he first asked if it was okay to kiss me. Who does that these days? Eventually, I decided that I wasn't in a place to date right then and asked if we could be friends. He was fine with that, and we even ended up being housemates. When I got the results of my GRE test, I hadn't done well. I felt ashamed and felt like a failure. Alex was the first person I thought of, because his love was unconditional. I knew he wouldn't judge me. He just held me while I cried and told me that he loved me, which meant a lot. We had multiple conversations about what we believed. With my background in psychology, I believe that people need to love themselves first before they can really love other people. Alex had a different way of thinking, which might not always have been the healthiest for him, but it's what he believed. He said, quote, "As long as I make other people happy, that makes me happiest. As long as I share with other people, that's what makes me content." This philosophy was one that he believed, but also followed, as he often knew I was having a tough day and as a result would give me hugs and say, "I love you." When you lose someone like Alex, when the world loses someone like Alex, it makes a huge difference. This is how losing Alex impacts me. I've had depression, sudden bouts of crying, insomnia, and recurring nightmares. It's affected my work, my relationships, and my overall quality of life. Losing Alex also has effects for the future. That's in the what ifs, in the absence of a future. For example, all the times that I can't call him, can't talk to him. Oftentimes, he's the one person that I want to talk to, and it's hard to know I can't. To know that I'll never talk to him again. Then there's the impact that he would have had on other people. Alex planned to be a philosophy professor. He had a great influence on my life through our academic discussions. And that's an impact that he will never have on me going forward, nor on all of the students and colleagues he could have benefited from having him in their lives. Alex was a good person, and he made me a better person. This is the impact that Alex's death has had on me, and I miss him every day. Alex was a forgiving person. I believe that he would want you to be lenient in sentencing, because that's who he was. I too am usually for giving people a second chance. But when a person makes the decision to stab someone 16 times and leave them suffering to die, I don't think they deserve a second chance. For this reason, I recommend that Ezra receive the maximum penalty.
Thank you.
I think the next statement will be from Court Fox.
I remember when I first met Alex, it was in class. He was just this young kid that was brilliant, shocked everyone in the class with his insights, his ability to speak, his ability to understand the concepts. But I didn't know him, I didn't even know his name. And I had another friend who was also in philosophy, but we didn't share the same courses. And this other friend and I would get together and we would talk about, he also had this young kid that was just so freaking impressive. And a short while later we figured out that we were talking about the same incredibly impressive kid. And so we're like, we have to know this guy. So we finagled our way into a reading group with him that he was setting up on his own, just to do more philosophy outside of class. Unfortunately for him, but fortunately for Nick and I, we were the only ones that showed up. But for, I think, all of 2 sessions, we actually did do the reading and do the discussion, but just those short moments with him inside of a coffee cafe, I knew I wanted to be this man's friend because his kindness, his empathy, his humor, his ungodly intellect just radiated out from him. And becoming his friend was the easiest thing because he so loved people. He just, as people have spoken, his joy came from other people. His most enjoyable moments in life were just interacting with people. And when you did, his face lit up and all of that incredible intellect and mind was trained right on you. He was so engaged and interested, it could almost be daunting to have such an intellect fully focused on you, but it was out of genuine kindness and interest. And to say that he was my best friend is almost limiting what he was to me. It probably speaks poorly of me, but after his death I have cast about my friends and found them all wanting. No one has been able to understand me, show the amount of concern. Not to say that my other friends and family don't, but he was unique in his ability to just show it and to put in the work, and it wasn't work for him. And that he would have gone on to great things in philosophy and education is undeniable. He did organize and contribute to a lot of extracurricular reading groups and other study groups, and his ability to speak to people, to use his brilliant mind, but still tone it down to explain. He would have been one of the best professors, but when he was in his element, speaking for himself, articulating his own thoughts, he was brilliant. And that's gone. But I don't want to naysay the other peoples that have been up here, but I am absolutely certain that Alex would have asked for some sort of leniency, because he did fully believe that every human being is possessed with infinite potential, and to squander that potential is perhaps the greatest sin. But I'm not as kind of man as Alex was, but I still have to agree with him. I would like to see Ezra released from prison at some point in her life, I care not when. Not for a chance of forgiveness or to, find some sort of salvation, but because after decades in prison, she will find inevitably some sort of normalcy, some sort of stability. It will become her life, and she will, if not be happy with it, be acquainted with it. I would like to ruin that for her again and cast her out into the wider world. I would like to see her struggle for friends, employment, housing, knowing that the pall of her actions weigh over her. I want her to agonize with each new person that she meets. Is she upfront about what she's done, or does she hide it and have to live with the anxiety of, oh my God, what if they find out? I want more chaos in her life after she's found normalcy. Actions have consequences, and to simply lock her away for the rest of her life will bar her from the full complement of consequences that she could suffer for this. And I would like to see that. I don't care when, but personally, that is what I would like. So, thank you.
Thank you.
Your Honor, the next statement, which I will be reading, is from Sarah Woodworth, the sister of Alex. Your Honor, and all those present, hello. You haven't seen my face during the trial, but I have watched it closely. I'm Alex Woodworth's little sister, but this year I will be older than he was. Something I told him I would do as a little girl, but not something I ever wanted to experience when I realized how that was possible. I'll be 24 this coming May, and he should have been 26. Maybe finishing his doctorate, seeing me as I talk about our futures. Maybe I would have had the guts to tell him I love him, even if we fell away the last 2 years of his life. But I'll never know if I would, because he's gone. He's gone, and I'll never get to tell him I love him ever again. I've put off writing this letter because it feels like a goodbye. I don't want a goodbye, but I know if I don't do this, I'll regret it for the rest of the life I'll spend without him. I could never tell him how I felt, because he thought it'd be stupid. Instead, he'd want to talk about me going back to school and ask me about my opinions on humanity. And I'd know, in between the lines of philosophy, he was telling me he loved me. And I'd do my best to tell him, I love you too. Because we were best friends growing up, being only 2 years apart. We started our life together with me being born. And as I lay fresh and still gross on our mother's chest, he managed to get his big toddler head stuck in a rocking chair. I'm often told how I would listen to him for hours as a baby. He'd tuck me into my crib and lay next to me while I fell asleep, kissing my head gently. And when I was in a walker, he'd slowly pat my head while watching TV whenever I stopped by him. He'd tell me stories, and when I was old enough to understand, I took them as gospel. There was, in fact, a volcano under our large black recliner. I cried for hours, scared it'd erupt. He'd tell me about the fish in the ocean. I'd ask, is that really true? And he'd simply say yes. And that was that. When we were a bit older and going to school, I cut my hair short so I could join the boys' club and play with him more in our neighborhood. He taught me how to build forts and do kicks and punches, and we'd race across mud puddles together and get in trouble together. And it was the best child I could have. When I learned I didn't know how to read or do math well, he spent hours helping me, printing off worksheets during the summer, playing me his favorite songs, replaying the ones I liked, and grading my papers so I could catch up with my class. I never got better at math, but thanks to him, I got the highest score on the English portion of the ACT. He was so proud. I hope he remembered it was all because of him. He went to college, and so did I, and we didn't talk much. I got married, he got a degree. And after a year, we realized we hadn't seen each other. That Easter of 2018, I was supposed to go home to catch up. My mom told me he was looking forward to it. But that Easter was an empty seat and an empty grave the day before. I've been dreaming about him since. And whenever I wake up, it feels like the grief is new. Because for a second he's alive. And like a cruel joke, he's taken away from us again. I woke up to my mom's shattered voice that Saturday. They found Alex. He's dead. I couldn't move. It was a scene from a sad movie. It wasn't real. I said, okay, and hung up. And immediately felt my body heave as the reality sank in. I was married then. I got a divorce soon after. I felt like my life crumbled apart, and I was doing everything I could to make a new one that he couldn't have. The constant pressure of needing to have a life he'd want on my shoulders. To this day, it's hard to know if what I'm doing is what I want or if it's me trying to live out his dreams. I don't know what to write besides that. I know my words won't make the one who took him regret it. And I don't think that's what I want. I think what I want, more than anything, is for everyone who doubts this verdict to know that he'd never hurt a fly. I have complex PTSD from sexual abuse and abuse from previous romantic partners. And though I can understand how a flashback feels, I couldn't imagine using it in court. If I hurt my current partner because of my disorder, I'd want to be put away for life. If I took him away from his siblings and families, I'd have deserved time. Because regardless of my hatred and fear for my abusers, they have loved ones. They have people who would feel this anguish, even if they knew they were bad. No one should feel this way. A mother shouldn't outlive her son. And a younger sibling should never avoid the calendar, thinking about the birthdays that will come that should be celebrated differently. And through it all, I should have never felt this unwavering weight of feeling like it should have been me. If I could, I would choose me every time. Why would anyone be okay with knowing that's what we all have to live with the rest of our lives? Why do we have to live with the image of hundreds of people we didn't know drive hours to his funeral? Why do I have to live looking through his Facebook page just to feel close to him again? I want to leave you with this because I feel it sums up everything while helping me end this without rambling. The night before I wrote this, I had a dream about him again. But in this dream, I was supposed to go somewhere. I had an appointment. It was important. But he showed up right before I left. And he said he only had that day to see me. In the dream, I told him, sorry, I have to see someone. I have to go. His eyes watered and he looked away, trying not to cry. I don't think I ever remember seeing him cry. I understand, but this is the last time we'll ever be able to talk. And I knew he was right. If I left, it'd be goodbye for good. So I said I'd stay. And we looked at each other with peace. We let a few tears escape, smiled, and then I woke up. And this time, I knew he was gone. That lingering feeling of him wasn't there. And I can't help but cry writing this, knowing we'll never have that in real life. I won't be able to say, I'll stay a while so we can catch up. Because Alex Woodworth was slaughtered. And the only time I'll ever be able to see him ever again is in my dreams. And when I wake, all I'll be able to think is it should have been me. Thank you for your time. I hope this made more sense than his death. And I hope no one here has to experience my words in their own life. And to his murderer, you've not seen me, but I have seen you. And with even all my grief and rage, I mean it when I say, I want no one to feel how I do, not even you. And that should speak more loudly than anything else I've said about how deeply this pain goes. Sarah Woodworth.
Thank you.
Thank you for this time. I'm going to start by changing just a bit on especially the PSI, because the time has passed since I said, the least amount. And every day I wake up without Alex is a day that I start every day talking to him. I end every day talking to him. And since that time, I realize that he'll never come back. The hurt is always there, but I thought it'd get better, and maybe it will. So I'll just read my letter now. Today is not Ezra's day. 3 months ago, she had her day, in fact, 3 weeks. She was convicted of first-degree intentional murder. She killed my grandson, and at this point, I don't understand why, only how. Not even the timeline of the event itself. Was Alex tortured before he died? It is certainly possible, as 3 hours of unexplained time is given. Maybe it's less, but it's a bunch of time. We do not know the fear and the pain, the terror that he felt as he was dying. And looking at those pictures, I can only imagine at times, and that picture, they come back so readily. How he got himself from the ground to the back seat of the car, we certainly don't know the pain he felt as he was being stabbed or his blood was being poured out of his body. We just know that he was alive at noon and gone at 4. I
Do not believe she deserves mercy from the court due to her age or sex, as Alex died a terrible death. Look at the pictures, blood up and down the front and the back of his jeans, yet not in the car, stabbed in the stomach and the groin. I call that torture. This I do know. We'll never see Alex again, never see his smile, never hear his weird humor, or see the hope that he had and shared with so many others. We will never know where life is leading him. He's gone, and so is a good part of our lives as well. A hole that can never be filled, an action taken by her without reason or remorse. There's not enough years left anyplace to replace or to pay the price of Alex's death. And thank you.
Thank you, sir.
Your Honor, that concludes the state's victim impact statements. I would just ask that if the defense has any character witnesses, that they would go first before the attorneys make their arguments.
All right, any objection to proceeding that way, Ms. Bishni?
Judge, we're going to have our witnesses speak when it's our turn for the sentencing presentation, not before the state. The state's not entitled to listen to them in advance. I'd like to proceed the way every other sentencing in my 39 years as a lawyer has gone.
All right, then Ms.
But I will have them speak before I make my remarks.
All right. Well, then that is, I guess, normally the way we do things, that you present your witnesses and make your arguments, and then defense has their opportunity. So why don't you go ahead then with your arguments? Recommendations.
Your Honor, as a prosecutor, you don't get to choose the facts of your case. You don't get to choose your victim. And in a homicide case, the defense is frequently blame the victim. And that was no exception in this case. And as the victim impact statements reveal, Alex wasn't your typical 24-year-old student. In preparation for trial, we met with friend after friend from the Lacy's crowd. And all of them described Alex in a similar way. Kind, considerate, intelligent, and always striving to learn more and understand different schools of thought. A friend who would happily put down his own writings and spend hours to help another friend learn their homework. A friend who would drink cups and cups of coffee to listen to someone who needed to talk. We ended each one of our witness preparation meetings with one question. Was Alex the type of person who was more concerned with himself or more concerned with others? And every single response was a resounding, more concerned with others. Without a doubt, Alex was only 24 years old and was going places. He was pursuing his dreams to become a professor. Some of his writings were getting published, and no doubt he was going to make this world a better place. Pursuant to the Wisconsin Supreme Court decision in Galleon, the courts to identify and rank its objectives in sentencing. In this case, the state ranks the sentencing objectives in the following order. First, and most importantly, protection of the public. Second, punishment. Third, deterrence to others. And fourth, rehabilitation of the defendant. These rankings derive from the facts of this case because the defendant engaged in a brutal and heinous attack on a young man and then left him there to die. When the court considers the seriousness of the offense, there is nothing more serious than the loss of an innocent life. In fact, the court is required to impose a life sentence for the defendant. The only issue is whether the defendant should be given the opportunity for parole. And given the very violent and heinous nature of Alex's murder, the state strongly argues that such an opportunity would be wholly inappropriate in this case. When the court considers the seriousness of the offense, it needs to remember that the defendant deliberately took a knife from her father's home and lured Alex to a remote location to brutally murder him. She violently and brutally stabbed him through the scalp, through the bone into the brain, sliced his neck 3 times, pierced his lungs, stabbed him in the genitals. She stabbed him not once, not twice, but 16 times. The remote location she lured him to, Alex's screams and cries would be heard by no one. And there's no indication that Alex ever even fought back. These were 16 deliberate and separate choices to stab and kill Alex, and so clearly this murder was extremely violent and brutal. When the court considers the character of the defendant, it needs to consider the defendant's actions after she murdered Alex. She staged the crime scene. She didn't run for help. She didn't call for help. She didn't try to stop the bleeding as Alex lay motionless. What did she do? She cut herself, planted blood around the crime scene where Alex lay dead or dying. She then had the apparent presence of mind to carve boy into her arm. She found Alex's phone. She didn't call for help. She didn't give Alex's phone to Don Sipple. No, she broke the phone, removed the battery, threw it in the ditch so no one could find Alex. She continued her performance and her calculated plan to try to be the victim, to throw law enforcement off of what really happened. She never mentioned Alex lay lifeless down that road. Nope, she asked for Jason Mingle. She tried to manipulate every person she came in contact with after March 22nd, 2018 with her Victim Act. Throughout the trial, the defense tried in vain to utilize smoke and mirrors to hide the actions of the defendant. And the defendant's sentencing memorandum is round two of that attempt to try to distract from the heinous and brutal actions of their client. The defense tries to humanize the defendant by filing photographs of the defendant playing with her siblings and eating pizza. And to the extent the court wishes to rely on those photographs in its sentencing decision, I'd ask the court to remember the photographs up on that screen of Alex laying dead out the back of a car, of photographs of Alex at this autopsy, which depict the violent nature at which Alex lost his life at the hands of the defendant. The defendant's sentencing memorandum is yet another example of a defendant who refuses to accept responsibility and is attempting to retry this case, even though the jury has already found her guilty. Shortly before coming into sentencing, we located a GoFundMe page that I would like to provide the court. The defense has been provided with the same.
It was a GoFundMe page. It's a defunct GoFundMe page, just so its record is clear.
It's a what?
I'm sorry?
Defunct. It's defunct. It may show up on the internet as a GoFundMe page, however, it's defunct. It's not an active GoFundMe page.
Well, I certainly believe it's relevant as it provides the defendant's version of events or another version of events, given she did not provide a separate statement to the PSI writer. However, in her GoFundMe page, which is entitled Support an Artist,
Judge, Ms. McCandless has been in the jail and she doesn't have access to the internet. So somebody else wrote this. And therefore, I would ask that the court not consider it and the state be barred from reading it into the record. Because Ms. McCandless, although this appears to be written in the first person, we know objectively speaking, she doesn't have any access to the internet and can't do this.
Well, it says right on the front of it that it was Rosie Gunnelson is organizing this fundraiser, so.
Yes, Your Honor, but it's then signed Ezra McCandless.
It doesn't matter. It's physically impossible for her to have written this and posted it online. So I don't think it should be considered when looking at Ms. McCandless's character or the Galleon factors.
All right, well, I think the court is capable of sorting things out, so I don't know, what is it that you plan to do with this?
Well, Your Honor, I just think it's relevant as it's another version of the defendant's story and her continued refusal to take responsibility for her actions. So I think it's relevant when the court considers the character of the defendant, where she continues to paint herself as a victim in this GoFundMe page.
All right, well, I'm going to allow you to go ahead, Ms. Nodoff. I'll note the state's objection.
The defense objection.
I mean, the defense objection, yes, that's noted and preserved for the record. Thank you.
Thank you.
In this GoFundMe page, it's written, in the end, this case was not decided on facts, logic, or the law. It was decided on retribution, shock, emotion, and prejudice. She continues to paint herself as a victim as that her sexuality, gender, and intelligence was attacked. It's written 15 days attacked, re-traumatized, re-experiencing traumatic details. How dare you be a young woman with more than one sexual partner? How dare you be LGBTQ? How dare you have a choice when it comes to your body? She continues to write, I did not have to raise my hand to speak. I made a choice to speak, to tell the truth of what has happened to me. I have survived. And now she's facing a mandatory life sentence, and basically support her for her appeal. Again, painting herself as the victim, again, refusing to accept responsibility for what she did. The defendant sentencing, as we noted in our sentencing memorandum, the defendant described herself better than I ever could when she wrote her paper about Ted Bundy. The defense notes she wrote this when she was 16, but yet she shared this with Jason Mingle and highlighted certain portions less than 2 weeks before Alex's death. And even in text messages to Alex, she talks about her fascination with psychopaths. She writes, during an interview, Theodore Robert Bundy, also known as Ted Bundy, said, quote, I don't feel guilty for anything. I feel sorry for people who feel guilt. Ted Bundy was considered an animal.
Excuse me, Judge, at this point, honestly, reading of a high school academic paper about Ted Bundy and saying that that's Ezra McCandless's character because she was proud of and shared her writing. I wasn't going to interrupt the state, but I actually find this so outrageous at sentencing that I feel compelled to object. And I've never objected at a sentencing hearing in my life. But to, you know, the state chose to file this with the court. I don't know if this is some kind of playing to television cameras or what's going on here exactly, but I think it's an outrage to talk about Ezra McCandless like she's Ted Bundy. She's guilty of a first-degree intentional homicide. The court's going to sentence her on that. But this is an attempt, a blatant attempt to elicit some kind of prejudice that's just beyond the pale here. So I would like my objection noted.
All right, well, it was submitted with the state sentencing memorandum, you know, so I'm aware of it, and I'll note your objection, be preserved for the record. Court understands what it should consider and can consider at sentencing, and rules of evidence do not apply. And, but this is the state's, their sentencing presentation, so